ಸ್ಟಾರ್ಟೆಡ್ ಅಂತ ಬಂತು, ಒಂದ್ಸತಿ ಚೆಕ್ ಮಾಡಿಬಿಡೋಣ ಲೈವಲ್ಲಿ.
ಓಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಇವತ್ತು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ ಯಾವ ಏನು ಸ್ಟೇಜ್ ಇದೆ ಅದು ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ ಅದು
ಅಲ್ಲ ಒಂದು ತಿಂಗಳ ಮೇಲೆ ಆಗಿದೆ ಸರ್ ಹಾಕಿ
ಬೋರ್ಡ್ ಆಗಿ ಬರ್ಬೇಕು ಕೊಡಿ ಅದನ್ನ ಹಾಕ್ಸೋಣ
ಸರ್ ಐಎಫ್ಎಲ್ ಅದು ಏರಿನ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಮ್ಮ ಕೊಟ್ಟಿದ್ರು ನಾಳೆ ಬರುತ್ತಲ್ಲ ಸರ್
ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ ಆಲ್ ಫ್ರೆಶ್ ಮಾಡ್ಸ್ ಕೊಡಿ
ಸರ್
ಸರ್ ಸರ್ ಇದೆ ಸರ್ ಇಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಪ್ರಿಲಿಮಿನರಿ
ಒಂದು ಮ್ಯಾಟ್ರ್ ಫಾರ್ 12th ಹಾಕ್ಬಿಡ್ತೀರಿ ಹಾಕಿದ್ದೀನಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್
ಯಾವತ್ತು ಬೇಕು ನಿಮಗೆ ನಾಳೆ ನಾಳೆ ಏನು ಡೇಟು
25
ತಗೊಳ್ಳಿ ಸರ್
ಬರುತ್ತೆ ಫಾಲೋ ಮಾಡಿ
ನಾಳೆ ಆಗಿಲ್ಲ ಸರ್ ಆಯ್ತು ಸರ್ ನಾವು ಮಾಡ್ತೀವಿ ಅದು ಅಲ್ಲ ನಾಳೆ ಹಾಕಿದ್ವಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಅವ್ರು ಮಾಡಲಿಲ್ಲ ಇಲ್ಲ
ಬರ್ತಿದ್ದೀನಿ ನಾನು ಬರ್ತಿದ್ದೀನಿ ಮೇಲ್ಗಡೆನೆ
ಬರ್ಬೇಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ಕೂಟ್ನಿ ಫ್ರೆಶ್ ಬದಲು ಸ್ಕೂಟ್ನಿ ಅಂತ ಬರ್ಬೇಡಿ ಎಲ್ಲ ಹೋಗ್ಬೇಕಂತ
ನಂದು ಸ್ಕ್ರೂಟ್ನಿ ಎಲ್ಲ ಆಗಿದೆ
ಅಷ್ಟು ಬರೋದೇ ಸಾಕು ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಏನು ಪೆಂಡಿಂಗ್ ಏನಾದ್ರೆ ಬರ್ತಾರೆ ಆಗಲ್ಲ ಇವತ್ತು ಐ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ಡ್ ಅಂತ ಬರೀ ಐ ಫಾರ್ ಅರ್ಲಿ
ಸರ್
ಪೆಂಡಿಂಗ್ ಅರ್ಲಿ ಫಾರ್ ಎಲ್ಲಿ ಪೆಂಡಿಂಗ್
ಏನಕ್ಕಿದೆ ಸರ್ ಕೋಡಿಂಗ್ ನೋಟಿಸ್ ಆಗಿ ಬಿ ಗ್ರೂಪ್ ಹೋಗಿದೆ ಅದೇ ಅರ್ಲಿ
ಮೆನ್ಷನಿಂಗ್ ಇದೆಯಲ್ಲ
ಅರ್ಲಿ ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚ್ ಅಂತ
ಯಾವುದು
ಇಲ್ಲ ಇದು
ಎಜುಕೇಶನ್ ರಿಸಲ್ಟ್ ಅದೇ ಮೈಂದೆ అంటే
ಹಿಯರಿಂಗ್ ಆನ್ ಐಎ ಅರ್ಲಿ ಹಿಯರಿಂಗ್
ಎಕ್ಸಾಮ್
ತಗೊಳ್ಳೋಣ
ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಸರ್ ಥರ್ಸ್ಡೇನಾ
ಆಯ್ತು
Thursday?
ಯಾವ ಡೇಟ್ ಸರ್
ಥರ್ಸ್ಡೇ
ಕರೆಕ್ಟ್
ಇರಿ ಸರ್ ಒಂದು ನಿಮಿಷ
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ರೆ ಮಾತ್ರ
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಆನ್ ಐಎನೇ ಸರ್ ಅಲ್ಲೇ ಹೊಡೆದಾಕ್ ಬರ್ದೆ ನೋಡಿ ಸರ್ ಹೌದು ಸರ್ ಐಎ ಹಾಕಿದ್ದೀನಿ
ಆಯ್ತು ನೋಡ್ಬಿಟ್ಟು ಕಳ್ಸಿ
ಸರ್ ಐಎ ಹಾಕಿ ಫ್ರೆಶ್ ಮಾಡಿ
ಸರ್ ಬಿ ಗ್ರೂಪ್
ಫ್ರೆಶ್ ಸ್ಕ್ರೂಟಿನಿ ಬರಿಬೇಕಾ
ಬಿ ಗ್ರೂಪ್
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಐಎ
ಕೊಡಿ ಸ್ಕೂಟ್ನಿ
ಸರ್ ಫ್ರೆಶ್ ಫೈಲ್ ಯಾವ
ఫ్రెష్ లెక్కిಲ್ಲ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್
ఫ్రెష్ మార్క్ తీసుకుంటారు ఐఎల్ ఉంటే వాళ్ళు హియర్
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾವಾಗ ಬರುತ್ತೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್
ಅದಂಗಿದೆ
ಸರ್
ಇನ್ನ ಇಲ್ಲ
75 ಯಾವ್ದು ಅದು ಫರ್ದರ್ Attendance.
Sir.
The dental college accommodation scheme.
ಅದೆಲ್ಲ ಅವರು ಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನು ನೀವು ಮಾಡಿದ್ರೆ ಏನು ಕೊಡ್ತಾರೆ?
No, madam, I can't say. How can I say? Matters are rich. I can't say this thing. As per list.
ಇಲ್ಲ ಅಯ್ಯ ಇದು ವೇಕೇಟಿಂಗ್ ಅಯ್ಯ.
ಸರ್ ಎಕ್ಸಾಮ್ ಬರ್ತಿದ್ದಾರೆ, ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗೋದಕ್ಕೆ IFR ಡೈರೆಕ್ಷನ್ ಹಾಕೊಂಡಿದ್ದೀನಿ. ಯಾಕಂತಂದ್ರೆ ಸೆಕೆಂಡ್ PUC ಮತ್ತೆ ಇದು ಕೋರ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ತದೆ, ಅಡ್ಮಿಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ತದೆ, ಅದಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್.
Last date of admission.
ಸರ್
Admission last date ಯಾವತ್ತು ಸರ್?
ಲಾಸ್ಟ್ ಡೇಟ್ ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ. ಅವ್ರದ್ದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಒಂದು ಅಲಿಗೇಷನ್ ಇತ್ತು ಸರ್, ಕೋರ್ಟ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರು, ಎಕ್ಸಾಮ್ ಬರೀರಿ, ರಿಸಲ್ಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ಔಟ್ಕಮ್ ಅಂತ. ಈಗ ಸೆಕೆಂಡ್ PUCಗೆ ಫಸ್ಟ್ ಇಯರ್ ಡಿಗ್ರಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತಂದ್ರೆ ಅಥವಾ ಇಂಜಿನಿಯರಿಂಗ್ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ದಟ್ CBSE ಸೆಕೆಂಡ್ PUC ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗಬೇಕು. ಅನೌನ್ಸ್ ಆದ್ಮೇಲೆ ಇವಾಗೆಲ್ಲ ಇದು ಮುಗಿತಾ ಇದೆ, ಏನ್ ಹೇಳಿ CET ಇದೆಲ್ಲ ಮುಗಿತಾ ಇದೆ. ಇದು ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆದ್ರೆ
ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆದ್ರೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಕೇಳ್ತಾರೆ ಸರ್.
Very-
ಲಾಸ್ಟ್ ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಅದು
ಹಾಕಿದೆ
ಹಾಕಿದೆ ಕವರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಸುಮ್ಮನೆ.
Last date ಅಲ್ಲ.
ಯಾವ ಕಾಲೇಜ್ ಅದು?
ಬಂದ್ರು
ಕಾಲೇಜ್
ಬಂದ್ರು
ಕಾಲೇಜಕ್ಕೆ ಅವ್ರಿಗೆಲ್ಲ ಸರ್ ವಕಾಲತ್ತಕ್ಕೆ ಅರ್ಜಿ
ಇವಾಗ ನೀವು ಈಸಿ ಆಗುತ್ತಲ್ಲ, ಕಾಲೇಜ್ ಇದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗತ್ತೆ ಯಾವ್ದು ಅಂತ ಅಷ್ಟೇ.
CBSE ಮಲಾಡ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
ಮಲಾಡ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡ್ಬೋದು. ಹಾ, it will come in the normal course. Yes,
ಮಲಾಡ this is
it will come in the normal course.
my
Yes.
lord, this is education matter, my lord.
Ah.
My lord, this Honorable Court has permitted to write the examination. CBSE has because of the petitioner has carried the mobile to the examination hall, they have not permitted. ಈಗೇನಂದ್ರೆ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಹಾಕೊಂಡಿದ್ವಿ ಸ್ವಾಮಿ, ಅವರು ಫಸ್ಟ್ ಇಯರ್ ಡಿಗ್ರಿ.
Yes.
tomorrow.
Ah. It will come in the normal course. Yes. Yes, please call out.
This number one. Fresh matters.
Fresh matters kodi. Please.
Murthy, read.
My lords, I appear for the caveator in this matter, my lord.
I challenge the annexure A and B. The last may kindly come to my note, page 49 of the impugned note. Who Nyam and Ashif got it, 49 annexure B.
Who approached the assistant commissioner?
My lord, the matter was remanded by this honorable court, my lord.
Huh? By which
Therefore,
order?
it was taken up before
By
the
which order?
assistant commissioner.
By which order?
My lord, in repetition, my lord, it has been stated,
Copy hakilva.
copy of that is. But it is a fact, my lord, say there's no dispute with regard to that.
Ah.
And therefore, the matter was taken up for
Remanded to?
remanded to the assistant commissioner
Ah.
to adjudicate.
Ah.
The
Who
assistant,
had filed the appeal before the assistant commissioner?
My lords, I had filed the appeal,
Who
my
had
lords.
filed the appeal?
Please.
I challenge. My lord,
What did they challenge before the assistant commissioner?
the assistant commissioner, my lord, see the respondents before your lordships, even including the agreement holder, they stated that you see the land tribunal.
RRT 5 of 2014-15
Yes, my lord.
was challenged
Yes, my lord. The respondents contend.
in the year 2021.
Yes. Ma'am. The
You
litigation.
filed the appeal in the year 2021.
No, my lords, what had happened was, the petitioner's father was the owner of the land. Thereafter, the land tribunal passed an order way back in 1981, granting rights over the same land to various persons. Thereafter, my lords, mutation was effected in their name, Khata or Hesral Agittu. From some of them, I have purchased the land in 2011. Apart from that, I have also entered into agreements in respect of the remaining properties, my lords. Thereafter, my lords, for the first time after the petitioner's father passed away, the petitioner's mother challenged the order of the land tribunal in this honorable court, my lords, that they have withdrawn. So therefore, the order of the land tribunal has reached finality. Parallelly, or mutation entries, they had challenged. That, my lords, had come before the assistant commissioner. They had remanded it back to the tehsildar for fresh consideration. I was not made a party to the same. Therefore, my lords, I approached this honorable court in the writ petition in 2021. This honorable court was pleased to direct me to approach before the assistant commissioner. Therefore, my lords, the 2014 order came to be again challenged before the assistant commissioner. Both the assistant commissioner and the deputy commissioner have rejected it, saying that they have lost their rights over the land because the land tribunal's order has reached finality.
The petitioners were not the parties in the land reforms. My mother, according to them, they are withdrawn. We are in USA, my lord. God only knows how the matter was withdrawn. I stated in my writ petition that we are contemplating to file an application to withdraw the memo as well as to set aside the order of withdrawal. Please come to my lord. The land tribunal, my lord, when the applications were filed, no survey numbers, no extent. Please come to my lord, page number 49.
Allala, pursuant to the original order passed by the land tribunal.
Yes, me.
Conferring occupancy rights.
Third time it was remanded, my lord. My mother appears to have challenged. I am the legal representatives. We are stationed in USA. My mother might have withdrawn. We don't know. Therefore, my lord, after we came to know that, we made an application to recall that order because we are the legal heirs of the late Mr. Gowda, who holds the property. And therefore, my lord, please come to my lord, page number 49. The order itself speaks that 49, 12, my lord, the reasoning. ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ ದಾವಾ ಸ್ವತ್ತು ಸರ್ವೆ ನಂಬರ್ 201/2, 200/2, 200/3, 210 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 18 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನು ಆದೇಶವಾಗಿದ್ದು ಮೇಲ್ಕಂಡ ಕೋಷ್ಟಕದಲ್ಲಿ ತೋರಿಸಿರುವುದಂತೆ ಒಟ್ಟು 7 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ನಂದು ಸೇರಿಸ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಅಧಿಭೋಗವಾಗಿದೆ, ಹಕ್ಕು ನೀಡಲಾಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಮಂಜೂರಾತಿ ಆದೇಶದಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿರುವುದಿಲ್ಲ. Therefore, the grant itself is bad in law. Therefore, there is no extent and no boundaries and nothing is shown. How could the assistant commissioner will enter the names of a particular person? Next, my lord. ಅಲ್ಲದೆ ಭೂ ನ್ಯಾಯ ಆದೇಶದಲ್ಲಿ ದಾವಾ ಸ್ವತ್ತನ್ನು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 18 ಗುಂಟೆ ಜಮೀನು ಆದಿಭೋಗಕ್ಕೆ ಹದ್ದು ಮಂಜೂರು ಮಾಡಿದ್ದು ಸದರಿ ಆದೇಶದಲ್ಲಿ ನಮೂದಿನ ವಿಸ್ತೀರ್ಣ ಲೆಕ್ಕ ಮಾಡಲಾಗಿ ಒಟ್ಟು 7 ಎಕರೆ 38 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್, ತಹಸೀಲ್ದಾರ್ ಮೈಸೂರು ಪ್ರಕರಣ ಸಂಖ್ಯೆ RRT 5 ದಿನಾಂಕ 2019 ಪರಿಶೀಲಿಸಿ ಸದರಿ ಆದೇಶದಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ ಅಧಿಭೋಗಕ್ಕೆ ಹಕ್ಕು ಮಂಜೂರು ಮಾಡಿದ್ದು, ಆದರೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಯಾವ ಅಧಿಭೋಗಕ್ಕೆ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ ಎಂಬುದು ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದಿಸಿಲ್ಲ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್ 17. ಇದೇ ರೀತಿ ಪ್ರಕರಣದ 2-3 ಎದುರುದಾರರು ದೇ ಕಂಟೆಂಟ್ ದಟ್ ದೇ ಆರ್ ದಿ ಅಗ್ರಿಮೆಂಟ್ ಆರ್ಡರ್. Can the agreement orders can get the khata in their name is the question to be determined by.
I'm also the purchaser, my lord.
54 of the act. I'll read my lord. ಈ ಪ್ರಕರಣದಲ್ಲಿ 2 ಮತ್ತು 3ನೇ ಎದುರುದಾರರು ದಾವಾ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಪ್ರಕರಣದ ವಿವಿಧ ಎದುರುದಾರರೊಂದಿಗೆ ನೋಂದಾಯಿತ ಕ್ರಯದ ಕರಾರು ಮಾಡಿ ಕೊಂಡಿರುವುದು ಕ್ರಯಾರು ಪತ್ರದ ಪ್ರತಿಯಿಂದ ತಿಳಿದು ಬಂದಿದೆ. ಅಲ್ಲದೆ ಕ್ರಯದ ಕರಾರು ಮಾಡಿಕೊಂಡಿರುವ ಕ್ರಯದಾರರು ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿರ್ದಿಷ್ಟ ಒಪ್ಪಂದ ಜಾರಿ ಕೋರಿ ವ್ಯಾಜ್ಯಗಳನ್ನು ಹೂಡಿರುವುದು ಎದುರುದಾರರ ಲಿಖಿತ ವಾದ ಪತ್ರದಲ್ಲಿ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಅವಲೋಕಿಸಲಾಗಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಸಂಖ್ಯೆ KLR M 2768 76 ಮತ್ತು ವಗೈರೆ ದಿನಾಂಕ 7/8/81 ಆದೇಶವನ್ನು ಗಮನಿಸಲಾಗಿ ದಾವಾ ಸ್ವತ್ತುಗಳಲ್ಲಿ ಅರ್ಜಿದಾರರು ಅನುಭವದಾರರೆಂದು ಮಂಜೂರು ಮಾಡಿದ್ದರೂ ಸಹ ಯಾವ ಅರ್ಜಿದಾರರು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಅಧಿಭೋಗಕ್ಕೆ ಹಕ್ಕು ನೀಡಲಾಗಿದೆ ಎಂದು ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದವಾಗದೆ ಇರುವುದು ಈ ಎಲ್ಲಾ ವ್ಯಾಜ್ಯಗಳಿಗೂ ನಮೂದಿಸಲು ಮೂಲವಾಗಿರುತ್ತದೆ. And therefore they said, my lord, enter the names in respect of.
The order was passed by the land tribunal on 7/8/1981.
Yes,
Huh?
yes, ma'am.
When was the mutation order passed?
The mutation
Pursuant to the orders passed by the land tribunal.
no mutation was effected.
Huh?
It was
Mutation
effective.
effected.
Ah.
If we have challenged persistently, we have challenged. There was a status quo in the before the assistant commissioner was also a status quo was ordered, and till now the names of nobody is entered. My name is continuing.
What information do you have after this order dated 7/8/1981? When was the mutation order passed and when was it entered? When was the name of the occupants entered?
My lords, in the year 2005, my lords.
Huh?
It was entered in the year 2005 as per the instructions received.
Please,
Modlu
madam.
ಏನಾದ್ರು order ಆಗಿದೆ, I will inquire, my lords. In the
Page
meantime,
number
my lords,
90.
I kindly pass the order passed by this honorable court or recall hakidini antare, that no information has been given, my lords.
Allah, why is it that after 1981, the grantees waited till 2005?
My lords, I will see, I do not have information regarding that, my lords. I will take information regarding that. In the meantime, my lords, may I kindly take your lordships to para 14 and para 19? My learned friend has read the remaining of the order of the DC, my lords.
Yes.
ಪ್ಯಾರಾ 14 ಅಲ್ಲಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಿ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ 6469 ರಿಂದ 6478 ಆಫ್ 22, ದಟ್ ಇಸ್ ರಾಂಗ್ ಮೈ ಲಾರ್ಡ್ಸ್, 2008 ಇದೆ, ಮತ್ತು 6480 ಆಫ್ 2008 ರಂತೆ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿದ್ದು, ನಂತರ ಪ್ರಕರಣವನ್ನು 2008 ದಟ್ ಆರ್ಡರ್ ಐ ಜಸ್ಟ್ ಪಾಸ್ಡ್ ಆನ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್. ನಂತರ ಪ್ರಕರಣವನ್ನು ಹಿಂಪಡೆಯಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 2008 ರಿಟ್ ಪೆಟಿಷನ್ 22 ಅಲ್ಲಿ ಅವ್ರು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Where is it?
ಅದ್ರಲ್ಲಿ ನನ್ನ ಪಾರ್ಟಿನೇ ಇಲ್ಲ, ನಮ್ಮ ಮದರ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿರೋದು ರಾಂಗ್ ಅಂತ
ನೀವೇ ಕೊಟ್ಟಿರೋದು
actually incorrect.
My lord, this is a writ petition.
Actually incorrect submission.
They had even challenged it in the civil court. That was dismissed, saying that they cannot challenge the order of the land tribunal. That also came to be withdrawn.
Rightly, civil court has no jurisdiction. Therefore, it is held that they have no jurisdiction. My mother has challenged. I am not a party to the writ petition. My mother cannot withdraw the writ petition. If she is withdraw the writ petition, it does not bind me. We are stationed in America. We are put into dark. We don't know under the what scenario my mother. She was aged old, passed away immediately. Therefore, my lord, para 19 now directed to enter the names.
One ನಿಮಿಷ.
They were duly represented before this honorable court, my lords. Their counsel have made the submissions. Finally, in page 21, the order is there, my lords. The same has been observed in para 14, my lords. ದಿನಾಂಕ 2/6/22 ರಂದು ನೀಡಿರುವ ಆದೇಶದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಪ್ರಕರಣವನ್ನು ಹಿಂಪಡೆದಿರುವುದರಿಂದ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಿರುತ್ತದೆ.
Nowhere in this order they have considered when after the tribunal mutation entries were made.
Please, my lords.
Nothing has been stated here.
Please, my lords.
When did you purchase the property?
Lords, I purchased the property in 2011, my lords. I also had agreements.
The 2005 mutation order?
My lords, it has not been produced.
They have also not stated anything about that.
Please, my lords. But my lords, thereafter in para 19, the order, they say that the way the order of the land tribunal has reached its finality, they have mentioned the various measurements. Adru prakara kodi. I will just read para 19, my lords.
Allah, you filed an appeal before the assistant commissioner, is it?
Please, my lords.
Challenging what?
Challenging the fact that initially the proceedings that they had initiated before the assistant commissioner, stating that the mutation entries affected in the occupant's favor, I was not made a party to those proceedings because I am the purchaser and also agreement holder. That, my lords.
Where is that order?
My lords, they have not produced that order, my lords. Even otherwise.
Where has the deputy commissioner considered it?
My lords, deputy commissioner has considered it, my lords. May I take your lordships to para 47? Alinda, the reasoning starts, my lords.
47, no?
Of the writ petition, my lords. That's the order of the deputy commissioner.
48. Reasoning, ವಿಶ್ಲೇಷಣೆ.
ಯಾವುದು?
Sorry, my lords.
48.
Page 48.
48 ವಿಶ್ಲೇಷಣೆ.
ಕೆಳಗಡೆ para 9 ಇಂದ ನಾವು ಓದ್ತೀನಿ.
9 and 10.
May I read, my lords? ಈ ಪ್ರಕರಣವು ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಬೆಲ್ವತ್ತ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 201/2, ಸರ್ವೆ ನಂಬರ್ 202, 203 ಮತ್ತು 210 ರಲ್ಲಿ ಒಟ್ಟು 7 ಎಕರೆ 38 ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ್ದಾಗಿರುತ್ತದೆ. ಚಾಲ್ತಿ ಸಾಲಿನ ಪಹಣಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಬೆಲವತ್ತ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 201/2 ರಲ್ಲಿ 1 ಎಕರೆ 5 ಗುಂಟೆ, 202 ರಲ್ಲಿ 4 ಎಕರೆ 3 ಗುಂಟೆ, 203 ರಲ್ಲಿ 3 ಎಕರೆ 5 ಗುಂಟೆ ಮತ್ತು 210 ರಲ್ಲಿ 4 ಎಕರೆ 27 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ನಮೂದಾಗಿದ್ದು ಎಂ ಪಂಕಜ ಕೋಮ್ಲೇಟ್ ಎಂ ಬಿ ಚಂದ್ರಶೇಖರ್ ಅವರ ಹೆಸರಿಗೆ ಖಾತಾ ದಾಖಲಾಗಿರುತ್ತದೆ. ಭೂ ನ್ಯಾಯಮಂಡಳಿಯು petitioner's mother, my lords, was withdrawn thereafter. ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 7/8/81 ಆದೇಶದಂತೆ ಈ ಕೆಳಕಂಡವರಿಗೆ ಅಧಿಭೋಗದಾರಿಕೆ ಹಕ್ಕು ಮಂಜೂರು ಮಾಡಿರುತ್ತಾರೆ. 12 ಜನದ ಹೆಸರಿದೆ. ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ.
How is it that Pankaja's name is found in the RTC?
My lord, she was the petitioner's mother, my lords, initially it belonged to her husband. ಅವರು ಬದುಕಿದ್ದಾಗ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಆಯ್ತು, ಅವ್ರ ನಂತರ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರು ತೀರ್ಕೊಂಡಾಗಿದ ನಂತರ ಅವ್ರ ತಾಯಿ ಫಸ್ಟ್ ಟೈಮ್ 2008ರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ, ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗಿದೆ ಅಂತ.
Just now read paragraph
ಹಾ,
number
ಅವ್ರ
10.
ಹೆಸರಲ್ಲಿ ಖಾತೆ ಆಗಿತ್ತು.
The RTC was standing in the name of Pankaja.
Please, my lords.
When was it changed?
My lords, it was changed in the year 2005.
ಏನು ಹೇಳಿಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ nothing has been said.
ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ ದಾವಾ ಸ್ವತ್ತಾದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಒಟ್ಟು 5 ಎಕರೆ 18 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿಗೆ ಆದೇಶವಾಗಿದ್ದು, ಮೇಲ್ಕಂಡ ಕೋಷ್ಟಕದಲ್ಲಿ ತೋರಿಸಿರುವಂತೆ ವಿಸ್ತೀರ್ಣ ಒಟ್ಟು 7 ಎಕರೆ 38 ಗುಂಟೆ ಆಗಿದ್ದು, ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಅಧಿಭೋಗದಾರಿಕೆ ಹಕ್ಕು ನೀಡಲಾಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಮಂಜೂರಾತಿ ಆದೇಶದಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ ದಾವಾ ಸ್ವತ್ತುಗಳಲ್ಲಿ ಒಟ್ಟು 5 ಎಕರೆ 18 ಗುಂಟೆ ಜಮೀನಿಗೆ ಅಧಿಭೋಗದಾರಿಕೆ ಹಕ್ಕು ಮಂಜೂರು ಮಾಡಿದ್ದು, ಸದರಿ ಆದೇಶದಲ್ಲಿ ನಮೂದಾಗಿರುವ ವಿಸ್ತೀರ್ಣವನ್ನು ಲೆಕ್ಕ ಮಾಡಲಾಗಿ ಒಟ್ಟು 7 ಎಕರೆ 38 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವಾಗುತ್ತದೆ. Thereafter, my lords, my learned friend has read. I take your lordship to para 19 now, my lords.
When they contend that they have made an application in respect of 5 acres, how could the
Now for the first time, by virtue of the order of the assistant commissioner, your names are sought to be entered.
My lords, initially they were already entered in 2005, my lords.
When was it changed? Nothing has been said. You
Yes,
are
my
stating, but no information you are placing before the court.
I will place it in the next date of hearing, my lords.
You are aggrieved by this order.
Yes, my lord. It has to be stayed, my lord. The order says, my lord, my mother's name has been entered.
My lords, even otherwise, my lords, one more submission. Due to the amendment, my lords, in fact, the appeal has to be placed before the KAT, my lords. Therefore, my submission is,
What appeal?
my lords, from the order of the Deputy Commissioner, the Karnataka Land Revenue Third Amendment Act. May I
Which
pass
year?
it on? 2025, my lords. This order has been passed in 12/3/2025. The amendment came into effect from 10th January 2025. Therefore, my submission, my lords, this may be relegated to KT. That is my other objection.
My lord, the order itself is illegal. Therefore, my lord, I'll demonstrate, my lord, see the writ court as a jurisdiction to. I'll see that, my lord, when the extent and the
Lord, section 5 of the Amendment Act, my lords, last page, my lords. Ali, in the Principal Act in section 136, in subsection 1, the word not shall be omitted. So therefore, chapter 5 will be applicable now, my lords, according to which the appeals should lie before the KAT, my lords. Shall I just read section 136, my lords? Section 136(1), before the amendment said, the provisions of chapter 5 shall not apply to any decision or order under this chapter. As per section 5 Amendment Act Prakara, in the Principal Act in section 136 in subsection 1, the word not shall be omitted. Therefore, my lords, it will now read, the provisions of chapter 5 shall apply. So according to that, my lord, section 50 Prakara, section 49 and 50 Prakara, order passed by the Deputy Commissioner, it has to go to the tribunal.
Please read it properly. It says this chapter.
Please, my lords.
This chapter pertains only to the revenue entries, not section 50. It cannot be applied to section 50.
My lords, may I kindly take your lordship to the statement of object and reason?
Please read the provision again.
Please, my lords.
Even after removal of that word, the provisions of chapter 5
Please, my lords.
shall apply to any decision or order under this chapter.
Please, my lord. Section 136(3) ಅಲ್ಲಿ DC order pass ಮಾಡಿದ್ದಾರೆ. Section 136(3) ಅಲ್ಲಿ DC order pass ಮಾಡಿದ್ದಾರೆ.
No. The provisions of chapter 5
Please, my lords.
shall apply
Please, my lords.
to any decision or order under this chapter.
Please, my lords.
Now you read subsection 3.
Please, my lords.
Yes.
The Deputy Commissioner may, on his own motion or on application of a party, call for and examine any records made under section 127 and section 129 and pass such orders as he may deem fit. Kindly, my lord, section 120.
How do you say that appeal will still lie before the KAT?
My lords, the reason is this, my lords. Section 136(2) ಅಲ್ಲಿ AC order pass ಆಗಿತ್ತು. Section 136(3) ಅಲ್ಲಿ DC order pass ಆಗಿತ್ತು.
Revision.
Please, revision was placed, my lords. This was regarding the change in the mutation entries only. That will come under section 129. So ಅದಕ್ಕೆ chapter 5 apply ಆಗುತ್ತೆ. So it has to go back to section 50. May I kindly take your lordships to the statement of objects and reasons, my lords. They've clearly mentioned, my lords, in para 5, my lords, further anta ide. It's in the second page, my lords. Further, there are many instances where petitioners are approaching Honorable High Court of Karnataka against orders passed by the Deputy Commissioners or Special Deputy Commissioners under Section 136(3) of the Karnataka Land Revenue Act under writ jurisdiction. The High Courts is also burdened with such cases in large number in writ petitions. The Karnataka Revenue Appellate Tribunal has been constituted in Chapter 4 under Section 40 of the Karnataka Land Revenue Act 1964 to hear revenue matters relating to appeal, revision and other proceedings as per provisions of Chapter 5 of the Act. Thereafter, my lords, they have said, therefore it is considered necessary to amend the Karnataka Land Revenue Act 1964 anta heli. They have now amended Section 136, my lords. So it is felt necessary that the appeal or review against the orders of deputy commissioners should be heard by the Karnataka Revenue Appellate Tribunal. This will also reduce the burden on the Honorable High Court.
Where did you read that?
My lords, thereafter, my lord, Chapter 5 of the said Act admale. Further in para 250 of 23-24 budget speech anta ide. That is regarding the other amendment. It was announced that agricultural land up to 2 acres shall be exempted from land use conversion for establishing new industries. Karnataka Land Revenue Act 1964 will be amended suitably for this purpose. Adadmele Section 95 amendment ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. Hence, Commerce and Industries Department has proposed to amend Section 95 of the Karnataka Land Revenue Act 1964 to exempt 2 acres of agricultural land from conversion for establishing new entries. Accordingly, the amendment to Section 95 of the Karnataka Land Revenue Act 1964 is proposed. Next to, so it is felt necessary that the appeal or review against the orders of deputy commissioners should be heard by the Karnataka Revenue Appellate Tribunal. This will also reduce the burden on the Honorable High Court. Therefore, it is considered necessary to amend the Karnataka Land Revenue Act 1964 to provide for 1. Powers to Assistant Commissioner or Survey Officers not below the rank of Assistant Commissioner to decide the claims of any person or on behalf of the state government about any property or any right in or over any property under Section 67. Agricultural land up to 2 acres shall be exempted from land use conversion for establishing new industries under Section 95. More clarity regarding removal of encroachments in government land by Tehsildar under Section 104. Removal of any ambiguity between understanding of Sections 39, 67 and 104. Provision to enable the Karnataka Revenue Appellate Tribunal to hear the appeals against orders passed under Section 67(2) and 136(3) of the Karnataka Land Revenue Act 1964. Therefore, after detailed examination, it is considered necessary to amend Section 67, 95, 104 and Section 136 of the Land Revenue Act.
The Supreme
They have
Court
said very clearly provision to enable the Karnataka Revenue Appellate Tribunal to hear appeals against orders passed under Section 136(3). ಏನ್ ಮಾಡೋದು?
I am approached my lord, see, let there be the status quo, my lord. I'll maybe 4 weeks time may be granted and then I'll file the appeal before 6 weeks time may be granted. I'll file the appeal.
Lords, even otherwise,
ಏನಪ್ಪ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗಳು ನೀವು ಇದನ್ನು ನಮ್ಮ ಗಮನಕ್ಕೆ ತರಲಿಲ್ಲ. We have been entertaining writ petitions after this amendment also. I also didn't notice it.
it has been
ಬರ್ಕೊಳ್ಳಿ.
even if it is conceded that the petitioner's mother, my lords, had the khata in her name, In respect to that, land tribunal order dismiss as withdrawn anta agide. That is my only submission.
See, the authorities were required to consider the matter having regard to the chronological events.
Please, my lords.
For the first time, an order is passed by the Assistant Commissioner in the year 2024, directing the Tahsildar to enter your names based on an order passed by the Land Tribunal in the year 1980.
Yes, oh, my lords, I will urge it
Nothing
before
has
the
been
case.
said.
Please.
So the question of delay, everything had to be considered. Learned HCGP takes notice for respondents number 1 and 2. Learned counsel, Miss G.K. Bhavana.
My lords, my name is Aparna, my lords. I'm her
Aparna.
colleague. Yes.
Allah, Miss G.K. Bhavana has entered appearance for respondents number 3 and 4.
My lords, 2 and
Contesting
3, my
respondents
lords.
number 3 and 4.
3 and 4. Yes, please. Please,
Huh?
please my lords. Yes.
Notice to all the other respondents may not be necessary for the following reasons. Next paragraph. Learned counsel for the petitioners submits that by virtue of the orders passed by the Assistant Commissioner at Annexure A dated 25/1/2024, for the first time, directions were issued to the Tahsildar to enter the names of those persons who were granted occupancy rights at the hands of the Land Tribunal. Full stop. Learned counsel submits that the Land Tribunal is said to have passed an order on 7/8/1981, and nothing is said about the delay and latches on the part of the respondents herein, who sought entry of their name pursuant to an order passed by the Land Tribunal in the year 1981. Full stop. Learned counsel submits that the petitioners were residing at
USML.
the United States of America, and they were not aware of the subsequent developments. Full stop. The petitioners are seeking to raise a challenge to the said order passed by the Land Tribunal, which even otherwise, does not contain any details of the extent of land conferring occupancy rights in respect of the applicants therein. Full stop. That being the position, the Deputy Commissioner has failed to notice these factual discrepancies and should have set aside the order of the Assistant Commissioner while directing the parties to approach the Land Tribunal to get a clarification regarding the extent of lands where occupancy rights were conferred in respect of the applicants. Full stop. Next para. Per contra, learned counsel Miss
Aparna, my lords.
Aparna, appearing for the learned counsel for respondents number 3 and 4, submits that by virtue of the amendment brought to subsection 1 of section 136 of the Karnataka Land Revenue Act by Act number 6 of 2025, which has come into effect from 10/1/2025, an appeal remedy is provided to challenge an order passed by the Deputy Commissioner under section 136(3) of the Act. Full stop. The learned counsel would therefore submit that the writ petition may be dismissed on this ground while directing the petitioners to approach the tribunal. Full stop. Next para. At this juncture, learned counsel for the petitioners would request that there should be an interim order of stay in respect of the impugned orders while granting reasonable time to the petitioners to approach the tribunal. Full stop. Next para. Consequently, the writ petition stands disposed of, granting liberty to the petitioners to approach the Karnataka Appellate Tribunal. Full stop. However, for a period of 4 weeks,
8 weeks minutes. They are in America, therefore I have to get
for a period of 8 weeks, there shall be an interim order of stay
date
of the impugned orders at annexures A and B to enable the petitioners to move the tribunal by filing an appeal.
receipt of the certificate copy.
Huh?
Certificate copy.
Illa.
Yes.
Yes.
Above.
Still number 2, B.S. Nagaraj.
Lord, I appear for the petition. But I'm seeking writ of mandamus.
One email is here. The time which is consumed here maybe.
The tribunal shall consider the time spent by the petitioners before this court while considering an application for condonation of delay.
Still number 2, B.S. Nagaraj.
Lord, I appear for the petitioner. I'm seeking writ of mandamus to consider my application for disposing the property. My lord. The land in which it was granted in the year 1975 in the name of my father Dasaya. And 80 it was changed to my grant certificate was issued to in the name of my mother. And land is out of 4 acres, 2 acres, 24 guntas was acquired in the year 1993. But it only remains 1 acre, 16 guntas. If it is divided among
You are seeking a mandamus
mandamus.
in terms of representation.
Representation annexure D page 27. And annexure E, government order, government direction.
ಏನಿದೆ?
ದುರಸ್ತು ಹಾಗೂ ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ಕೋರಿ ಟು ಡಿಸ್ಪೋಸಿಂಗ್ ಮೈ ಪ್ರಾಪರ್ಟಿ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನಮ್ಮ ಬಾಬು ಹುಣಸೂರು ತಾಲೂಕು ಅನಗೋಡು
ಮೈಸೂರು ಜಿಲ್ಲೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಕಂದಾಯ ಸಚಿವರ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಿಂದ ಬಂದ ಮನವಿಗಳನ್ನು
ಸೀರಿಯಲ್ ನಂಬರ್ ಅನೆಕ್ಷರ್ ಇ ನಲ್ಲಿ
ಏನು
ಅನೆಕ್ಷರ್ ಇ ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಮ್ದು
ಜಮೀನು ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ನೀಡುವ
ಬಗ್ಗೆ ಸರ್ಕಾರ ಮನವಿಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ವರದಿ ಸಲ್ಲಿಸಿ.
ಏನಿದೆ? ವಾಟ್ ಇಸ್ ದಿಸ್?
But it is a land granted to the petitioner's father and it was acquired in the year some of the portion 2 acre 24 guntas acquired for the Arangi channel and it remains 1 acre 16 guntas remains that we want to dispose it. We are not able to cultivate this property among the 2 brothers. I am a handicap, so I want to dispose of this, sold the property. I made an application to the commissioner. In turn, the
why permission necessary?
Well, he belongs to scheduled caste. The land was granted to him. That is why he seek permission to sell the property. Otherwise, nobody was purchasing.
Also, this
and thereafterwards, the Tahsildar forwarded the application to the DDLR to change the kata. The Podi and Durasti. Page annexure G. ಪ್ರಸ್ತಾಪಿತ ತಮಿಳಳ್ಳಿ ಗ್ರಾಮ
ಕೋಡಿ ದುರಸ್ತಿನೂ ಆಗಿಲ್ವಾ?
ದುರಸ್ತಿ ಆಗಿಲ್ಲ.
ಫಸ್ಟ್ ಅದನ್ನ ಮಾಡಿಸ್ಕೋಬೇಕು.
ಅಲ್ಲ ಅದನ್ನು ಕೇಳಿ ಎರಡನ್ನೂ ಸೈಮಲ್ಟೇನಿಯಸ್ ಆಗಿ ಕೇಳಿದೀವಿ.
ಕೋಡಿ ದುರಸ್ತಿ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು.
ಇಲ್ಲ ಇದಾಗ್ಲೇ 2018 1 to 5 ಆಗಿದೆ. 1 to 5 ಆಗ್ಲೇ carried out. Page 31 annexure G may kindly look into that.
Subsequently, what has happened? Annexure H, page 33 may be seen, Mela. Page 33.
But they are creating problems.
Page 33 is a letter issued by ADLR to the Forest Department to clarify whether this land comes under any forest area. So, because there is a adralli second para second para ullekha prati ante kadeta ಪರಿಶೀಲಿಸಿದಾಗ ಸರ್ವೆ ನಂಬರ್ 37ರಲ್ಲಿ ಕರ್ದದಲ್ಲಿ ಅರಣ್ಯ ಇಲಾಖೆ ಜಮೀನಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಬಾಬ್ತು ಅರಣ್ಯ ಇಲಾಖೆ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ಪಡೆದು ಕಡತವನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿರುತ್ತದೆ. So this letter is issued to Forest Department to clarify. The next page 34 is annexure J is the letter from Forest Department. Where they say last paramila ಉಲ್ಲೇಖ 5ರಂತೆ ಪ್ರತಿಯಲ್ಲಿ ಉಪ ವಲಯ ಅರಣ್ಯ ಹೊನಗೋಡು ಶಾಖೆರವರ ಸದರಿ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ನೋಡಲಾಗಿ ಸದರಿ ಪ್ರದೇಶವು ಕಲ್ಬೆಟ್ಟ ಬ್ಲಾಕ್ 11 ಅರಣ್ಯ ಪ್ರದೇಶ ನೋಟಿಫಿಕೇಶನ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಡೇಟೆಡ್ ಸೋನ್ಸೋ ರಲ್ಲಿ ರಾಜ್ಯ ಅರಣ್ಯ ಪ್ರದೇಶ ಘೋಷಣೆಯಾಗಿರುತ್ತದೆ. ಮುಂದರೆದು ಕಾರ್ಯಯೋಜನೆ ಮೈಸೂರು ರವರ 2007-8ನೇ ಸಾಲಿನ ಕಾಲ್ಬೆಟ್ಟ ಬ್ಲಾಕ್ 11 ಅರಣ್ಯ ಪ್ರದೇಶ ಗಡಿ ಗುರುತು ಮಾಡಿ ಕಲ್ಲುಗಳನ್ನು ಹಾಕಿರುವ ನಕಾಶೆಯ ಪ್ರಕಾರ ಸದರಿ ಸ್ಥಳ ಅದರ ಒಳಭಾಗದಲ್ಲಿಯೇ ಇರುತ್ತದೆ. ಸದರಿ
how can he make this kind of a statement now when admittedly the other portion of the land
was acquired,
was compensation was given in respect of that land?
Please.
How did you give compensation then if it is a forest land?
That I'll have to verify. I'll take instructions.
avalla agadilla.
In the same survey number 37, this honorable court is directed to effect the Podi and the Durasti, and it was affected. Annexure L is the order passed by this honorable court in the same survey number. This honorable court survey number Tamrelli village, Angod Hobli, Unsur Taluk. ಅವ್ರಿಗೆಲ್ಲ ಎಫೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Because of this man, they are giving trouble.
Survey number 37 of
Tamrelli village.
Nimdu?
Namdu Tamrelli.
Survey number
37, block number 22.
Nimdu same survey number.
Survey number.
So first you will have to get the Podi and Durast done, only then the question of sale will come.
ಅಲ್ಲ Podi Durasti and both we have asked.
ಆಗೋದಿಲ್ಲ, ಹಂಗಾಗೋದಿಲ್ಲ.
ಅಲ್ಲ ಈಗಾಗಲೇ 1 to 5 ಆಗಿದೆ. They have affected.
ಫಸ್ಟ್ Podi Durasti ಆಗ್ಬೇಕು, ನಂಗೆ ಸೆಪರೇಟ್ ನಂಬರ್ ಕೊಡಬೇಕು, ಆಮೇಲೆ ಕ್ವಶನ್ ಆಫ್ ಪರ್ಮಿಷನ್ ಟು ಬಿ ಸಾಟ್ ಬರ್ಕೊಳ್ಳಿ. Learned HCGP takes notice for all the respondents.
The Tahsildar already placed the record before the ADLR to effect the Podi and Durasti.
Next para. The prayer in the writ petition is to issue a writ of mandamus directing respondent number 3, Deputy Commissioner, respondent number 5, Tahsildar, and respondent number 6, Assistant Director of Land Records, to consider the representation dated 22/7/2015 ಯಾವುದು annexure?
Annexure D ಮೇಲೆ.
Page number?
Page number 27.
They'll have to make an online application.
Annexure D, page.
Given by the petitioner. Full stop. Learned counsel for the petitioner submits that it is not disputed that 4 acres of land in survey number 37, block 22 of Tamadahalli village, Hunsur Taluk, was granted in favor of Sri Dasaya, the father of the petitioners, on 15/2/1975. Full stop. However, after the death of Sri Dasaya, the grant certificate was issued in the name of his widow, Srimati Rachamma, on 25/7/1980. Full stop. In the year 1993, 2 acres and 24 guntas of land belonging to the petitioners were acquired in view of the establishment of Harangi project and the submergence of the lands.
No, Arangi channel.
Ashte, Harangi channel. For the purpose of formation of Harangi canal. Full stop. Compensation in that regard has been given to the petitioners. Full stop. However, in respect of the remaining
1 acre 16 guntas.
1 acre 16 guntas of land, the petitioners are seeking Podi and Durast, and thereafter permission to sell the land. Since the petitioners belong to Yav community? Scheduled caste community. And in view of the express provisions contained in subsection 2 of section 4 of the Karnataka SC/ST (PTCL) close Act 1978. Full stop. Learned Counsel has drawn the attention of this court. The other page
Page 27, annexure D.
Page?
Page 27, annexure D.
Allah, ಅದೇನೋ ಪ್ರೋಸೆಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಪ್ರೋಸೆಸ್ ಆಗಿರೋದು
ಯಾವುದು?
annexure. Annexure G, page 31. Page 31, 32 ನಲ್ಲಿ page para 32. ಯಾಕಂದ್ರೆ ಆದ್ದರಿಂದ ಪ್ರಸ್ತಾಪಿತ ತಮ್ಮಡಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 37ರಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಏಕ ವ್ಯಕ್ತಿ ಕೋರಿಕೆ ಮೇಲೆ ದುರಸ್ತಿಪಡಿಸುವ ಸಂಬಂಧ ಈಗಾಗಲೇ ಈ ಕಚೇರಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಮಂಜೂರಾತಿಯ ನೈಜತೆಯ ಅನುಸಾರ ಆದೇಶ ಹೊರಡಿಸಿದ್ದು, ಅದರಂತೆ ಸದರಿ ಜಮೀನಿನ ದುರಸ್ತಿ ಸಂಬಂಧ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಪುಟ ಸಂಖ್ಯೆ 1 ರಿಂದ 92 ಇರುವ ದುರಸ್ತಿಯ ಕಡತ ಹಾಗೂ ಪುಟ ಸಂಖ್ಯೆ 1 ರಿಂದ 389 ರವರೆಗೆ ಇರುವ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತ ಸಂಖ್ಯೆ ಅನ್ನು ಕೂಡ ಲಗತ್ತಿಸಿ ಕಳುಹಿಸಿದೆ. To address it to the ADLR.
To annexure G, which is a communication dated 3/9/2018 made by the Tahsildar, Hunsur Taluk, to the Assistant Director of Land Records. Full stop. Learned Counsel submits that on verification of the original records, the Tahsildar being satisfied that the claim of the petitioners is genuine, forwarded the necessary information along with photocopies of the original records to the ADLR for further action in the matter of Podi and Durast. Full stop. Next para. Learned HCGP, however, submits that the petitioners cannot seek for permission to sell without Podi and Durast. Full stop. Moreover, there is a prescribed format under which the petitioners are required to seek permission under section 4(2) of the Act 1978. Full stop. Next para. Having regard to the submissions made by the learned counsel for petitioner and the learned HCGP, this court is of the considered opinion that the Tahsildar and the Assistant Director of Land Records are required to proceed further to conduct a Podi and Durst in respect of the lands in question. Full stop. As noticed at Annexure G, the Tahsildar has already recommended the case of the petitioners for Podi and Durst. Full stop. Nevertheless, since online application is required to be filed for Podi and Durst, and without which it may not be possible for the Tahsildar and the ADLR to proceed, the writ petition stands disposed of, reserving liberty to the petitioner to file an online application forthwith. And if such an application is filed, the Tahsildar and the Assistant Director of Land Records shall immediately act upon the application that would be filed by the petitioners and proceed to conduct Podi and Durst, taking into consideration the recommendation made by the Tahsildar at Annexure G dated 3/9/2018. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date when which the online application will be filed by the petitioner. Full stop. Next para. Needless to mention that the petitioners are at liberty to seek permission from the government in terms of section 4(2) of the PTCL Act, 1978. And if such an application is filed, the government shall consider the same and pass necessary orders as expeditiously as possible. Yes.
See number 3.
Petitioner in this matter. See, John, petitioner is calling in question the order of the Honorable Karnataka Appellate Tribunal, which affirms the 7A rejection application filed before the Land Tribunal. The order is at page 28. What happens is the petitioners.
Was there any interim protection given to you before the KAT?
There was an interim protection.
Where is it? Where is the order?
That has not been affixed with this petition. But however, the KAT disposes the my appeal by affirming the Land Tribunal's order. During the subsisting of the Land Tribunal proceedings, what happens is petitioner's mother, who is the original 7A applicant.
Sir, I can only issue notice now. Unless you point out that there was an interim order passed by the tribunal protecting your possession,
Please.
I will not be able to pass an order protecting your possession.
The entire order sheet is affixed.
Please point out from that on.
The entire order sheet is at. Please, 134, page number 134.
136, my lord. Order is on.
136.
And 130. Please, 137 and 8. 138. May I beg your pardon? 138. This is the interim protection which was given
Yes.
by the KAT.
Yes.
May I read it? This is an appeal directed against the impugned order dated 24/6.
The appellant has made out a prima facie case, and the delay would defeat the very purpose of granting stay, and the very purpose of appeal would be rendered. The impugned order dated 2015 passed by the first respondent is stayed till the receipt of LCR. Learned AGA takes notice for all the respondents. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioners submits that although the appeal filed by the petitioners herein before the tribunal was dismissed, nevertheless, it is pointed out from the order sheet maintained by the tribunal that by order dated 26/10/2016, the tribunal had passed an interim order of stay of the orders passed by the tribunal, protecting the possession of the petitioner. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures
Annexure
A and B.
A, my
What about B?
B, my lords, is the Form 7A application that was filed before the land tribunal.
Where is the original order of the land tribunal?
Land tribunal order is at annexure, yes, my lords, page number.
Annexure.
It's 97. my lords.
Annexure A and annexure S.
Yes.
Till the next date of hearing.
All the respondents in 1, 3 and 4. 2 is a private.
Oh, correct. AGA for 1, 3 and 4. Issue notice to respond number 2.
Number 4, Omkar Kambi M. Petitioner, my lord. This petitioner is a student who has completed her course in Bachelor of Science, my lords, in the year 2007 in the respondent university, my lords. As the marks card has been issued, my lords, which is at annexure A series. My lords, on 13/5/2020.
Who appears for this Karnataka State Open University?
Mr. Rajendra Kumar Singh.
Learned counsel Shri Rajendra Kumar Sungai is requested to take notice for respondent number 1. For both the respondents.
Both respondents.
Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned counsel for the respondent. Release this matter on 12th of August.
That's one other submission. The council name is being shown as Omkar Kambi MMK. It's only Omkar Kambi. To that effect, it may be. The name of the council, so the petitioner is Omkar Kambi, not Omkar Kambi MMK.
MMK, adiyana typographical error.
Maybe shown as
Office
Omkar.
is directed to show the name of the learned counsel, Shri Omkar Kambi, properly.
Please.
Yes.
Fine. Arun J. Kumar Patil.
Without randomness, your lordships. Directing the authorities to enter my revenue and my names in the revenue entries arising out of a decree of the civil court, your lordships. Arising out of a decree of the civil court, wherein the state government was also a party. Annexure B may be taken, your lord. Page number 28. A suit for declaration and injunction was filed by the petitioners where they are
2013.
Please, your lordships.
What were you doing from 2013?
We have been annexure E1 may kindly be taken immediately after the decree was passed by the civil court. We have given the first representation. Annexure C1, page number 60. 16/1/2014, we have given one representation. Immediately after that, 20th May 2015, we have given a representation. And the latest representation now is 26/2025.
Why did you wait for so many years?
On the part of the petitioners, they have delayed it, your lordships. 4 continuous representations, even as late as 2019, we have given, your lordships. Now in 2025, 20th/6/2025, we've given one more. That is why I have produced all the representations.
You filed a writ petition earlier, obtained an order. Still, you did not. Learned HCGP takes notice for
1 to 4, all respondents.
all the respondents. Next para. The petitioners are seeking a direction to the respondent Fourth
Tahsildar.
respondent, Tahsildar, Anekal Taluk, to consider the representation dated 26/2025 at annexure F given by the petitioners for entering their names in the land records pursuant to a judgment and decree passed by the learned senior civil judge and JMFC at Anekal in OS number 812.
I'll have to verify if there is any appeal filed against this. It may be taken up on Monday, Milord.
Allala, let them consider. OS number 812 of 2009, dated 2nd of September 2013. Good stop. Next para. Although there is a huge delay on the part of the petitioners in filing this writ petition, nevertheless, that shall not preclude the Tahsildar from considering the representations given by the petitioners. Full stop. The Tahsildar is duty bound to consider the representations given by the petitioner and either pass necessary orders mutating the name of the petitioners in the land records or issue an endorsement by stating the reasons for rejecting the application. Full stop. Next para. Consequently, the writ petition stands disposed of with such direction to the Tahsildar, Anekal Taluk, to consider the representation dated 26/2025 at annexure F given by the petitioners.
F and F1, two petitioners.
F and F1 given by the petitioners. Why two representations?
Two different lands, two different petitioners. One person owns 3 acres, 26
suit?
acres, the other one 4 acres. Please.
Suit? What is the judgment and decree?
Judgment and decree also is for the entire. Lordship should get the decree at.
The plaintiffs are the owners.
Plaintiffs are the owners.
Howdo?
Representations are two because they own different lands. Two different lands were granted. In the same survey number, measurement is different, Your Lordships.
Where is the schedule?
Schedule is in the decree, Your Lordships.
So only one schedule.
One schedule, it was a larger extent of 15 acres. In that, 3 acre 26 guntas is in favor of petitioner number 1 and 4 acres in favor of
There is
petitioner
such
number
a
2.
declaration.
Please,
There is no such declaration.
no such declaration. It was for the entire extent. We were granted that extent, Your Lordships.
Correct. There is no such declaration given in the judgment and decree. Madak baradilla. ಏನು ಹೇಳಿದ್ನು? And pass necessary orders after verifying the records or issue necessary endorsement
Please,
as stated here in above, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
please.
Serial number 6, Dayananda KG.
Appear for petition, my lord. The petition filed representation to consider the representation annex rep, my lord. Annex rep representation, my lord. Page number 30, my lord. To enter the name of the petition in the revenue record. Annex rep, page 30. Saguvali ಚೀಟಿ ವೈಯಂತೆ ಖಾತೆ ಮಾಡಿ ಕೊಡುವ ಬಗ್ಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಹೊಸಕೋಟೆ ತಾಲೂಕು ಚೊಕ್ಕಸಂದ್ರ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 78ರಲ್ಲಿ 2 ಎಕರೆ ಕುಸ್ಕಿ ಜಮೀನು ದಿನಾಂಕ 14/8/2006ರಲ್ಲಿ ಮಂಜೂರಾಗಿದ್ದು ಅದರಂತೆ ತಾಲೂಕು ಭೂ ಸಕ್ರಮಣೀಕರಣ ಸಮಿತಿಯ ಸಭೆಯ ನಡುವಳಿ ದಿನಾಂಕ 18/10/1993-94 ಹಾಗೂ ತಹಸೀಲ್ದಾರ್ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ LND DR so and so 9394 ಸಾಗುವಳಿ ಚೀಟಿ ವೈ ಸಂಖ್ಯೆ 2
HCGP takes notice for both the respondents. Next para. The petitioner is seeking a writ of mandamus directing the second respondent Tahsildar Hoskote to consider the representation dated 24/6/2025 at annexure F given by the petitioner and pass necessary orders to issue Form 10, Saguvali chit and enter the name of the petitioner in the land records.
ಸಾಗುವಳಿ ಚೀಟ್ they have issued, my lord. They have
Issued,
issued ಸಾಗುವಳಿ ಚೀಟ್.
Only the entry has to be made in the.
To enter the name of the petitioner
Petitioner.
in the land records pursuant to the Saguvali chit issued in favor of the petitioner. Stop. Next para. Learned counsel for the petitioner submits that the Committee for Regularization of Unauthorized Occupation had passed an order on 14/8/2006.
18/10/1993, my lord.
ಅದು ಸಾಗುವಳಿ ಚೀಟಿ ಇಶ್ಯೂ ಮಾಡಿರೋ ಡೇಟ್
18/10/1993.
Annexure A.
Granting 2 acres of land in survey number 78 of Chopkasandra village, Hoskote Taluk to the petitioner and pursuant thereto a Saguvali chit was issued to the petitioner on 14/8/2006. Full stop. However, the name of the petitioner has not been entered in the land records. Full stop. Next para. The writ petition stands disposed of with the direction to the second respondent Tahsildar Hoskote Taluk to verify the records and find out if such an order was passed by the committee on 18/10/1993 and whether Saguvali chit was issued in favor of the petitioner on 14/8/2006. Full stop. If it is found from the records that the two facts stated herein above are true, then the Tahsildar shall proceed to mutate and enter the name of the petitioner in the land records.
They have also paid the TT, the tax, and
After collecting the necessary fee. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
7, V.V. Badrinath.
Next year, here, my lord, is a government order to grant lands for unauthorized occupants, my lord.
Huh?
The government order annexed here, my lord,
Grant of land in survey number 2 of
of 7 out of Kaligi Halli village.
Kallugapalli,
Type copy at page 15 in favor of
Patalaya.
Patalaya. It is unauthorized occupation. Unauthorized occupation. My lord. The Saguvali chit issue
Unauthorized occupant of
of the land. Grant of survey number 2. Saguvali chit issued, my lord. Next year, beam, my lord.
Patalaya.
Patalaya. Annexure B, the Saguvali chit. Condition is only this 10 years, there shall not be alienation. After the demise of Patalaya, they sold the property. His wife sold the property to the petitioners. So he have a wife and children, wife and sons. And the challenge made, but now the challenge is by the grandsons of Patalaya under section 4(2) of the PTC Act. So this land is an unauthorized occupation, granted land. No, it's based on unauthorized occupation. So therefore, not come under the purview of section 4(2) of the PTC Act. So the alienation made after the period of 10 years. And the initiated proceedings after 21 years later. They filed the application before the third respondent in 2018, my lord, 2018. 18. 22/1/2018. 22/1/2018. Nearly 20 years
Where
later.
do you get the date?
The synopsis, my lord.
Synopsis already order ಎಲ್ರಿ ಗೊತ್ತಾಗುತ್ತೆ ನೀವು ಬರ್ದಿರೋದಂಗೆ
Order ಅಲ್ಲಿ ಇದ್ರೆ is annexed. Annexure J.
It is 2017.
17. This is 18. 17-18, my lord. Case number is 17-18.
ವಾದಿಗಳ ಪರ ವಕೀಲರು ದಿನಾಂಕ 22/1/2018 ರಂದು ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ
ಸಲ್ಲಿಸುವ ಅರ್ಜಿ.
ಮೇಲ್ಪನಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದಾರೆ. January 2018.
Nearly 20 years later, my lord. Nearly 20 years later after the grant, they challenge. The order passed under section 4(2) of the PTC Act. That is confirmed by the Deputy Commissioner. That is under challenge now. This is unauthorized cultivation, unauthorized cultivation. So therefore, provisions of section 4(2) of the PTC Act is not attracted.
Why?
Because it is unauthorized occupation. Though it is not categorized as SC/ST. It is not categorized as
Local
SC/ST.
land is categorized as SC/ST. That's a wrong understanding. Lower land will be categorized as SC/ST lands. Angalla.
No, grant is made
under the provisions of the
Karnataka land grant
rules.
Land grant rules.
If a land is granted to a certain person belonging to the community, it will be categorized as a land granted to SC/ST persons. Ashte.
After 20 years later, they initiated. 20 years later. 2000.
Was there a protection for you before the Deputy Commissioner?
No, there is no such interim order passed. No such interim order.
ಮತ್ತೆ mutation ಎಲ್ಲ ಚೇಂಜ್ ಆಗೋಗಿದೆ ಆಗ್ಲೇ.
Mutation ಇವ್ರ ಹೆಸರು ಚೇಂಜ್ ಆಗಿದೆ. ಇವ್ರ ಹೆಸರು ಆಗಿದೆ.
ಅಲ್ರಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆದ್ಮೇಲೆ
ಆಗಿಲ್ಲ.
2014-3-2022
ಆಗಿಲ್ಲ. ಇನ್ನು ಆಗಿಲ್ಲ.
So you want only issuance of notice?
Stay, because stay also.
That is why I am asking you, where was the stay granted by the Deputy Commissioner?
There is no such order passed.
ಮತ್ತೆ
interim order passed by the Deputy Commissioner. There is no.
ಬರೋದಿಲ್ಲ ಅಂದ್ರೆ.
ಇಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಬರೋದಿಲ್ಲ.
Learned AGA takes notice for response number 1 to 4. Issue notice to response number 5 and 6. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Yes.
Stay may be granted for limit.
No, you should point out there was an order of stay granted by the Deputy Commissioner.
Usually appeal is filed, immediately they grant stay, but there is no material to show that stay has been granted before the Deputy
Of course,
Commissioner.
you'll have to show them. Yes.
Till such time they shall not precipitate the matter, precipitate the order passed under annexure.
Anyway, they have not even made an application. We will see. Yes.
Till then protection order may be given. Otherwise if they
No,
mutate the order.
unless you say such a protection was given to you by the Deputy Commissioner, for the first time it cannot be given without issuing notice to the other side. Yes. Please.
May it please, my lord. My lord, this is impugning the order of the Assistant Commissioner, the Deputy Commissioner, my lord, whereby the grant has been set aside, my lords. The Deputy Commissioner's order, page 44. This is under 108K. 108K, my lords, of the land revenue rules, initially on the ground that they held more lands. That was the, please cite out after
Where is
10.
the order passed by Assistant Commissioner?
Page 27, my lords. That page number 1 itself, the allegation is about line number 4 or 5. ಜಮೀನು ಮಂಜೂರು ಮಾಡಿ ಖಾತೆ ದಾಖಲಿಸಿದರೆ ಒಂದನೇ ಪ್ರತಿವಾದ ಕುಟುಂಬಕ್ಕೆ 10 ರಿಂದ 15 ಎಕರೆ ಜಮೀನು ಇದ್ದರೂ ಸಹ ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ದಟ್ ಈಸ್ ಥರ್ಡ್ ಪಾರ್ಟಿ ಫೈಲ್ಸ್ ಮೇಲ್ಮನವಿದಾರರು, ಮೈ ಲಾರ್ಡ್ಸ್. files the application for cancelling the grant of about 10 years old grant. And then my lord, he says the documents are not found in the file, page 29 from the Right to Information Act.
When was the grant made?
Grant is, my lords, 2012 actually. They have put some other number, my lord, which is not correct. I have produced the Saguvali chit, my lords, page number 20. Page number 20, that page number 21, my lords, 23/6/2012. And subsequently record of rights have been changed and loans were obtained.
2012.
Howdo. Loans were also obtained, my lords. Record of rights show the loans have been obtained from the banks. And subsequently neighbor files an application, my lord, stating that they have hold more lands. Based on that, my lords, the jurisdiction is excised.
Yes.
And at that time he says, neighbor says there are no original documents found. He gives an endorsement, page 29, that extracted, my lords. Tiluvalike Patra, page 29 at the top, my lords. Upendra is the person who filed complaint. He says, I have obtained the information, the Right to Information Act. Document mahiti sigudilla ant heli. That copy he produces. And they say, therefore, document itself is not available. And therefore, I am cancelling it.
What document?
Original grant documents. Neighbor says, I have filed application for certified copy of the original grant documents.
Grant made in your favor.
Howdo. Adu sikkilla copy. Many times, they give endorsement without in searching for that. And they give endorsement. And the endorsement is extracted. Kindly see that, page 29. Tiluvalike Patra. Melgade, page 21. Tiluvalike Patra is extracted. And therefore, he says, document is not clear, genuine, fake madidare. Therefore, I am cancelling it. If it is fake, my lord, say, why did be an issue? Please, at that page number 29 alli, ಮಾಹಿತಿ ಹಕ್ಕು ತಿಳುವಳಿಕೆ ಪತ್ರ ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ ಅಡಿಯಲ್ಲಿ ಕೋರಿರುವ ಅರ್ಜಿ. That's dated 21. ಉಪೇಂದ್ರ ಸೋಯಾನ್ಸೋ ಅರ್ಜಿ ದಿನಾಂಕ ಸೋಯಾನ್ಸೋ. ನೆಕ್ಸ್ಟ್ ಉಪೇಂದ್ರ ಅವರು ಕೇಳಿದ ಕೆಳಗಂಡ ಮಾಹಿತಿಗಳು. ಬಗರ್ ಹುಕುಂ ಅವರ ಅರ್ಜಿ ನಕಲು ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಎಕ್ಸೆಟ್ರಾ ಎಕ್ಸೆಟ್ರಾ. ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ನಮೂದಾಗಿರೋ ಕಾರಣ ಮಾಹಿತಿ ನೀಡಲು ಸಾಧ್ಯ ಆಗುವುದಿಲ್ಲ, ಆದ್ದರಿಂದ ಕಚೇರಿ ವೇಳೆಯಲ್ಲಿ ಹಾಜರಾಗಿ ನಿಮ್ಮಲ್ಲಿರೋ ಮಾಹಿತಿ ನೀಡಿದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ದೃಢೀಕೃತ ನಕಲು ನೀಡಲು ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. Then the endorsement by the Tahsildar concludes, Assistant Commissioner concludes, everything is fake. Next sentence will also be. ಎದುರುದಾರ ಅರ್ಜಿ ಸಲ್ಲಿಸದೇ ಇರುವುದು ಬಗರ್ ಹುಕುಂ ಸಭೆಯಲ್ಲಿ ಮಂಜೂರಾಗದೇ ಇರುವುದು ಸ್ಪಷ್ಟಪಡುತ್ತದೆ. Immediate conclusion. ಕಚೇರಿ ವೇಳೆಯಲ್ಲಿ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. That the neighbor uses it and files. ಆದ ಕಾರಣ everything is fake. Therefore,
ನಿಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ.
Therefore, he cancels it because neighbor does not get the certified copies. Endorsement issued to the neighbor, my lords. ನೀವು ಕಚೇರಿ ವೇಳೆಯಲ್ಲಿ ಬನ್ನಿ. ಕಚೇರಿ, like kindly see at the top, my lords. ನೀಡಲಾದ ಮಾಹಿತಿ. Sushilamma Kom.
Let us come to the impugned order at Annexure E.
Annexure
E, page 27.
27. That's the Assistant Commission's order. First, my lords, ಪ್ರಸ್ತಾವನೆ, may read, my lords. ಮೂಡುಗೆರೆ ತಾಲೂಕು ಬಣಕಲ್ ಹೋಬಳಿ ಕೋಗಿಲ ಗ್ರಾಮದ 41ರಲ್ಲಿ 1 ಎಕರೆ 21 ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಭೂಕಂದಾಯ ಅಧಿನಿಯಮ 94B1 ಅಡಿಯಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿ ನಮೂನೆ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಬಗರ್ ಹುಕುಂ ಸಭೆ 23/6/2016 ನಿರ್ಣಯದಂತೆ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದು, ತಹಶೀಲ್ದಾರ್ ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಅವರ ಆದೇಶ ಸಂಖ್ಯೆ -- ಪ್ರತಿವಾದಿ ಹೆಸರಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿ ಸ್ವಯಂ ಸುರತೆ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿ ಖಾತೆ ಹಾಕಲಿದ್ದಾರೆ. 1ನೇ ಪ್ರತಿವಾದಿಯ ಕುಟುಂಬಕ್ಕೆ 10 ರಿಂದ 15 ಎಕರೆ ಜಮೀನಿದ್ದರೂ ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅವರ ಮಕ್ಕಳಾದಿಗೆ ಸೋ ಅಂಡ್ ಸೋ ಇರುತ್ತದೆ. ಅಂಡ್ ಲಾಸ್ಟ್ ಬಟ್ ಥರ್ಡ್ ಲೈನ್, ಮೈ ಲಾರ್ಡ್ಸ್, ಪ್ರತಿವಾದಿಯಾದ ತಹಶೀಲ್ದಾರ್ ತಾಲೂಕು ಅವರು 1ನೇ ಪ್ರತಿವಾದಿ ಹೆಸರು ನಮೂನೆ 53 ಅರ್ಜಿಯಲ್ಲಿ ನಮೂದಾಗಿರುವುದರಲ್ಲಿ ಹಿಂಬರ ನೀಡಿರುತ್ತಾರೆ. Therefore, filing this application. This is the contention, my lords. And relies upon that endorsement issued by the Tahsildar's office.
Tahsildar Moodigere Taluk.
Moodigere Taluk, my lord. Tahsildar Moodigere Taluk. He gives an endorsement.
ಪ್ರತಿವಾದಿಯ ಹೆಸರು ನಮೂನೆ 53 ಅರ್ಜಿ ವಹಿಯಲ್ಲಿ
ಇರುವುದಿಲ್ಲ,
ನಮೂದಾಗಿರುವುದಿಲ್ಲವೆಂದು ಹಿಂಬರಹ ನೀಡಿರುತ್ತಾರೆ.
Please, that ಹಿಂಬರಹ, my lord, my
1ನೇ ಪ್ರತಿವಾದಿಯ ಹೆಸರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ರದ್ದುಪಡಿಸಲು ಕೋರಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
If it is not there, there is no question of and kindly see now page number 29 for a moment, my lords. This is all narration.
Let us continue reading this.
ಮೇಲ್ಮನವಿ ವಿನಾಯಿತಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಮೇಲ್ಮನವಿ ಅಂಗೀಕರಿಸಿ ಉಭಯತರರಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ಕಾಲಾವಕಾಶ ನೀಡಿ ಸ್ವಯಂ ಅಂತಿಮ ಆದೇಶ ಕಾಯ್ದಿರಿಸಲಾಯಿತು. ಒಂದನೇ ಪ್ರತಿವಾದಿ ವಕಾಲ ಸಲ್ಲಿಸುವುದು ಯಾವುದೇ ಲಿಖಿತ ಹೇಳಿಕೆ ಸಲ್ಲಿಸುವುದಿಲ್ಲ. ಮೇಲ್ಮನವಿದವರು ಮತ್ತು ಪ್ರತಿವಾದಿ ತಕರಾರು ಮತ್ತು ವಾದಗಳನ್ನು ಆಲಿಸಿ ದಾಖಲೆಗಳನ್ನು ಸ್ವೀಕರಿಸಿ ಕಡತದಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಮೇಲ್ಮನವಿದ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಕುಟುಂಬ ಸಾಕಷ್ಟು ಜಮೀನಿದ್ದರೂ ನಮೂನ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸದಿದ್ದರೂ ಸಹ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿರ್ತಾರೆ. ಆದರೆ ಸದ್ಯ ಮಂಜೂರು ರದ್ದುಪಡಿಸಲು ಕೋರಿರ್ತಾರೆ.
ಸೊ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
ಹೌದು.
But they say you are not filed an application.
That's their contention, please.
You are not filed an application.
And
you are holding
excess lands.
Two grounds.
My submission is, my lords, next para he says the same thing, my lords. He reiterates this. Avarige bere jaga untu, etc. Avarige bere jaga untu. That's next para I will not read, my lords. Excess lands are there.
So they have given information.
Excess land as on 2021 kinds that line, my lord. Tahsilar Mudigere ತಾಲೂಕು ವರದಿ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್ 19/11/2021 ರಂತೆ ಪ್ರತಿವಾದನೆ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಯಾವ್ದು ಸೋ ಅಂಡ್ ಸೋ ಇಷ್ಟು ಜಾಗ ಇದೆ ಎಕ್ಸೆಟ್ರಾ ಜಾಗ ಎಷ್ಟಿದೆ ಅಂತ ಹೇಳಿ ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಹೇಳಿ ಒನ್ ಆಸ್ಪೆಕ್ಟ್, ಮೈ ಲಾರ್ಡ್ಸ್. ನೆಕ್ಸ್ಟ್, ಮೈ ಲಾರ್ಡ್ಸ್, ನಮೂನ 53 ಅರ್ಜಿ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ, ಲಾಸ್ಟ್ ಪ್ಯಾರಾ, ನಮೂನ 53 ಅರ್ಜಿ. That is based on the endorsement. Next, kindly see, my lords, page 29. ತಿಳುವಳಿಕೆ ಪತ್ರ.
So now on 2 grounds,
please,
your grant has been cancelled.
My respectful submission is,
yes,
this is invoked, my lords, 2021-22, and there is no order for condonation of the delay. Absolutely no order passed. ವಿಳಂಬಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. My lord may kindly find it, first sentence and page number 28. And the revisional power, my lords, should be 90 days, section 53, or else within a reasonable time, and an exercise by the judicial or the quasi-judicial exercise, my lords, by the authorities, so that he is exercised his power.
These grounds you raised before the deputy commissioner.
Raised before the deputy commissioner. Deputy commissioner says there is no application, the excess land is there, page 44. Therefore, same grounds are reiterated, page 44, my lords.
It does not answer your grounds.
No, those answers, nothing is answered, my lords. About the delay, everything, nothing is answered.
What is your entry?
It is an appealable order.
Deputy commissioner ಹೋಗಿದ್ವಿ.
Under section 50, it is an order. It says if such order is passed by deputy commissioner.
Second appeal. Second appeal before the tribunal.
No, my lords, my respectful submission is, my lords.
Before tribunal.
Section 50.
May I beg to submit on that point, my lords. No, my first original order is by the grant order.
Correct.
Then it goes to the AC.
First appeal is before the assistant commissioner.
Second
appeal is before the deputy commissioner. Yes.
This was considered by lords, by my lords on the previous occasion, because agriculture loan is there, continuous. May I pass on with kind permission? If my lords order, my lords. Unless, my lords, your lordship stays and restores the land, my lords, the loans are also not continued. Huge agriculture crops are there. That's being continued from stage to stage, year to year, my lords. Agriculture loans, practically 3-4% is the interest, bank interest, my lords. My lords, facts were documents were not found. Last but one para, my lords. My lords found in equity, my lords, that the entry should be continued in the name of the petitioner, my lord, as it stood.
Learned HCGP takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for the petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Stop. Next para. Learned senior counsel Shri P.P. Hegde, appearing for the petitioner, submits that 10 years after the Committee for Regularization of Unauthorized Occupation conferred 4 acres and 38 guntas of land in favor of the petitioner. In the year 2012, the fifth respondent herein seems to have
1 acre 20 guntas. 1 acre 20 guntas. The order, my lords, the grant order, my lords.
1 acre 20 guntas in survey number 41.
Please, please.
Of Kogile village Panakal Hobli, Mudigere Taluk.
ಹೌದು.
The fifth respondent herein seems to have filed an appeal invoking
108K.
Rule 108K of the Karnataka land revenue rules, questioning the grant made in favor of the petitioner. Full stop. The Assistant Commissioner merely notices the endorsement issued from the office of the Tahsildar, Mudigere Taluk, that no application was filed by the petitioner, but the grant has been made in her favor. Full stop. Further, the Assistant Commissioner places reliance on a communication dated 19/11/2021 made by the Tahsildar, who stated that the petitioner has various other extents of land in various survey numbers totaling to 13 acres 30 guntas, and therefore the Assistant Commissioner concluded that the grant made in favor of petitioner cannot be sustained. Full stop. Learned senior counsel submits that even the Deputy Commissioner did not consider the contention raised by the petitioner that the application could not have been entertained after 10 years of the grant, without even condoning the delay. Full stop. Moreover, the petitioner has obtained loan from a bank by mortgaging the property in question, and therefore, if the impugned order is not stayed, while permitting the name of the petitioner to continue in the land records, it would cause great difficulty for the petitioner. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures C and D.
Please, my lord. And also, my lord, please. Annexure E and K. Sorry, my lord. How? My lord. E and
K now.
E and K.
Till the next date of hearing.
And also, my lord, in the meanwhile, if they have changed, my lords, it should be, may kindly direct my lords to, shall not change the land record, shall be maintained as it is prior to the impugned endorsement, which your lordship has passed similar order in a similar case, my lords. Last but one para, my lords, in the previous order of my lord.
If in any case, the name of the petitioner is removed from the land records, the same shall be restored forthwith.
Please. Grateful.
Number 9, Sundar Raman MV.
My lord, appear for the petitioner's counsel. My lord, education matter. My lord, this pertains to a college in Mysore called the St. Philomena's College, which, my lord, was set up by the then Maharaja in 1945. And my lord has been receiving grant aid, my lord, from the state, my lord, since 1977. Now, my lord, in 2017 is where the present issue arises. My lord, we wrote to the fourth respondent stating that there are 10 positions that have become vacant because of position teachers, lecturers who have left and gone. So 10 positions have become vacant. So please permit us to recruit fresh teachers, fresh professors in their place. So this was in 2017. Then, my lord, in 2018, my lord, the fourth respondent says, I permit you, according to me, it's fine, you can recruit, go ahead and recruit 9 people. Then, my lord, we complete the process of recruitment in 2019. And we sent it to them saying, please see, these are the people we have recruited. Please approve this and, my lord, therefore give us grant in aid for these professors. Then, my lord, in 2019, several months thereafter, my lord, the commissioner then says, no, sorry, you ought to have followed the procedure that is prescribed by UGC, which involves the establishment of a committee by the university. So therefore, you have to redo this process. And my lord, they asked us to redo this process in September of 2019. Then, my lord, COVID-19 comes. In 2020, the government passes an order stating that please don't fill up any of these positions, keep them vacant, place a hold on all these appointments, etc. So, my lord, they've kept on hold till 2022. Then, my lord, 22, we write to the universities to say, please, now that this prohibition is lifted, please appoint a committee to do the recruitment of these 9 professors. The university then, my lord, appoints a committee. The committee then, my lord, conducts interviews, etc., and recruits people. And then, my lord, we again send them the list of 9 professors who have been selected, saying, please, these are the 9 professors, please accept them. Then, my lord, they again sit on it for several months. They ask us for documents after documents. They sit on it for several months. Then, my lord, they come back and say, sorry, according to us, you have now, your registration as a minority institution has expired in 2019. Therefore, we cannot approve any of these things. You must go and get a fresh registration as a minority institution, which, my lord, is completely wrong. I'll come to that in a minute. But notwithstanding this, my lord, we said, very well, if you say my minority status is expired, I make an application for appointment of a grant of minority status. They, my lord, appoint a 3-member committee. The 3-member committee then, my lord, goes into my lord, only few things to be looked at to see whether I am a minority institutions. They look at all of it, and they also verify whether I have sufficient number of minority students in my college and all of these things. Then, my lord, the committee also recommends it in September of 2023. My lord, till date, my lord, neither have we heard anything further with regard to the minority status, nor, my lord, about the appointment of these professors. Now, my lord, these professors, my lord, are going on, my lord, a partial part of their pay, because they're not getting the entire pay which they would have got if they would have got the scales that was available for grant in aid. Now, my lord, if I may just point out 2 positions with regard to the law on this. My lord, under the provisions of the Karnataka National Commission for Minority Education Institutions Act, the central law. My lord, I am an institution recognized as.
A few years ago, all these problems arose. I remember many of these institutions made applications, and they came before this court, saying we are not. It is not clear whether we should approach the central government or the state government. Thereafter, state government issued a circular appointing a particular person before whom you could go and make an application. That was the position insofar as the minority status is concerned.
What is the position? My position is not. I have made an application to that person. They appointed this 3-member committee. 3-member committee has also recommended that. 3-member committee has also recommended. Is asking me where it is. Annexure Q at page 113. If Manoj kindly looks at Annexure Q at page 113, this is on pursuant to an inspection that they did on 14/9/2023, which Manoj will see at the mast. Kindly go over to the next page at page 114. Sarkarada Adhisoochane, reading the last paragraph. Sarkarada Adhisoochane Sankhya number so and so Dinanka 37/2014 ಪ್ರಕಾರ ಪರಿಶೀಲಿಸಲಾಗಿ ಆಗಿದೆ. Then, my lord,
Christian
ಸಮುದಾಯದಿಂದ ವಿದ್ಯಾರ್ಥಿಗಳ ಸಂಸ್ಥೆಯು
ಸಂಖ್ಯೆಯು ಸದರಿ ಸೂಚನೆಯ ನಿಯಮ 4ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಪ್ರಮಾಣ ಅಂದರೆ 50% ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಕಾಲೇಜನ್ನು ಮತೀಯ ಅಲ್ಪಸಂಖ್ಯಾತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಎಂದು ಘೋಷಿಸಲು
ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ.
That is the recommendation.
This is the recommendation.
They have not passed any order.
No order till date. So, my lord, at this point of time, I'm not seeking any interim relief, but if, my lords, they take notice and this can be disposed of finally, my lord, 9 professors who are getting a part of their pay for last several years.
When was that recommendation made?
This is on 14/9/2023, my lord.
14/9/23 is the inspection. My lord, this report itself does not have a date. It is a little after that is my.
But Annexure A impugned is much prior to that, my lord. 21/6/2023.
Huh?
Annexure A impugned order.
What is
Please.
Annexure A?
No, the Annexure A, my lord, is where they say that my status as a minority institution has now expired. It has come to.
Not renewed after 2009.
So that I have challenged, my lord, contending that that's not the correct position in law. So I have challenged that also, but that's quite apart from that.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned senior counsel Shri Arun Kumar, appearing for the petitioners, submits that at Annexure A is a communication made by
The fifth respondent to the fourth.
additional director, collegiate education, to the joint director, regional joint director, respond number 4, stating that it would not be possible to approve the 9 candidates proposed by the petitioner institution for appointment to various vacant posts
And selected by lot with the committee appointed by the university under the UGC rules.
on the ground that the minority status given to the petitioner institution has since lapsed.
Yes. 6/8.
Full stop. Learned senior counsel submits that the entire process of filling up the vacant posts commenced in the year 2017, and thereafter, although the appointments were made in accordance with law, nevertheless, on the insistence of the respondents, the petitioner institution went before the committee appointed by the university for selection of the candidates for appointment, and the committee of the university approved the same on 6/8/2019. Full stop. Nevertheless, since it was pointed out that the minority status granted to the petition institution had lapsed, the petitioner made an application seeking the minority status, and a 3-member committee recommended the case of the petitioners for grant of minority status, as can be seen from Annexure Q.
Yes. At page 113. Annexure Q is also at page 111. Q1, Q2 and
Q2.
Q2.
Annexure Q2. Full stop. Learned senior counsel points out that the inspection made by the 3-member committee was on 14/9/2023, and the recommendation was made somewhere at that point of time, and till date no action has been taken by the competent authority to confer minority status, and the filling up of the vacancies is also delayed on account of the inaction on the part of the state government. Full stop. Next para. Release this matter on 12th of August 2025. Learned AGA is directed to secure instructions and make submissions.
Can I request 11th?
Huh?
Can I request 11th? 11th or 19th?
19th.
All right, 19.
19. Great.
So number 10. J. Sridhar, S.J. Sridhar.
Will appear for the petitioner. My lord, petitioners are students of law in a college, my lord, affiliated to the first respondent university. They have, my lord, have pursued the 3-year LLB course, and now, my lord, they are finished their examination of the second year and going to third year. Now, my lord, as a bolt from the blue, there is a communication that has been received from the university. Your lordship may kindly turn, my lord, to Annexure B. Well, the matter relates to payment of fees, my lord. Kindly see what has happened. Fee has been fixed. Now, my lord, for the first year, it is 8,580 rupees. And for the subsequent years, my lord, they have excluded only that registration fee of 2,000 rupees.
Where do you get this 8,000?
My lord, 8 at the bottom, my lord.
Abstract of total fee. Karnataka student.
Yes, my lord. 8,580.
First year in the mail.
Yes, first year the mail. Second year, they only exclude the 2,000 rupees, which is the registration fee, and then charge, my lord, again the admission fee, everything, and then make it 6,580. Now, my lord, kindly see, my lord, under the statute, this has been issued, my lord, if your lordship will kindly see reference on top of page 23, approval of the 37th Academic Council and Honorable Vice Chancellor. Now, my lord, under the statute, neither the Academic Council nor the Vice Chancellor have any power like this. It is only the syndicate. Please see the statute, my lord. My lord, if your lordship will kindly turn to.
You are challenging this one.
Yes, my lord. Yes.
8,580.
8,580 for the first year. And 6,580 for the subsequent year. And now, my lord, kindly see the type of increase they have done, which is so arbitrary. Please be kind enough to turn to page 8, my lord, of the writ petition. Kindly see how from 2023 this is going on, my lord, and now because of this steep increase which students cannot afford, we are before your lordships, my lord. I mean, there are students from all kinds, my lord, this is impossible to pay this type of fee. Please see, my lord, what has happened.
8,580.
Yes, my lord.
Per year.
Yes, my lord, it is. It is. I mean, my lord, it's a huge. Kindly see, my lord, the type of increase that has taken place. Please see, my lord, page 8.
I thought the fees was somewhere around 1 lakh.
This is
affiliated university.
This is for the university.
Affiliated.
And there is a separate college fee. This is for the university. College fee is what your lordships mentioned. That is different. Now this is for the university again. Now, my lord, please see page 8. My lord, your lordships will kindly see why I am mentioning this. Though as an amount it may look a little small, but kindly see, my lord, page 8. My lord, 2023-2024, university fees was 3,700. It was increased, my lord, by 93% for 2024-2025. And it has been increased, my lord, between 2023 and 2024 and 2025-2026 by 128%. Apart from the increase, my lord, apart from the quantum of increase, your lordship may kindly see, my lord, the Act, Karnataka State Law University Act. If you, may we pass on a copy, my lord, for your lordship. Lord, please be kind enough to turn to section 30. They have no power like this. It can't be done like this, my lord, under the statute. There is a provision itself as to how fee can be regulated by the university. Now, would your lordship kindly turn to page section 30, my lord? Syndicate. The syndicate shall have the following powers, namely, if your lordship will now kindly go to 23, my lord, at page 23 of the, to charge and collect such fee as may be prescribed by the statutes. There is no statute. Syndicate has not done anything. It is the Vice Chancellor Academic Council that is borne out by Annexure B. So therefore, my lord, this type of increase is unauthorized.
Where is the statute?
There is no statute. There is no statute. And in any event, academic council and vice chancellor cannot do anything with respect to the fees. And your lordship may kindly see annexure B. It says academic council and vice chancellor.
Statute this is the statute. The
No,
Karnataka State
up to
Law
appoint.
University Act
ಇಲ್ಲ, ಅದು
2009.
ಬೇರೆ ಬರುತ್ತೆ ಅಂತ ಕಾಣುತ್ತೆ. To appoint, to charge and collect such fee as may be prescribed by the statutes. Statutes ಮಾಡಬೇಕು. Under the act, they have to make statutes.
We'll issue notice.
My lord, now the last date for payment of this fee, my lord, is 11. My lord, your lordship may state this for the present, my lord. We will pay it later, my lord. After all,
It states, sir.
my lord, there's no power at all.
No, no,
My lord, there's no power at all.
How do you say that they don't even have the power to collect the fee?
No, they have. I'm not saying
Then-
no. Syndicate can. Not the vice. My lord, now kindly see annexure B.
Do not know. You
Madam,
are only
annexure
aggrieved,
fee, madam.
you are only aggrieved of the increase in the fee.
No, my lord, kindly see
Earlier
annexure.
also you have paid the
Of
fee.
course, we have paid. Kindly see annexure B, my lord. Please see annexure B.
Issue, who appears for this Karnataka State Law University? Huh? Who is the other one?
Girish Kumar.
Girish Kumar. Learned Counsel Shri Girish Kumar is requested to take notice for response.
I'm told my copy has been served on him also.
Huh?
Serve ಮಾಡಿದ್ದಾರೆ.
1 and 2. Issue notice to respond number 3.
My lord, we will continue pay as per earlier, my lord. This increase may be stayed, my lord. Because your lordship may kindly see annexure B for a minute.
We will have it next week itself. Let them come. We will see.
Even reference, they don't even give the reference of the syndicate also. They only give academic council and vice chancellor. Everybody power.
Earlier also it was the same thing.
I know. That's why, my lord, I
Let us-
understand. My
let us-
lord. Can the increase be stayed, my lord? Because it's difficult, my lord. There are 30,000 students. And it's difficult, my lord, for the students.
No.
College fees ಕೊಡಬೇಕು.
College fees, you are paying to the tune of 1 lakh.
Of course.
And you are aggrieved by increase of 2-3,000
This is
rupees.
because this is governed by a statute.
consider.
This is governed by a statute.
We will consider.
College is different, my lord. It's my option. Whether I want to go to that college or I don't want to go to that college.
Directed to serve copies of the petition along with annexures on the learned council for response number 1 and 2. Release this matter on 11th of August, Monday.
When?
11, Kumar V.
But can it be on Tuesday, my lord, Mr. Ben?
All right. Well, all right.
Please, my lord, for the petitioner, my lord. Challenging the order, my lord, passed by JDLR. Lord, after a lapse of 83 years, Podi is sought to be revoked and cancelled, my lord. Can we see, my lord, annexure A,
Suo motu powers, huh?
on basis of an application made before Deputy Commissioner of Land Records, my lord, at annexure B. What he says, my lord, there are two aspects. One, there is a lapse of 83 years that is not explained. Secondly, there is a suit, comprehensive suit, partition and declaration suit pending between the parties since 2006. Because of these reasons, this application cannot be entertained. It came to be dismissed. They prefer an appeal before JDLR. The JDLR taking note of all these, my lord, kindly look at, my lord, page 16. The order starts from page 13. He takes into consideration all these aspects, my lord. He says 83 years delay there. On the OS pending there, which is for partition and declaration. This is amongst family members suit, partition and declaration of sale deeds. Despite this, without explaining any reason for 83 years delay, my lord, order came to be passed at, my lord, page 19. Page 19, my lord, operative portion. ಮೇಲಿನ ಖಂಡಿಕೆಗಳಲ್ಲಿ ಸಿಕ್ಕ ಸರ್ ಮೇಲಿನ ಖಂಡಿಕೆಗಳಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಆನೇಕಲ್ ತಾಲೂಕು ಅತ್ತಿಬೆಲೆ ಹೋಬಳಿ ಸೋ ಅಂಡ್ ಸೋ ರ ಕುರಿತು 1ನೇ ಎದುರುದಾರರ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕರ ಆದೇಶ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 6 ರಲ್ಲಿ ದುರಸ್ತಿರಾಗಿರುವ 6/1/2 ಹಿಸ್ಸಾ ಪೋಡಿ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸಿದೆ. 1938 ಸೇಲ್ ಡೀಡ್ ಅವಾಗಾಗಿರೋ ಪೋಡಿನ while the case is still pending, my lord, now after lapse of so many years, my lord, except for a judgment of the court, my lord, Podi could not be cancelled. Respondent number 14 herein is the applicant.
FCDP takes notice for response number 1 to 5. Issue notice to response number 6 to 14. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next paragraph. Huh?
Vishwanath Reddy.
Learned counsel G. Vishwanath Reddy has entered appearance for respondent number 4.
14.
Huh?
14
Respondent number 14. Man.
14. Huh?
14.
14 by filing a caveat petition.
Copy has been served on him.
Next paragraph. Learned counsel for the petitioner submits that although the deputy commissioner and ex officio deputy director of land records had rightly rejected the appeal filed by
Respondent number
14 herein. Nevertheless, the regional director, regional commissioner, and joint director of land records has passed the impugned order without considering the fact that the Hissa Podi, which were settled about 83 years ago, is sought to be challenged by respondent number 14 herein, and the fact that the rights of the parties are yet to be decided at the hands of the competent civil court in OS number 1672 of 2006. This is filed by whom?
This is filed by the petitioner's husband. He is no more.
Which has been which was filed by the petitioner's husband. Full stop. Next paragraph. Consequently, there shall be an ad interim order of stay of the impugned order at annexure A till the next date of hearing.
12. Rajesh Gowda.
Writ of mandamus.
ಇದರದ್ದು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ರಿ ಸ್ವಲ್ಪ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದರದ್ದು ಪ್ರೊವೈಡ್ ಮಾಡಿದಾರೆ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ ಇಲ್ಲಿ ಎಲ್ಲ ಇನ್ನು ಮತ್ತೆ ಟ್ರೈಬ್ಯುನಲ್ ಕಳಿಸ್ಬೇಕು ನಾವು
Those tribunal will get the clarification, my lord. There, the amendment is only the word not on the chapter.
ಅಲ್ಲ it is very very clearly stated. It is clearly stated in the provision itself. It is to reduce the burden of the High Court.
High Court.
They have used both the provisions.
Yes, sir.
49 and 136. ಎರಡು ಮಾಡಿದ್ದಾರೆ.
Chapter 5 ನಲ್ಲಿ that is said.
It will apply anta.
Yeah, will apply. 49.
And they have clarified it is for this purpose that we are removing that word so that the matters can go before the tribunal.
So the burden of the High
Yes,
Court.
yes. ಇದರದ್ದು ಒಂದು ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಕೊಂಬಿಡಿ. Yes.
Writ of mandamus. The land has been granted in favor of the petitioner 1978. The mutation entries still continued till 2001. Thereafter were discontinued. In page number 9, we produce the grant certified copy of the grant order. 2 acres of land in survey number 81. And in page number 16, 1978 to 2001 is
2001 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? Learned AGA takes notice for response number 1 and 2. Next para. The prayer in the writ petition is to issue a writ of mandamus directing respondent number 2 to consider the representation dated 2/6/2025 at annexure A given by the petitioner and to re-enter the name of the petitioner in the land records. Full stop. Learned next para. Learned counsel for the petitioner submits that 2 acres of land in survey number 81 of Kitagnur village, Bidarahalli Hobli, Bangalore East Taluk, bracket earlier Hoskote Taluk, close bracket, was granted in favor of the petitioner in the year 1978. Full stop. Pursuant to the grant, the name of the petitioner was entered in the land records in the year 1979, and it continued till the year 2000-2001. Full stop. However, after computerization, the name of the petitioner was not continued in the land records. Full stop. Therefore, the petitioner has given a representation to the second respondent Tahsildar to re-enter the name of the petitioner in the land records. Full stop. Next para. Having regard to the grievance of the petitioner, the petition stands disposed of with the direction to the second respondent Tahsildar Bangalore East Taluk to consider the representation dated 2/6/2025 at annexure A given by the petitioner. Full stop. The Tahsildar shall verify from the records as to whether the grant was made in favor of the petitioner and whether his name was earlier entered in the land records. Full stop. If it is found that the statement made by the petitioner is correct, then the Tahsildar shall pass necessary orders to re-enter the name of the petitioner in the land records. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
13, Ganesh NI, petitioner.
Appearing for R3 member, K. Veta. Government matter. According to 1978 PTC.
I will make my submission.
Please wait. Yes.
Let's the deceased respondent number 3, please. Let's. Deceased respondent number 3 on Ramaswamy. He was issued with an Saguvali chit on 14/5/1974. The grant was on offset price basis, please. Measuring 2 acres of land. Let's on 16/11/1991. The period fixed for non-alienation clause was 15 years, please. On 16. Then Yogesh did not get the revenue records changed on to his name. Taking such an advantage, once again he sells the same land in favor of one Madan Lal Jain. We have purchased in 1994. After 3 years from the date of first sale. In the year 1994 itself, we have purchased the land, same land, from both Yogesh and Madan Lal Jain. So from 1994, we are in possession of the land prisoners. In the year 2009, the deceased Ramaswamy grantee, he approached the Assistant Commissioner prisoners. He files an application. The Assistant Commissioner conducted proceedings without even issuing notice, please. I have produced the entire order sheet, please. Maintained in the AC court, please. Without issuing notice, he has conducted the proceedings. The proceedings were conducted from 27/2/2019 to 8/4/2011. The deceased petitioner died on 3/7/2010. The order came to be passed against the dead person, please. No LRs were brought, no report of death was made before.
Against in favor of?
Illa, against. Purchaser satogtare. Purchaser satogtare. Purchaser satogtare, no LRs were brought, no report of death was made in the proceedings, please. I have produced the entire order sheet, annexure K. Let's before this, please. Let's annexure M, please. Let's in page number 3. what it says, it is the impugned order.
2011 is the order.
ಹೌದು 8/4/2011
Directing restoration.
ಎಸ್ ಪ್ಲೀಸ್ ಈ ಮನವಿಯನ್ನು ಪ್ರಕರಣವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಚಾರಣೆಗೆ ದಿನಾಂಕ 27
ಆಯ್ತು, there is an order of restoration.
ಅಲ್ಲಲ್ಲ 2009ರಲ್ಲಿ ವಿಚಾರಣೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳಿಗೆ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. I have produced the entire order sheet annexure K in page number 47. 27/2/2009 proceedings start ಆಗುತ್ತೆ. No notice was ordered to be issued. ಇಲ್ಲಿ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಬಗ್ಗೆ ಒಂದು ವರ್ಡ್ ಕೂಡ ಇಲ್ಲ. ಸೊ after this order came to be passed, I have received a notice from the Assistant Commissioner Office, please, in the year 2023. Then I applied for certified copies of the entire order sheet and I preferred appeal before the first respondent Deputy Commissioner. The Deputy Commissioner passes orders without going on to the merits, please. That's only on the point of delay. Since there is 11 years delay in preparing the appeal, so the appeal has to be dismissed. So he has dismissed the appeal, please. And I have, along with the appeal memo, please, I have also produced application under Section 5 of Limitation Act, narrating the entire facts as to why delay is caused, please.
You see the second page of the order.
Order passed by DC, please.
AC.
Please. There is an observation that the elder son of deceased petitioner was served on time.
Yes.
But in the entire order sheet,
Yeah.
in the entire order sheet,
Anyway, next.
Same.
Deputy Commissioner ಮುಂದೆ ಹೋದ್ರಿ.
Please. The Deputy Commissioner, he passes orders only on the point of delay, please. Last page. Page number 75, please. Para 8. ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿದಾರರು 11 ವರ್ಷಗಳ ನಂತರ ಕೆಳ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಪ್ರಶ್ನಿಸಿ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸುವುದು ಕಂಡುಬರುತ್ತದೆ. ಕರ್ನಾಟಕ ಅನುಸೂಚಿತ ಜಾತಿಗಳ ಮತ್ತು ಅನುಸೂಚಿತ ಬುಡಕಟ್ಟುಗಳ ಕೆಲವು ಭೂಮಿಗಳ ವರ್ಗಾವಣೆ ನಿಷೇಧ ಕಾಯ್ದೆ 1978 ಕಲಂ 5A ರ ಉದ್ಧೃತ ಭಾಗ ಈ ಮುಂದಿನಂತಿದೆ. Any person aggrieved by.
What did you do after the order was passed by the Assistant Commissioner?
Lordship, they prepared an appeal before the DC.
What did you do after?
Restoration.
When it was restored?
2011.
When the mutation entries were changed?
No, till now RTCs are in my name.
In your name only?
Yes, I have produced.
So you have not sought for restoration?
We sought for
not implemented the order.
AC, my lord. We sought for restoration before the AC, my lord. AC order in favor of us, sir, grantee.
Order ಆದ್ಮೇಲೆ ಏನ್ರಿ ಮಾಡಿದ್ರಿ?
They preferred.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು. You didn't do anything. You kept quiet. What is the use of taking that order from the Assistant Commissioner? You didn't seek physical restoration of the land and change in the mutation entry. Nothing you did.
Millards, he settled in Bangalore, please, Millards. Our deceased respondent number 3, nobody was there in the vicinity. So they did not implement the order. We also did not know about the order passed by the Assistant Commissioner for 11 years.
Learned AGA takes notice for response number 1 and 2. Learned Counsel Shri M.R. Hirematad has entered appearance for response number 3.
Yes, ma'am.
By filing caveat petition.
We will file objection.
Learned Counsel for petitioners is directed to serve copies of the petition along with annexures and the learned AGA. Full stop. Next para. Learned Counsel for the petitioner submits that although the Assistant Commissioner noticed the fact that the first sale was made on 31/1/1991 and the appeal before the Assistant Commissioner is filed in the year 2008. comma, that is nearly 17 years after the first sale. Nevertheless, the Assistant Commissioner has directed resumption and restoration of the land on the ground that the sale is in contravention of section 4(2) of the PTCL Act, 1978. Full stop. It is also pointed out from the order passed by the Assistant Commissioner that the notice sent to the respondent was received by his elder son Ishtiaq Ahmad, but there is no representation for the respondent. Stop. The petitioners were not aware of the orders passed by the Assistant Commissioner, which is supported by the fact that pursuant to the orders passed by the Assistant Commissioner, neither mutation entries were changed nor the authorities came to the lands in question to restore the land physically in favor of the original grantee or his legal heirs. Full stop. The petitioners continue to be in possession and the revenue records are also standing in the name of the petitioners. Full stop. The appeal filed before the Deputy Commissioner was dismissed only on the ground of delay, since the appeal was filed in the year 2023, while the order of the Assistant Commissioner is of the year 2011. Full stop. Next para. There shall be an ad interim order of stay of the impugned orders.
Annexure M and R.
At annexure
M and
R till the disposal of the writ petition.
Say number 14, Akka Mahadevi Remat.
This is super specialty batch of the year who passed out in the year 2023. After 2 years, my lords, the government has issued notification at Annexure A, page number 139, asking them to come and serve. And they
Compulsory service.
Yes,
Same.
Rural specialty. Now they have issued, my lords. What they say is, we are going to give you only for those who have the vacancies. Remaining all will be based on the merit they are going to exempt. They are not taking all the candidates compulsorily, as mentioned in the original act. The act is amended, which makes it as merit-based exemption. And there are no vacancies according to them only. According to the department only, we don't have so many vacancies. But they say that you all have to work without even showing vacancies. And my lords, these all have completed in the year 2023. It is 2 years since now. Now they are asking them to come back when they are now in the midst of their jobs. And many of them have taken fellowship exam. So it is very difficult now at this stage to come and do it, my lords. The same law is already stated by this honorable court. That is there at the page number. In this only I have annexed, my lords. Page number 154. Annexure A2, my lords. But since they cannot now come, my lords, therefore they may not be insisted upon.
Is it not the same
law
order?
Same law, same order, my lords.
Same
That is
order.
for PG, this is for super specialty.
So same orders that had passed in that
Yes,
order also?
Yes,
Same.
yes. As far as candidates are concerned, they are super specialty. But the batch came out in the year
Learned
2000.
AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 9.
Yes, because, my lords, these are the candidates.
Learned counsel for the petitioners is directed to serve copies of the petition along with annexures and the learned AGA. Full stop. Next paragraph. Same orders. Yavadamma? Monne madidno?
Annexure A to 5.
Alla monne anno madid yavadu?
Annexure A to same, my lords.
Monne ನಾವು ಮಾಡಿದ ಯಾವ writ petition ಅಲ್ಲಮ್ಮ? In case ಅಲ್ಲಿ
My lords, that the writ petition number I'll put.
Please give the writ petition number. Same order.
My lords, may I request, my lords, here. That is already they have given documents. Here after 2 years they are calling. Let them not insist upon registration or even counseling.
ಆಗಿದೆಲ್ಲ same order we are passing, whatever has been passed.
My lords, in the yesterday's order, your lordship said they are not prevented from registering.
Correct.
Here, they cannot even register because of the reason after 2 years they are calling them. After 2 years, they have issued notification now. Therefore, let them not insist till the government files out their objections.
No, you yourself said.
For that is for PG, my lords.
Howdo?
That was issued in the December.
Correct. Even though such an order is passed, clarifying the previous order, nevertheless, the government itself has.
Yes, that is already 5 months over.
Taken
They
a
have
decision not
taken-
to.
But now it is imminent, my lords, because 25/7 is a notification.
Agadi.
Annexure A.
No.
No, my lords, my request is
No,
this.
no.
My lords, because 2 years since, my lords,
Yes.
they cannot now come in between and they
No,
cannot
no.
do it.
Yes.
Number 15.
Lord, petitioner is seeking writ of mandamus for issuance of Saguvali chit. Lord, second respondent committee has regularized the land, my lord, in survey number 282 as per annexure A, my lord, on 25/2002. Thereafter, my lord, as per annexure B, my lord, Tashildar is issued a OM, official memorandum, my lord, on 14/5/2004. Subsequently, my lord, called upon the father of the petitioner to issue notice on 10/6/2004 as per annexure C, my lord, called upon to pay the amount. Subsequently, as per annexure D, he paid the amount, TT amount. Then, my lord, they have not issued, my lord, Saguvali chit. Lord, the petitioner father died in the year 2016. Subsequently, petitioners have made representation.
So he also did not seek entry of his name till his death.
Unless they have issued Saguvali chit, my lord, they will
He
not.
didn't ask for Saguvali chit.
During his annexure G series, I have produced similar other persons. They have already issued Saguvali chit in respect of the land regularized by the committee.
Yavaga?
Lord, in the year 2004 itself. Lord, annexure G
Therefore,
page.
what were you doing then? What was your father doing? Huh? Learned AGA takes notice for all the respondents. Next para. The prayer in the repetition is to issue a writ of mandamus directing respondent number 3 Tahsildar to issue Saguvali chit in favor of the petitioners pursuant to the order of regularization of unauthorized occupation passed by the committee on
25/2002.
25/2002 at annexure A. Full stop. Next para. Learned Council submits that at annexure A is the list of persons bar applicants in whose favor the committee passed orders of regularization, and the name of the petitioner's father is found at serial number.
That's serial number 19 and 36.
19.
Yes, serial number 19, my lord, and 36. There are two parts, my lord, 25 guntas and 22 guntas.
And 36. Comma, both in favor of Shri Chikkanna, son of Narsimhaya. Full stop. Two pieces of land measuring 25 guntas and 22 guntas were regularized in favor of Shri Chikkanna. Full stop. It is pointed out from annexure G that Saguvali chits were issued in favor of the other applicants way back in the year 2004 itself. Full stop. However, Saguvali chit was not issued in favor of Shri Chikkanna. Although he paid the Kimmat as seen at annexure
D and D1, my lord.
D and D1 pursuant to the notices issued at annexures C and C1. Full stop. Next para. The writ petition stands disposed of with the direction to the third respondent, Tahsildar, Kunigal Taluk, to consider the representations given by the petitioner. At annexure F dated 12/12/2024, comma, verify the records and find out whether Sri Chikkanna was indeed granted with the 2 pieces of land. Full stop. If it is found that the committee had in fact regularized the lands in favor of Sri Chikkanna, comma, the Tahsildar shall proceed to pass necessary orders issuing Saguvali chit in favor of the legal representatives of Sri Chikkanna and enter their names in the land records pursuant to the issuance of the Saguvali chit. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Lord, serial number 16, my lord, arising out of same survey number is serial number 30. Granting. Same serial number 30.
One single portion, no? Serial number 30 in the list.
You know?
A list.
Arising out of same survey number, my lord, is one of the grantee. Serial number only 30, my lord. Her land was granted by regularized by the committee.
All either listal serial number 30 you are saying.
Listal say.
Yes, sir.
Jayamma from Chikkanna.
ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಇದಲ್ಲ ನಮ್ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲ ಆ ಲಿಸ್ಟ್ ಆಫ್
ಆಸ್ ಪರ್ annexure A in the list
annexure A ಅಲ್ಲಿ ಅವರದು ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಮತ್ತೆ 36 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದೆರಡು ತೆಗೆದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 30
annexure C and D is
in the name of
Jayamma
Chikkanna.
Jayamma, wife of Chikkanna.
Yes.
Extent
1 acre 5 guntas.
All right.
Representations, my lord, annexure E and F.
Dated?
Lord, dated, my lord, 3/3/2023 and 12/12/2024.
All right.
Number 17, Khan Pasha.
Appearing for the petitioners in this case. My lord, Podi and Durst online application. Similar to item number 2, my lords. Petitioner has given representation to the respondent to conduct Podi and Durst given. In 2023, my lords, since 2 years, no action has been taken.
You will have to file it online. Even in that case, we have said you will have to file it online.
Please, my
Huh?
direction.
Online
And time period.
Podi and Durst. We have fixed it.
Please.
Yes.
Great.
4 weeks
One submission.
to file memo of appearance. Yella case.
My lord, one submission. Due to oversight, ADLR is not made party, my lords. I am filing application.
ADLR.
Please.
ಅಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ what is that you are giving?
Impleading application.
Application
For
learned counsel Podi. Learned counsel for the petitioner has filed an application to implead the assistant director of land records.
please.
Comma Chikbalapura subdivision.
Please.
Huh?
Please.
The application is allowed. And the assistant director of land records is directed to be impleaded as respond number 5.
Please.
Learned counsel for the petitioner shall carry out the amendment forthwith. Yes.
Great.
Preliminary, serial number 18.
I appear for the petitioner, Manoj. My request for change of Kata Pani is rejected on the ground that no permission of sale is obtained, Manoj. My lords have heard this matter in the last date of hearing, directed me to produce the RTCs in favor of my vendors. I am producing them along with him.
My instructions are, my lord, it is a PTCL land. It is granted. It seeks for weeks time, my lord, to secure that records, my lord. Annexure A is the under challenge, my lord. It is a grant land, PTCL land.
My vendor sale deed is of the year 1978, my lords.
You know, annexure A is under challenge, my lord, wherein it is mentioned that it is a grant land. There is a violation of condition. It is mentioned.
What is this annexure A? Endorsement.
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 When was it given?
4/5/2019, my lord.
2019.
Please, my lord. It is mentioned, my lord. There is a violation of condition, my lord. In the grant, it is a PTCL land, my lord. I have to secure that records, my lord. It is mentioned in the endorsement, my lord. Petitioner has not produced the documents, my lord.
No, my lords, how can, my lords, kindly see page number 13, my lords. The typed copy, the shara that
No,
is
the
written.
question is, just by saying this, can you reject the request for mutation?
In the decree also, my lord, which was obtained by the petitioner, my lord, it is a compromise decree, wherein, my lord, government is not a party. The decree which is produced by the petitioner, my lord, it is a compromise decree. There was a suit, my lord, between the parties.
Suit for specific performance, my lords. It was a compromise decree was entered into. It was not agreed. I mean, it was not complied. I have filed execution. Sale deed was executed through appointment of court commissioner.
Junjaya was granted the lands in the year 1974. Please come to the synopsis.
Junjaya was granted the land, my lords. Junjaya,
When?
in the year 1974, sold the property to Ugrappa. I produced that sale deed also. Ugrappa in turn sold the property to Joganna in the year 1978. Thereafter, mutation is effected in favor of Joganna, my lords. Joganna died. In the year 2011, mutation is entered in favor of all the legal representatives of Joganna. The legal representatives of Joganna enter into agreement of sale in favor of the petitioner in the year 2015. I have filed to suit for specific performance in the year 2017. 9/9/2017, the suit is decreed in terms of the compromise. Compromise is not effected. Then I filed execution petition, my lords. 4/9/2018, commissioner was appointed and the sale deed was executed by appointing court commissioner in my favor. I give a representation in the January 2019 to change Kata Pani pursuant to the sale deed. 4/5/2019 is the endorsement that is given, my lords. Annexure A. Page number 13, my lords, the typed copy, the shara that is written. ಶರಾ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ ಪೈಕಿ ನಂಬರ್ ಆಗಿದ್ದು 11ನೇ ಮೋಜಣಿ ನಕ್ಷೆ ಇರುವುದಿಲ್ಲ. ವಿಕ್ರಯದಾರರು ಮಾರಾಟ ಪೂರ್ವ ಸರ್ಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ ಹಾಗೂ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮಗಳ ಉಲ್ಲಂಘನೆ ಆಗಿರುವುದು ಬಾಬ್ತು ಯಥಾಸ್ಥಿತಿ ಉಳಿಸಲು ಕೋರಿದೆ. That is the reason, my lords, have directed me to produce the RTCs and the mutation in favor of the vendors.
Yes.
Page number 2 is the MR, my lords, in favor of the legal representatives of Junjanna, my vendors.
That are 2001 onwards.
Joganna, son of Sarnappa. ಎಲ್ಲ legal representatives ಹೆಸರು.
ಅಲ್ಲ, ಇಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಜೋಗಣ್ಣ ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದಿದ್ದಾರೆ, ಇಲ್ಲಿ ಬೋಗಣ್ಣ ಅಂತ ಬರೆದು. ಇದು 10/10/2011.
10/10/2011.
This is in favor of the legal representatives of Joganna. 2011. You entered into an agreement with them.
Yes, ma'am. Yes, ma'am.
The RTCs are from the year 2001, my lord. RTCs are produced, my lord, which are from 2001 onwards.
So ಈಗಲೂ ಅವರ ಹೆಸರಲ್ಲೇ ಇದೆ.
ಈಗಲೂ 2025-26 also produced.
Yes.
Therefore, my lord, annexure checklist is issued.
Chapter?
Yeah, my lord, page 10.
How can you deny mutation in the name of the petitioner
It was not brought to
on
the
these
notice.
grounds?
Yes, my lord, it was not, I think, my lord, it was not brought to the notice of the authorities, my lord, earlier, my lord. I will secure that grant records, my lord.
Only thing is 11E sketch you'll have to produce.
I will do that. And to that
Huh?
extent, I'll produce it.
Berkeley.
There is no permission for sale. Endorsement, yes, says my lord, annexed.
How can he simply say like this and deny the right of the petitioner to have their names entered in the land records? ಎಲ್ಲಿದೆ ಪವರ್ ಅವ್ರಿಗೆ? At least after issuing such an endorsement, he should have moved the assistant commissioner to initiate suo motu proceedings. ಅದು ಮಾಡಲ್ಲ. ಸುಮ್ನೆ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ಟು ಬಿಟ್ಬಿಡೋದು. It's all right even if the name of the other person is in the land records.
No, my lord, it is.
He is also a purchaser. You don't want to take action.
Therefore, my lord, I will seek time for this reason, my lord, they have produced the artist before 2001, whose name is reflected.
Howdri, mutation was done in the year 2011. Adu in the name of the legal heirs of Joganna. Earlier, his name was entered. Isn't it?
Yes, my lord.
The grievance of the petitioners is in respect of the impugned endorsement at Annexure A issued by the second respondent Tahsildar Sira Taluk, declining to mutate and enter the name of the petitioners in the land records pursuant to the registered sale deed executed through a court of law. Stop. Next para. Learned counsel for the petitioners submits that it is not disputed that one Junjaya was granted 6 acres of land in survey number 64/1 of Huildore village, Bukkapattana Hobli, Sira Taluk. Full stop. The said Junjaya sold the lands in favor of one Ugrappa under registered sale deed dated 16/10/1974. Full stop. Shri Ugrappa sold the same in favor of Shri Joganna on 14/12/1978. Full stop. It is also not denied that the name of Shri Joganna was entered in the land records. Full stop. Pursuant to the death of Shri Joganna, the names of the legal representatives of Shri Joganna was also entered in the land records pursuant to mutation order bearing MR number H8/2011-12 dated 10/10/2011. Allah 15/12/2011. Full stop. The petitioner, Yaro,
AB Manjuna.
he is no more. Huh?
He is no more.
The original writ petitioner, Shri AB Manjunatha, entered into an agreement of sale with the members of the family of Shri Joganna on 17/1/2015. Full stop. When the owners failed to fulfill the terms of the agreement, Shri Manjunatha filed OS number 84 of 2017 on the file of the learned senior civil judge and JMFC at Sira, seeking specific performance of the contract. Full stop. A compromise decree was entered into on 9/9/2017, and the defendants agreed to execute the sale deed in favor of Shri Manjunatha. Full stop. However, when the defendants failed to execute the sale deed, Shri Manjunatha filed an execution petition, and through court directions, the commissioner appointed by the court executed the sale deed in favor of Shri Manjunatha on 4/9/2018, and the same was registered before the jurisdictional sub-registrar. Full stop. Following the execution of the sale deed, the petitioner gave a representation on 29/1/2019 seeking change of kata and entry of his name in the land records. Full stop. The Tahsildar has issued the impugned endorsement at Annexure A, declining to enter the name of the petitioners in the land records on the ground that they have not produced 11E sketch, and that the purchasers did not obtain prior permission at the hands of the government. Full stop. Next para. Learned counsel for the petitioners submits that during the course of these proceedings, Shri Manjunatha passed away and the legal representatives have been brought on record. Full stop. Learned counsel submits that it is beyond the powers of the Tahsildar to have issued such an endorsement declining to register the name of the petitioners in the land records pursuant to registered sale deeds. Full stop. Next para. There is sufficient substance in the submission of the learned counsel for petitioners. Full stop. The Tahsildar could have called upon the petitioners to furnish 11E sketch. Full stop. Other than that, the Tahsildar could not have declined to enter the name of the petitioners on the strength of a registered sale deed. Full stop. If the Tahsildar is of the opinion that the initial sale made on 16/10/1974 at the hands of Junjaya was in contravention of Section 4 of the Karnataka SC/ST (PTCL) Act, 1978, then the only legal recourse that was open for the Tahsildar was to initiate proceedings before the Assistant Commissioner. Full stop. Unless and until a competent authority sets aside the sale as void, the Tahsildar could not have declined to enter the name of the petitioners in the land records. Full stop. Next para. Consequently, the writ petition is allowed. The impugned endorsement at Annexure A is set aside. Full stop. However, the petitioners are directed to ನೀವು ಎಂಟೈರ್ 6 acres ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು, ಎಂಟೈರ್ 6 acres.
ಎಲ್ಲಿ 11E sketch?
Only if I
For
have
what
to,
11 is sketch?
if I have to sell, I'll have
If
to.
it is a part of the survey number,
Yes, ma'am.
then he can ask for 11 sketch. Otherwise, where 11 sketch? The entire land is purchased.
Yes, ma'am.
However, ತೆಗ್ದಾಕ್ಬಿಡು. The
My lord, it is scheduled, my lord, measuring the total survey number, my lord, 64/1, measuring 48.31 acres, my lord. Out of that, my lord, they have purchased the 6 acres.
you know,
My lord, the survey number measures, my lord, totally 48 acres, 31 guntas.
ಯಾವುದು?
64/1.
You know,
64/1 survey number.
The survey number entire.
Lord, now
extent
they
is
have produced the document, my lord,
48,
decree
39.
document.
Yeah.
Along with memo, now they have produced the document of the decree. Page 19, my lord, the schedule is mentioned. Survey number 64/1, my lord, consists 48.31 acres, my lord. Page number 19. Out of that, my lord, they have purchased the 6 acres, my lord.
ಅದೇ ರೀ 6 acres were only granted in favor of Junjaya.
Yes, my lord.
Why have you mentioned this 48 acres, 31
Alla,
guntas?
64/1 entire extent is 48 acres, 39 gunta.
Why have you mentioned that one?
Agri schedule ಅಲ್ಲಿ ಹಾಕಿ.
The land that was granted in favor of Junjaya was only 6 acres.
It was only.
That is what has been transferred
Please. Yes.
3 times. ಬರೋದಿಲ್ಲ.
Uncle.
Since it is pointed out by the learned counsel for petitioners that the extent of land granted in favor of Sri Junjaya was 6 acres and the subsequent sales, including the sale deed in favor of Sri Manjunath, is in respect of 6 acres only, and therefore there was no need for the Tahsildar to seek a 11E sketch. Full stop. ಇದನ್ನ ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಎಲ್ಲರೂ ಸೇರಿಸ್ಕೊಳ್ಳಿ. ನನ್ನ ಕನ್ಕ್ಲೂಷನ್ ಅಲ್ಲಿ ಅದನ್ನೊಂದು ಪ್ಯಾರಾ ಸೇರಿಸ್ಕೊಂಡು, the learned counsel for the petitioners is also right in her submission that since 6 acres of land were transferred by Sri Junjaya in favor of Sri Ugrappa, and the same is now transferred in favor of the petitioners under registered sale deed dated 4/9/2018. There is no need for the petitioners to furnish 11E sketch. Full stop. Lastly, the Tahsildar shall proceed to mutate the names of the petitioners in the land records pursuant to the sale deed dated 4/9/2018 and the affidavit that would be filed by the petitioners seeking joint entry of their names on the strength that they are the legal heirs of late Sri A.P. Manjunatha. Full stop. Next para. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Great.
Number 19.
I'm appearing for the petitioner.
Chandrakanta.
Land reforms matter. In identical matter, my lordship is already granted the interim order. Brother petition ಅಲ್ಲಿ ತಾವೇನೇ interim order ಕೊಟ್ಟಿದ್ದೀರಾ. ಎರಡು ಮ್ಯಾಟರ್ ಇದೆ, ಅದರಲ್ಲಿ ಎರಡರಲ್ಲೂ ತಾವೇ interim order ಕೊಟ್ಟಿದ್ದೀರಾ. ಸೇಮ್ ಆರ್ಡರ್, ಸರ್ವೆ ನಂಬರ್ಗಳು ಮಾತ್ರ ಚೇಂಜ್ ಅಷ್ಟೇನೆ.
ಕಾಪಿ ಇದೆ ಸರ್, ಕಾಪಿ ಇದೆ ಕೊಡ್ತೀನಿ.
ಇವರ ಅಣ್ಣಂದ್ರ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿರೋದು. This writ petition is WP number 10850 of 24.
Same order. Interim order dated 10/4/2024 in WP 10442 of 2024. Yes.
20, Fayaz Saab BG.
Here for petitioner, Lord, I mean, this case, I'm seeking for a week's time, Lord, I'm not keeping well.
Huh?
I'm seeking for a week's time, I'm not keeping well, Lord. Seeking for a week's time.
The respondent number 5 is filing statement of objection. This may kindly be taken out of the file. I have heard the copy.
I challenge the annexure K, page 13/12/2022, Lord, which has been passed by this Tahsildar. I'll address the argument, Lord, not keeping well, there is a throat infection, Lord. Next week, I'll mark. K, page 82, Lord. This is the case with regard to restoration of Pada land. Huh? Restoration of Pada land, Lord. I'll address the argument next date.
Tahsildar ಮುಂದೆ section 15
ಅದು ರಾಂಗ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಅವ್ರು 49 ಅಲ್ಲಿ ಮಾಡೋದು.
49.
ಆಗ ಆಗ್ಬೇಕು.
Is not supposed to do it in 50 ಮಾಡಕ್ ಬರಲ್ಲ ಅವ್ರು. ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Pursuant to the order passed by the Deputy Commissioner wherein remanded the matter to that Tahsildar, he passed that order.
Wrongly passed.
But a petitioner is not an aggrieved person, my lord. If he has the right over the property, even if this writ petition is allowed, petitioner will not get anything.
Who approached the Tahsildar?
Dodrangappa, LRs of Dodrangappa.
Rangappa is the original granting.
Rangappa.
Rangappa is the original granting lord. The land was granted on 26/6/1922. So thereafter, from some time, he has not paid the land revenue.
1922.
1922, 26/6/1922. So far, he has not paid the land revenue. On 21/10/1936, the land has been notified as a Padam lot. So ಅಲ್ಲಿಂದ litigation next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ sir, because of some health ground. Next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
ಆಗ್ಬೋದು, ಅಡ್ಜರ್ಮೆಂಟ್ ನಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಐ ಕ್ಯಾನಾಟ್ ಅಬ್ಜೆಕ್ಟ್ ಆಲ್ಸೋ.
ಈಗ ಅವ್ರು ಹೇಳೋದಂದ್ರೆ ನಾನಲ್ಲ ಲೀಗಲ್ ಹೇರ್ಸ್ ಅಂತ ಹೇಳಿದ್ದೆ, ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಅಲ್ವೇ.
ನಮ್ಮ submission is
even if legal heirs of original grantee, that is
even if this writ petition is allowed, petitioner will not get any relief. If he had a right, he can claim a right prove right through civil court, then he will entitle for the benefit of Pada. Pada set aside ಆದ್ರೆ ಸರ್ಕಾರಕ್ಕೆ ಹೋಗುತ್ತೆ, ಅವ್ರಿಗೂ ಸಿಗಲ್ಲ ನಮಗೂ ಇಲ್ಲ.
ಲೀಗಲ್ ಹೇರ್ಸ್ ಯಾರಿದ್ದಾರೆ ಅವರಿಗೆ ಬರಬೇಕು ಸ್ವಾಮಿ. ಗವರ್ನಮೆಂಟ್
That has to be independently adjudicated. Who is the legal heir?
Who is the legal heirs of original grant? Rangappa, that property has to go to them. I will convince your lordship next week.
Now I have purchased the property, Pada has been restored, I have purchased the property, fifth respondent. Even the petitioner has a right to prove independently.
ಏನಾಗಿದೆ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಗಿ Pada ರೆಸ್ಟೋರ್ ಆಗಿದೆ, ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಬರುತ್ತೆ ಎಸಿಗೆ 49 ಕೆಳಗಡೆ. They can file appeal before the AC, but ಅದರಲ್ಲಿ ಏನು ಅವ್ರಿಗೆ ಲಾಭ ಇಲ್ಲ. They have to prove their right over the property.
Next week I will convince your lordship because that Pada is.
At the request of learned counsel for the petitioner, Rama released this matter on 12th of August.
21, Ajit PB.
Not so happy for the petition.
Confirming of report.
My lord, in this writ petition, I have challenged annexure L at page 40. My lord, the land is a grant land, my lord.
For cancellation of kata in respect of other persons.
Other persons, negative parity has
Here
been
is-
sought
what
by
is
this
this?
person.
My lord,
Now, my lord,
this-
the contention that was taken by the Tehsil of a cancellation was that the prohibited limits of 5 kilometers from the CMC limits.
Huh?
5 kilometers from the CMC limits on the day of the application cannot be granted under 108. ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಬೇರೆಯವ್ರದೆಲ್ಲ ನೀವು ಖಾತೆ
What, when was it granted?
My lord, it was granted in the,
6/8/1997
my first application,
was rejected.
no, I made an application in the year 1991, my lord.
Yes.
And the land was granted in the year 2019. The grant certificate is at page 32,
Sir,
annexed
please come to the list of dates.
list of dates.
You yourself are written 6/8/1997. What is this?
My lord, first I filed
Rejected the application.
please. Then it went up till AC.
You filed an appeal.
Appeal.
Ah.
Appeal agi, ನಂತರ it got remanded, my lord. The matter got remanded back.
Rejected on what ground?
It was rejected on the ground that it's a forest land. Tahsildar rejected on the ground that the entire land is a forest land. Anta. Then, my lord, my application was placed before the committee
Which committee?
seeking this unauthorized occupation of the land ant heli.
Ah.
I filed an application seeking Saguvali chit. My lord, my application was considered, and in the year 2019, the land was granted in my favor. 2019. Date of application was, my lords, 1991. The land was granted in the year 2019. Grant certificate I have annexed, my lord. Now, my lord, this land was granted on the basis of the report filed by the surveyor, which is at page number 27. It has a typed copy at page number 28, my lord, in which the surveyor says, Kasaba Hobali Indavara Grama, survey number 32 ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಬಾಪ್ತು ಸಾಗುವಳಿ ಜಮೀನಿಗೆ ಇರುವ ದೂರದ ಮಾಹಿತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಟಿಟಿ ಅರ್ಜಿ ಸೋ ದಿನಾಂಕ 12/7/1991 ಮೇರೆಗೆ ಅರ್ಜಿದಾರರ ಶ್ರೀ IS ಚಂದ್ರಶೇಖರ್ ಅವರು ಜಮೀನು ನಗರಸಭಾ ವ್ಯಾಪ್ತಿಯಿಂದ ಬಳಕೆ ರಸ್ತೆಯ ಮೂಲಕ 5 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿರುತ್ತೆ. Since there is a bar under
right position.
Please, my lord.
He has rightly said, having regard to the application filed in the year 1991.
Correct.
It is beyond 5 kilometers and therefore it can be granted.
Now, my lord.
What is wrong in this?
Now, my lord, the argument is being advanced by their side is that now they are saying the distance has changed. They are measuring it through aerial view and it comes within 5 kilometers. It's a settled position of law that the distance should be calculated as on the date of filing application.
Correct.
Not the present one, my lord.
Correct.
So on this basis,
this statement made by the surveyor is correct.
Please.
Having regard to the year in which the application was filed, 1991, he has considered what was the geographical jurisdiction of the municipality.
ರಸ್ತೆ ಮೂಲಕ 5 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇರುತ್ತದೆ.
ಹೌದು.
From the road, it is 5 kilometers.
Yes.
So within 5 kilometers ಬಂದಿದೆ ಅಂತ ಅವರು ಹೇಳ್ತಾರೆ. That is the contention that is taken. Even in this one also, on the last date of hearing, the lordship could kindly see 2 affidavits have been filed by the Tehsildar in this matter. Regarding that thing, and on the daily orders also, my lord, the learned friend said that wherever khate madidare, they have not initiated any action anta. And the court said, kindly produce all the documents that.
ಅವರಿಗೆ ಯಾವಾಗ grant ಆಗಿರೋದು ಅವರಿಗೆಲ್ಲ?
My lord, kindly see page 41. I have produced their RTCs, my lord. ಇವರೆಲ್ಲ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ adjacent owners, land owners.
41.
Page 41, my lord, annexure M.
One of the documents that you have given now.
My lords, that documents is
not that.
The petition. In the
petition.
In the main petition. ಅವ್ರು ಹಾಕಿರೋದು.
Similarly placed grant is, my lord, same survey number. They have issued RTC. Siddhaya Shantamma.
Now presently, my lord, we have initiated action against them also under 108K. All.
ಅನ್ಯಾಯವಾಗಿ ಅವ್ರ ಮೇಲೂ ನೀವು ಆಕ್ಷನ್ ತಗೋತಾ ಇದ್ದೀರಾ. What is this?
The direction of this court was that.
That is because your learned AG made that statement. That is not correct.
Anyway, my lord,
ಅವ್ರಿಗೆ when was the grants made in their favor?
2017.
ಎಲ್ಲ ಸೇಮ್
17 or 19, my lords. In my case, it's
17, 19.
they are 17, he is 2019.
Applications were filed in the year 1991.
1991. Now, my lords, kindly see the order dated, my lords, 5/3/2025. When this court said that on what basis you have issued the grant certificate to similarly placed grantees, then they initiated one not
ಅದೇ, that was not necessary at all.
Anyway, my lord, the learned AG is very busy. He will only come on this matter. He was argued the matter on the last date of hearing. Anyway, I am placing the memo before the honorable.
These are all covered matters. That Ashwatthappa.
Anyway, my lord, lordship may have it after 2 days. We'll keep him present. Then the court can pass appropriate orders.
ಯಾವ ಮುನ್ಸಿಪಾಲಿಟಿ ಇದು?
ಇದು
Chikmagalur,
CMC.
ಹಾ?
Chikmagalur Municipal Corporation.
ಬರ್ಕೊಳ್ಳಿ. Having regard to Annexure D, comma, information given by the surveyor comma, it is clear that having regard to the applications filed by the petitioner in the year 1991, comma, the distance between the lands in question and the boundary of the city municipal council Chikmagalur was more than 5 kilometers. Full stop. If the authorities are now seeking to contend that the distance is less than 5 kilometers, comma, such statement cannot be accepted. Comma, unless the distance measured would be in terms of the geographical jurisdiction of the then municipality in the year 1991. Full stop. This court has held in the case of Shri Ashwatthappa versus Kodriyadu. Ashwatthappa and others versus State of Karnataka and others in WP number 2411 of 2022, dated 18th of February 2022, that the distance has to be measured having regard to the geographical jurisdiction of the local authority at the relevant point of time when the applications were filed. Full stop. Next para. The first respondent, Tahsildar, is directed to file an affidavit as to the geographical jurisdiction of the then municipality, Chikmagalur, as in the year 1991. Full stop. The Tahsildar shall also state as to whether the distance between the lands in question and the boundary of the municipality would be less than 5 kilometers or more than 5 kilometers. Taking into consideration the geographical boundary jurisdiction and boundary of the then municipality as in the year 1991. Full stop. Next para. The notices issued by the Tahsildar pursuant to the observations made by this court on 22/7/2025 shall not be proceeded with any further. Release this matter on 18th of August.
But tomorrow is the date fixed in the.
That is why I am saying, please don't proceed. ಅದಕ್ಕೆ ಮುಂಚೆ learned AGA has filed a memo along with certain documents, and the learned AGA submits that the same is in compliance with the observations made by this court on 22/7/2025. Yes.
Correct. Student number 22, Basanta AK.
Appear for the petitions. Last date of hearing, this honorable court viewed that the approval of the Pharmacy Council of India is there or not. I am furnishing the entire documents along with the memo before this honorable court. It is approved for the year 2024-25, page number 2. Document.
Senate Council for the petitioner has filed a memo along with certain documents. Full stop. Copy of the same is served on the learned council for respondent number 1 and the learned AGA. Full stop. Next para. Learned council for the petitioner submits that document number 1 is
A approval
the approval granted by the Pharmacy Council of India
for the year 2024-25.
granting approval to the petitioner institution for the year 2024-25.
Please, my lord.
Yes, what do you say?
One for advocate for the year 23-24. The approval is there for 24 and 24.
My lord, my submission, each and every year renewal should be taking place. 2016 academic year. From the 2016, each and every year we have taken the approval, my lord.
The approval which have produced is for 24 and 25. Approval up to 24 and 25. Admission is made on 23-24.
My lord, document number 2, page number 3.
It is actually extension of the approval.
No,
We see in the said document itself. D Pharma extend approval up to 2024-25.
my lord,
It's extension.
page number 3 also.
Earlier also it was granted.
Page number 3 is specific, my lord.
What is the grievance?
For 7 students, they have not given the hall ticket. Out of 7 students, petitions number 6 to 8, we are not pressing. To that effect, I am filing the memo. Only with respect to petitioner number 2 to 5. But now examinations already started 30th. That being the fact, next academic, this education examination, they have to be allowed.
I have filed my statement of objection saying that those candidates have failed to produce the relevant required documents.
My lord, page number 4.
That's why their name has not been.
We'll continue at 2:30.
Yes.
My lord, my one submission, my lord. Some inconvenience is there. It may be taken up next week, my lord. I will make it. Please, my lord.
ಇದು ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು already recorded, isn't it?
Other documents also, my learned sister made the observation in page number 4. Entire details have been given.
ಏನಿದು?
That is with respect to, we are not pressing the petitioner number 6 to 8.
Learned counsel for the petitioners has also filed a memo stating that the petition in respect of response number 6 to 8 may be permitted to be withdrawn.
The petitioner's number.
6 to 8.
Please, my lord.
Full stop. Next para. Release this matter on, when do you want?
Next week, the same day, my lord.
12th.
12th, my lord.
All right. 12th of August.
Grateful to this.
May I make a submission? Sir, some urgency in this matter, my lords, for tomorrow. Demolition order has been passed against me, my lords. I'm occupying a Kumki land, my lords. Demolition order has been passed for tomorrow.
Please move it tomorrow.
ಹಾಕಿದ್ದೀರಿ ಅಲ್ಲ ಹೇಳಿ ಎಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಮುಂಚೆ ನೋಡಿ ಎಲ್ಲ ಹಾಕಿದ್ದೀವಿ.
ಸರ್ ಕೊಟ್ಟಿದ್ರೆ ಅವ್ರು ಅದೇ ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ನಾವು 52 ಜನ ಇವ್ರ ಮೇಲೆ ನಮ್ಗೇನು
ನೋಡಿ ಇಲ್ಲಿದೆ
ಇನ್ನೊಬ್ರಿಗೆ ಏನ್ ಸರ್
ನೋಡಿ ಇಲ್ಲಿದೆ
ಪಾಸ್ವರ್ಡ್ ತುಂಬಾ ಇದೆಯಾ?
ಇಲ್ಲಿದೆ ತಗೊಂಡಿರೋದು ಇದೆ
ಒರಿಜಿನಲ್
ಹೌದು ಎಲ್ಲ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡಿ ತಗೊಂಡಿರೋದು ಇದೆ.
ಇಬ್ಬರಿಗೆ
ಅಲ್ಲ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೇವೆ ನೋಡಿ ಎಲ್ಲರದ್ದು ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದೆ 4 ಸ್ಟೂಡೆಂಟ್ಸ್
ಬೆಳಗ್ಗೆಯಿಂದ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
4 ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದೆ
ಈ 4 ಸ್ಟೂಡೆಂಟ್ಸ್
ಈ 4 ಸ್ಟೂಡೆಂಟ್ಸ್ ನಾವು ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
ಕೊಟ್ಟಿದ ಮೇಲೆ ಪ್ರಾಕ್ಟಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೊಡ್ತಾರೆ, ಪ್ರಾಕ್ಟಿಕಲ್ ರಿಸಲ್ಟ್ಸ್ ಕೊಡ್ತಾರೆ ಮೇಡಮ್. ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
ನಮ್ಮ ಕಂಟೆನ್ಷನ್ ಅಷ್ಟೇ
ಪ್ರಾಕ್ಟಿಕಲ್
Serial number 88, Abhishek Marle, MJ.
For petitioner's minutes. Lords, petitioner has challenged the annexure A, my lords. I have engaged service of senior counsel, my lords, is coming. I have engaged the senior counsel, my lords, in this matter. Annexure A has been challenged, my lords. My lords, petitioner's father was a owner of large extent of lands, my lords. In that, my lords, as per annexure B, my lords, that page number, the lands were granted, my lords, at annexure page number 18. In that, my lords, 36-2A, 1 acre 45 cents and 36-2AP, that is 20 cents was granted, my lords. It was written 90, but it was corrected as 20, my lords. Later, and annexure C is the statement given, my lords, of the, my lords. Leave may be granted, my lords. I have engaged the senior counsel.
Yes.
Lords, the order is to be set aside only on the ground of issue estoppel because an application was made. Lords, if your lordships were to see the application at page number 19, though it was mentioned as
19.
19. Yes. Lords, two extents are there in survey number 36/2AP. P is Paiki. 1 acre 45 cents. The other one is actually 20 cents. 90 is struck off and 20 is written. Now, if your lordships were to see at page number 20, the statement given by Girija, last 3 lines. I produced a typed copy also. This is Tiruvalai 35/1, 16 gunte, 36/2A, 1 acre 45 cent to 20 cent. Our statement kottirodu. Typed copy is also there. The dispute is only about this 20 cents, whether it is 20 cents or 90 cents. Ishte dispute.
Yaudado survey number?
Survey number 36/2A.
2AP.
ಅದು 2A ಅಂದ್ರೆ 2A ಪೈಕಿ ಅಂತ ಅದು 2A ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು 1 acre 45 cents ಮತ್ತೆ 20 cents ಗೆ. ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು 1 acre 45 cents ಮತ್ತೆ 20 cents ಗೆ. Then form number 10 is at page number 24. Order is also for 1 acre 45 cents. ಅದರಲ್ಲಿ 3ನೇ ಎಂಟ್ರಿ 4ನೇ ಎಂಟ್ರಿ. ತಿರುವೈಲೂನಲ್ಲಿ 36/2AP 145 20. So ಇದನ್ನ ಏನ್ ಮಾಡಿದ್ರು, they made an application seeking rectification from 20 cents to 90 cents before the land tribunal, which is at page number 35. ಅದರಲ್ಲಿ page 37.
Application is filed by
this Girija.
That is
applicant. That is form 7 applicant. This application at 35, at page 37, ಅದರಲ್ಲಿ ಒಂದು ಟ್ಯಾಬ್ಯುಲೇಟೆಡ್ ಕಾಲಮ್ ತರ ಕೊಟ್ಟಿದ್ದಾರೆ. ತಿರುವೈಲು ವಿಲೇಜ್ ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಎಂಟ್ರಿ 36/2A ಈಗಾಗಲೇ ಮಂಜೂರಾತಿ ನೀಡಿರುವ ವಿಸ್ತೀರ್ಣ 165, 1 acre 65 cents ಅಂದ್ರೆ 1 acre 45 cents plus 20 cents, 1 acre 65 cents. ಪರಿಷ್ಕೃತ ಆದೇಶ ನೀಡಬೇಕಾದ ವಿಸ್ತೀರ್ಣ 2 acre 60 cents. Andre 20 cents, they wanted it to be increased to 90 cents. This was rejected at page number 38. I'm sorry, this was granted, page number 38. At page number 39, this rectification was granted. This was against a dead person. Now kindly have a look at page number 40, your lordship's order. Notice this at page number 46 is very relevant.
Because now the question is how much cost should be imposed on them. Page number 46, para 6. We have pointed question put by the court. Learned counsel for the petitioner submitted on instructions that petitioners give up their claim in respect of the application made at the hands of Srimati Girija on 11/10/1996. In other words, it is submitted that the petitioners confer their claims in respect of the original order dated 23/7/1981. After holding this, after this is recorded, notice your lordships at page number 50, recording a finding that it would not be permissible for the land tribunal to undertake this exercise, set aside this order. Petitioners were those who were claiming under Girija. If your lordships were to see page number 40, Ali Sadananda, son of Girija, Devaki Girija, Uralla, they are children of Girija. They made a statement, no, this order was set aside, saying that it is restricted only to the order of 1981, which is 145 and 20 cents. This order has become final. Then, by suppressing all these facts, they go before the learned single judge at page number 53.
The writ petition is allowed in part.
Now what they say is, what I have been given in 36/2AP is 90 cents and not 60 cents. Adhan ellide andre prayer nallide. Page 54, last line. Direct the R3 to effect khata in the name of petitioners in respect of 36/2P measuring 90 acres, that is 90 cents of Thiruvalli village, Bangalore, Taluk, Bangalore, so and so. Order final ಆಯ್ತು. ನಾವು ಆ ಕ್ಲೈಮೇ ಮಾಡೋದಿಲ್ಲ ಅದನ್ನ ಅಂತ ಹೇಳಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ. ಅದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡಿ ದೇ ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ವಿತೌಟ್ ಮೇಕಿಂಗ್ ಅಸ್ as parties. Earlier litigation was then
call for the records from respondent number 3 pertaining to endorsement.
Yes, there is an endorsement issued. They have challenged that endorsement. Then the learned single judge directs me not that you enter the name of Girija in the revenue records, because the endorsement is being set aside. Notice this is the representation which we give at page number 66. Notice we have no notice, nothing. If your lordships were to see page number 57, annexure J, which is the RTC. Notice 145. Sadanand ಅವರ ಹೆಸರಲ್ಲಿ 9 ಸೆಂಟ್ ಇದೆ ಅಲ್ವಾ? 9 cents. ಅದರೊಳಗೆ 9 ಸೆಂಟ್ ಇದೆ, ಎರಡನೇ ಎಂಟ್ರಿ. 11 cents was to be entered in their name pursuant to form number 10. So that is what they could have asked for. Rest of the entries is standing in the name of the present petitioners. Now if your lordships were to see, we gave a representation at page number 66.
What is referred to in that endorsement?
Annexure in the endorsement before the coordinate bench, my lords. Notes, they give a representation.
Annexure R9, my lord.
R9.
R9.
R9, in my statement of objections, page 85. Page 85 of my statement of.
ಅದರಲ್ಲಿ representation ಏನು ಅಂತಂದ್ರೆ, if your lordships were to see the first paragraph at annexure R9, ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಂತೆ ಮಂಜೂರಾದ ಜಮೀನಿಗೆ ಪಹಣಿ ದಾಖಲಾತಿ ಕೋರಿ ಉಲ್ಲೇಖ 1ರಂತೆ ನೀವು ಅರ್ಜಿ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತೀರಿ. ಉಲ್ಲೇಖ 2ರಂತೆ ಉಪತಹಸೀಲ್ದಾರ್ ಗುರುಪುರ ನಾಡ್ ಕಚೇರಿ ಇವರು ತನಿಖಾ ವರದಿ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಮಂಗಳೂರು ತಾಲೂಕು ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ ಸಂಖ್ಯೆ 81ರಂತೆ ಗಿರಿಜಾ ಹೆಸರಲ್ಲಿ ತಿರುವೈಲಾ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 26/2P ಯಲ್ಲಿ 90 ಸೆಂಟ್ಸ್ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೂಡ ಅವರಿಗೆ ಹಕ್ಕು ಲಭ್ಯವಾಗಿದ್ದು, ಗಿರಿಜಾರವರು ಮೃತಪಟ್ಟ ಕಾರಣ ವಾರಸುದಾರರ ಹೆಸರಲ್ಲಿ ದಾಖಲಿಸಬಹುದು.
ಯಾವುದು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ
ಅದು ನಮಗೂ ಗೊತ್ತಿಲ್ಲ.
2 occasions, my lord. 1981 has been confirmed by this honorable court at R4 page 22 in WP 35794 of
2013 dated 1/8/2018. Number? WP 35794.
Page 22, my lords.
22 annexure R4, my lord.
Page 22.
In that, my lord, I request my lords for a moment to take page 29, wherein the honorable court has extracted the land granted in my favor. 90 cents another 23/7/1981 nalli ide. It has not been striked out at any point of time as stating by learned senior counsel.
Page 20, my lords.
Annexure.
Page 30 in that order. My lords, that is paragraph number, adeshtu para number? 29 bottom alli.
29 ಅಲ್ಲಿ ಅದಾದ್ಮೇಲೆ ಅಲ್ಲೇ ಇದೆ ಸುಮ್ಮನೆ ತಿರುವೈಲ್ವೇಲ್ ವಿಲೇಜ್ fourth in that tabular 36.
This is in respect of the original order passed.
Original order passed. Lords, then kindly have a look at page number 30. What is the order granted?
Finish his argument, I will address that.
I'll kindly have a look at page number 30. Thereafter, on the application made by Girija, mother of respondent 3 to 7, impugned order dated 2/12/1998 was made by the tribunal modifying the order of 1981 so far as survey numbers and extents are concerned, which is extracted as under 36 part 2A, 36 part 2A, 1 acre 45 cents and 20 cents. According to the learned counsel for the petitioner, occupancy rights in respect of 1 acre 99 cents in excess of what is sought for by Girija is granted by the land tribunal pursuant to order of 98 by way of modification order of 98.
One nimsha. That tabular column.
Yes.
Left hand, as per prior judgment dated 23/7/1981 of land
ಇದರೊಳಗೆ
tribunal.
ಈ 90 cents ಅಂತ ಏನ್ ಹೇಳ್ತಿದಾರೆ ಅದಕ್ಕೇನು ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ. That is a mistake. ಅದಕ್ಕೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಫಾರ್ಮ್ ನಂಬರ್ 10 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. That is not in dispute. They have not disputed the form number 10 produced by me in their statement of objections.
Allah, modified order is that 2/12/1998.
Correct.
The same which was brought to my notice.
Yes.
That is
No, that is
23/7/1981.
Yes. No.
1981 ಆದ್ಮೇಲೆ she filed an application.
1981 order stands still, my lord. This honorable court in WP 356794 has confirmed occupancy rights granted on 23/7/1981. This 90 cents is mentioned on 23/7/1981 only. Thereafter, some extents were not been granted. Hence, a modification application has been filed.
Yes.
At the time of modification of the order, the original father of the petitioner was died. Hence, this honorable court remanded only to the extent of considering the modification order, not the order of 23/7/1981.
If your lordships were to see page 39, my lords, of the writ petition papers, that will clarify. ನಾನು ಮುಗಿಸ್ಕೋತೀನಿ. Page 39, my lords, of the writ petition papers, this will clarify what your lordships asked for.
39
of the writ petition papers.
Modification.
There they have unequivocally said we are not pressing on that application.
Correct.
This court recorded it.
Yes. And my lords, kindly have a look at page. No, I am referring to the order which is dated 2/12/1998. At page 38 it starts. My lord, this is on the application filed seeking rectification from 20 cents to 90 cents.
Correct.
On this, the order is at page 38.
Correct. They allowed the application.
Lords, kindly have a look at page 39, lords. ಈ ಹಿಂದಿನ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಇದೇ ಸಮ ಸಂಖ್ಯೆಯ ದಿನಾಂಕ 1681 ಆದೇಶದಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ನೀಡಲಾಗಿರುವ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಹಾಗೂ ವಿಸ್ತೀರ್ಣದ ತಿದ್ದುಪಡಿಯನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಈ ಹಿಂದಿನ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ತಿದ್ದುಪಡಿ ದಿನಾಂಕ 16 ಸರ್ವೆ ನಂಬರ್ 32A ಅದನ್ನ 2A ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 321 2A ಪೈಕಿ 23 ಸೆಂಟು ಮಾಡಿದ್ದಾರೆ. 321 + 23 ಮಾಡಿದ್ರು. ಅದನ್ನ ತಿದ್ದುಪಡಿ. ಉಳಿದ ಸರ್ವೆ ನಂಬರ್ಗಳ ಜಮೀನು ಯಾವುದೇ ಬದಲಾವಣೆ ಇರುವುದಿಲ್ಲ. ಆದೇಶವನ್ನು ಸೋಣಿಸು. Now your lordships may kindly see the order passed by the coordinate bench at page 22 annexure R4.
One nimsha. I am at page number 39 only.
That order has been quashed by the hands of this honorable court.
Modification you asked for was only in respect of 36(2A na.
36 ಎಲ್ಲ ಕೇಳಿದ್ರು. But the present subject matter is only 36(2A. ಅದರಲ್ಲಿ ಆ tabulated column ಅಲ್ಲಿ second line from the bottom 36/2A first one ಹೇಳಿದ್ದಾರೆ. 36(2A ಪೈಕಿ 20 ಸೆಂಟ್ ಇದೆ.
ಅದನ್ನ ಬಾಟಮ್ ಇನ್ ದ ರೈಟ್ ಸೈಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ 36/2A ಪೈಕಿ 90 cents ಮಾಡಿದ್ರು, ತಿದ್ದುಪಡಿ ಮಾಡಿದ್ರು. Now your lordships may kindly see, lords, the order at page 22 annexure R4.
This is modification dated?
This is the modification 2/12/1998.
2/12/1998.
Yes. This order is set aside. At page number 43.
Therefore, the impugned order dated 2/12/1998 is liable to be quashed.
Yes.
As it is a nullity and it is in violation of principles of natural justice.
Because it was filed against a dead person. Lords, even this order of the learned single judge stood confirmed, affirmed in appeal. Lords, now comes the litigation, my lords, at page number 40 of the writ petition papers. After this order. Your lordships will kindly see what has been challenged in this 6/7/22. Lords, page 42.
That writ petition.
WP 14613 of 22 is challenging the order dated 6/7/22.
Annexure R4.
Yes.
The writ petition filed by Mario Perez.
That's the petitioner.
That writ petition was allowed.
That writ petition was allowed.
Partly allowed, my lord.
It was remanded back. Lords, it was held as a nullity and it was remanded back. That order was confirmed even by the division bench.
Who filed appeal?
Appeal was filed by the petitioner only, Mario Perez Bhatt.
Why?
So, my lords, he wanted the entire order to be set aside, not an order of remand. So that remand order was upheld by, my lords, by the division bench. After the remand, an order is passed on 6/7/22. Lord, 6/7/22 order is challenged before your lordships, which is at page number 40, WP number 14613 of 22.
You produced matter of the page number 60.
Page number 60. This is the order. This order was challenged before your lordships.
Relevant portion in page paragraph 11, my lord, page 73.
One minute.
ತಿರುವೈಲ್ 20 cents ನ ರಿಟೈನ್ ಮಾಡಿದ್ರು ರಿಮ್ಯಾಂಡ್ ಆದ್ಮೇಲೆ. ಪೇಜ್ 60 ಬಾಟಮ್ ಆಫ್ ದ ಪೇಜ್.
23/7/1989 ಆದೇಶದಂತೆ ಮಂಜೂರು ಮಾಡುವುದನ್ನು
ಕಾಯಂಗೊಳಿಸಿದೆ ಮತ್ತು ಶೆಡ್ಯೂಲ್ ಬಿ ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಬೂಡಂತಿಲ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಜಮೀನುಗಳು ಪೂಂಜಾ ಜಮೀನುಗಳಾಗಿರುವುದರಿಂದ ಸದರಿ ನಂಬರ್ಗಳ ಬಾಬ್ತು ಅರ್ಜಿದಾರರು ಬರೆದುಕೊಂಡಿರುವ ನಮೂನೆಗಳು ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲು ಸರ್ವಾನುಮತದಿಂದ ಆದೇಶಿಸಲಾಗಿದೆ. ಹಾಗೂ ದಿನಾಂಕ 11/10/96 ಅರ್ಜಿದಾರರು ತಿದ್ದುಪಡಿ ಕೋರಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. So their application was rejected.
Yes.
So Girija's LRs came before your lordships.
Correct.
Having come before your lordships, what they did, they made a categorical statement saying that we will not press that application and we will go by the order of 1981.
Yes.
And it is in this background, if your lordships were to see the operative portion of the order, my lords, because there were two portions in the order. One is pertaining to Thiruvail village, where they confirmed that we are not pressing on that. That is what is recorded by your lordships at paragraph number 6. Now, so far as the other village is concerned, if your lordships were to see at page 52, there are two portions in the order. Adralli enayitu andre avrdu innondu village ge form number 7 reject madibitru. Then your lordships asked them whether you are pressing on that application so that 1981 order could be maintained. They said that all right, we are not pressing on that modification application. Therefore, what your lordships did was, your lordships set aside the order of 6/7/2022, so that their 1981 order is restored in their favor. Their application is rejected. That is what is observed at page 52.
Yes.
Consequently, 11/10/1996 is rejected. That is that rectification which they sought for. Page 50. Now, after this, they filed this writ petition, second writ petition, saying that we are entitled for 90 cents.
Again,
This is the writ petition, page number 53. They have not disclosed the fact before this honorable court.
they didn't make you parties.
They did not make us parties. They did not disclose these facts that these proceedings had come to a closure. They also did not disclose the fact that this honorable court pointedly asked them a question, and they conceded that they are not pressing the application of the year 1996 seeking rectification. But they again come before the court. It's a daring raid, my lords, on this honorable court, saying that whatever might have happened, we will tell lies and again come before the court. This honorable court, my lords, was made to understand that 90 cents was granted, my lords, in 1981, and therefore directed that entry should be made in their name.
For a moment, I request my lords to take annexure R1, page 14, that is the original grant order dated 23/7/81. This is what, which is confirmed by my lords. In page 15, my lord, both the villages are there. Tiruvalvale as well as Bondantila. Tiruvalvale, survey number 35 1P, 18 kuntas, 1P, 1 acre 52 kuntas, 2AP, 1 acre 45, 36 2AP, 90 cents.
20 cents.
It is not 20 cents. It has not been modified or not been altered at any point of time. That is 90 cents, my lord. That is, if there is an order, let my senior advocate produce before this honorable court to establish that it is 20 cents. It is not 10 cents.
Then why did you file the application for modification?
Modification ಬೇರೆ ಎಲ್ಲದಕ್ಕೂ ಹಾಕಿದ್ರು. ಅಲ್ಲಿ ಬರ್ತೀನಿ ಸ್ವಾಮಿ. Next, my lord, ಅವರೇ ಹಾಕಿದ್ದಾರೆ application. I request, sorry for inconvenience for my lordship. In annexure E, my lord, that is the application for modification order, page 36. For a moment, may be kindly seen, my lord.
36 of
annexure E, writ petition, my lord. Page 36. In addition to this, ನಾನು original ಅದರಲ್ಲಿ first column declaration ante ಅಪೇಕ್ಷಿಸಿದ ಕ್ಷೇತ್ರ, that is my original application. 36 2AP 2 acre 60 guntas, 1 acre 45 and 20 has been granted. My original application is that this is not for modification. Original application is 2 acre 60 guntas. Hence, the tribunal on order dated 23/7/91 has granted 1 acre 45 guntas and 90 cents in 36 2AP. This was challenged by my learned friend in WP 35794 annexure R4. For a moment, I request my lords to kindly take para 10, page 41, my lord. Adರಲ್ಲಿ page 29 ಅಲ್ಲಿ my lordships has been extracted the extent which I am granted in order dated 23/7/1981, page 29 ali. In page 8, page 29, statement of objections. Tiruvalvale 35 1P, 35 1P 1 acre 52, 36 2AP 1 acre 45, 36 2AP 90 cents. This has been confirmed. For a moment, I request page 41, para 10. Entire order has not been remanded. Para 10 soon. Page number 41. The aforesaid decisions are square.
One nimsha. After this page number 29,
Please,
you showed that tabular column saying 1 acre 45 cents
plus
90 cents.
Please.
Thereafter, please read the
Next tabulated
next
column.
sentence.
At this stage, it may be mentioned that petitioner's father died on 24/2/1987, which is evident from annexure D, death certificate. Thereafter, on the application made by Girija, mother of respondent 327, impugned order dated 2/12/1998 was made by the tribunal, modifying order dated 23/7/1981 insofar as survey numbers, extents of lands are concerned, which are extracted under. Since this petition has been filed after lapse of 30 years, ಅದಕ್ಕೆ para 10 ಬಂದ್ಬಿಡಿ ಸ್ವಾಮಿ. This honorable court, the aforesaid decisions.
That tabulated column.
Please don't run. Please. Although it is stated in the previous tabular column that it is seen that 90 cents is granted. Thereafter, you filed an application seeking modification. Huh? And in that column, as per prior judgment dated 23/7/1981, please see what is the extension.
36-2A 3 acre 21 guntas, 36-2A 23 guntas.
Huh?
36 right side ಮೇಲೆ
ಯಾವುದು ಅಲ್ರಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಓದಿದ್ರಿ ಮೊದಲು.
as prior judgment 36-2A 1 acre 45, 36-2A 20 ಅಂತ ಅವ್ರು ಬರ್ದಿರೋದು. ಆದ್ರೆ 1980
because of that you filed an application seeking modification.
ಅಲ್ಲ 1981 ಆರ್ಡರ್ ಅಲ್ಲಿ 90 cents
ಈ ಆರ್ಡರ್ ಅಲ್ಲೇ ಇದೆ.
ಅಲ್ಲ ನನ್ನ ಎಕ್ಸ್ಟೆಂಟ್ ಇನ್ನೂ ಜಾಸ್ತಿ ಇತ್ತು ಅಂತ ನಾನು ಹಾಕಿದ್ದು. ನನ್ನ ಎಕ್ಸ್ಟೆಂಟ್ ಇನ್ನೂ ಜಾಸ್ತಿ ಇತ್ತು ಅಂತ ಅನೆಕ್ಸ್ಚರ್ ಡಿ ಡಿಕ್ಲರೇಷನ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಶೋಡ್ ಮೈ ಲಾಟ್ ನಾನು ಇನ್ನೂ ಜಾಸ್ತಿ
ಅದಕ್ಕೆ 2 acres 60 cents is the original claim.
ಹೌದು
ಹೌದಾ?
ಹೌದು ಹೌದು.
ಈಗ 1 acre 45 cents.
ಹೌದು
1 acre 45 cents plus 90 cents ಎಷ್ಟಾಯ್ತು?
190 235 ಆಗುತ್ತೆ.
235. What was granted even according to you is 1 acre 45 cents. 1 acre 45 cents and 20 cents.
90.
In the second tabular column, in the left hand side, what you have shown is that it was corrected as 20 cents. And therefore you made an application seeking modification as 90 cents and that application was allowed.
ಅಲ್ಲ ನಾವು 90 cents ಗೆ ಅಂತ ಕೇಳಿಲ್ಲ, ಅಲ್ಲಿ ಇದ್ರಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ ಅಪ್ಲಿಕೇಶನ್. ಒರಿಜಿನಲ್ ಡಿಕ್ಲರೇಷನ್ ನಾನು ಕೇಳಿದ್ದೆ 2 acre 60 ಗುಂಟ.
Correct.
That has been confirmed 23/7/1981. Order has been categorically confirmed by this honorable court for 90 cents.
ಎಲ್ಲಿ ಯಾವ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಇದು ಪೇಜ್ 20 para 10 ಮೇಲೆ ಇದೆ ಆರ್ಡರ್ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ R4 ಅಲ್ಲಿ 1981 ಆರ್ಡರ್ has been confirmed by this honorable court. Page 41 para 10. Page 41 para 10. The aforesaid decisions are squarely applicable to the instant case having regard to the facts of the present case. Therefore, the challenge made to the order dated 23/7/1981 is rejected on the ground of delay and lapses. Hence, it has been confirmed. Now, ಇದು 1981 90 cents confirm ಆಯ್ತು ಸ್ವಾಮಿ. Now, this honorable court remanded only to the matter to the extent to consider modification order na consider ಮಾಡಿ ಇದು right or wrong ಅಂತ, not in respect of order dated 23/7/1981. Para 15 page 43.
What do you say about page number 9?
ಅಲ್ಲ ಒರಿಜಿನಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೇ ನಾನು 90 cents ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Correct. Then why did you file the application for modification?
ಅಲ್ಲ ಈ ಬೇರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಎಲ್ಲಾನು ಇದೆ ಅಂತ my lords may kindly
ರೀ ಇದನ್ನು ಸೇರಿಸಿದ್ರಲ್ರಿ ಅದ್ರಲ್ಲಿ?
ಇದನ್ನು ಸೇರಿಸಿದ್ದೀನಿ ಸ್ವಾಮಿ. My original application is
where was the need for you to ask for modification in respect
ಬೇರೆ
of
ಇದ್ರಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ
36? We are confined only with this survey number.
For a moment, my lord, my original application
If according to 90 cents were granted, 1 acre 45 cents and 90 cents were granted.
Please, my lord.
What is the modification that you sought?
ಅಲ್ಲ ನಾನು ಕೇಳಿದ್ದು 2 acre 60 ಗುಂಟಾಸ್. 260 cents. 2 acre 60 cents in my original application.
That has been noted by the tribunal. But what was granted to you? 1 acre 45 cents and 20 cents.
90 20 ಅಂತ.
ಅದನ್ನೇ ದಯವಿಟ್ಟು ಅದನ್ನೇ ಓದಿ ಸರ್. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದೀರಾ ಓದಿ ಸರ್.
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಅದು
ಅಲ್ಲೇ ಮೇಲ್ಗಡೆ ಓದಿ.
ಅಪ್ಲಿಕೇಶನ್
thereafter an application made by Srimati Girija.
Yes, my lord. Mother of respondent. ಅದು ಎಕ್ಸ್ಟ್ರಾ ಕೇಳಿರೋದು ಎಕ್ಸ್ಟೆಂಟ್ ಇನ್ ಎಕರ್ಸ್ ಅಂತ.
ಎಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ? Why did you not include these persons in the writ petition?
ಅಲ್ಲ ಇದು ಅದಾದ್ಮೇಲೆ ಖಾತೆ ಮಾಡೋದಕ್ಕೆ as per the order of my lords 23/7/1981 order has been confirmed by the hands of this honorable court. Hence I made an application to effect khata in my name in respect of 90 cents as per the order dated 23/7/1981. ನಾನು extent extra ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ. I am not asked for any extra extent.
Apart from the order dated 23/7/1981, I have not sought for a single gunta of land.
Yes.
This order has been confirmed by the division bench of this honorable court. Thereafter, the tribunal disturbed the order dated 23/7/1981 as well as 1988. Hence, a writ petition has filed before my lords in WP 14613 of 2022, page annexure R7. Para 11, page 73 may be kindly seen. My lords, after recording the order dated 23/7/1981, even till today, I don't want an inch of land apart from the order dated 23/7/1981. I am confined my rights only in respect of 23/7/1981. Having regard to the extensive finding, page 73, my lord, order of my lords. In my statement of objections. Para 11, may I read, my lord?
Now please come to internal page 4 of my order.
Please, my lord. Yes, my lord. The occupancy rights in respect of various lands and on the strength of consent given by the owner of the land, Gilbert Phyllis Spirit, but Gilbert Phyllis, but the land tribunal proceeded to pass an order dated 23/7/91 granting occupancy rights in respect of 7 pieces of land situated at Trivelvale village and 5 pieces of land situated at Bondantila village. However, Srimati Girija once again moved the land tribunal by filing an application dated 11/10/1996, invoking the provisions of subsection 6 of 48A of the Karnataka Land Reforms Act hereunder, stating that 4 more pieces of land in respect of which the original application and form number 7 was filed was not considered, and same is required to be considered, and orders have to be passed granting occupancy rights in respect of those land also. The land tribunal passed an order dated 2/12/1988 by allowing the application and granted occupancy rights in respect of additional 4 lands also. The said order dated 2/12/1998 was questioned along the original order dated 23/7/1981 at the hands of respondent number 3 herein, who is the son of original landlord Gilbert Philip Piris. But this court by order dated 1/8/2018 in WP 35974 to so and so held that challenge raised by respondent number 3 herein, who was the petitioner before this court in respect of original order dated 23/7/1981 passed by the land tribunal is required to be rejected since the same has attained finality. And there was no challenge raised to the said order dated 23/7/1981 in the manner known to law. This court held that in terms of section 48A clause 6 of the Act, when once land tribunal passed an order, it shall become final and the land tribunal become functions officio. However, in terms of the proviso to subsection 6 of section 48A, only clerical and arithmetical mistakes are permitted to be corrected. Nevertheless, it was found that subsequent order dated 2/12/1998 was passed by the land tribunal without hearing the legal representatives of Gilbert Philip Spirit, who died in the year 1987. And therefore, the said order was quashed and the matter was remitted back to the land tribunal for reconsideration after giving opportunity of hearing to all the parties concerned. Respondent number 3 herein filed writ appeal 2847 and division bench by the order dated 31/2019 disposed of the writ appeal, noticing that learned single judge remanded the matter to back to the land tribunal for fresh consideration after giving opportunity of hearing to all the parties concerned, and therefore the division bench did not find any infirmity in the order of learned single judge. After remand, the land tribunal has passed the impugned order dated 6/7/2022 confirming the grant of occupancy rights in respect of lands originally granted in terms of order dated 23/7/1981 in respect of Thiruvalveli village, but cancelled the grant of occupancy rights in respect of all the lands situated at Bondantila village, and second application date 11/10/1996. Learned counsel for the petitioner submitted that it was not permissible for the land tribunal to modify the original order dated 23/7/19, since this court had clearly held that the land tribunal had passed the order on 23/7/1981, which was never challenged by the landlord or his legal representatives, including respondent number 3 herein. And in terms of subsection 6 of section 48A, the order having attained finality cannot be permitted to be reopened. Moreover, there was never a challenge raised by the original landlord or his legal representatives, and on contrary, impugned order has been passed on an application made by Girija, under whom petitioners herein claim seeking grant of occupancy rights in respect of additional lands. Therefore, at any rate, the land tribunal could not have modified the original order dated 23/7/1981. To a pointed question put by the court, learned counsel for the petitioner submit on instruction that petitioner give up their claim in respect of the application made at the hands of Girija on 11/10/1996. In other words, it is submitted that petitioners confine their claims in terms of the original order dated 23/7/1981. Per contra, learned counsel for the contesting respondents seek to contend that in the order of division bench in the writ appeal 2847, the division bench has kept the question regarding nature of land open to be decided by the tribunal. According to the learned counsel, the division bench permitted the land tribunal to reopen the question even in respect.
Please show me a copy of that application filed by Girija.
Application.
Can I just pass on the copy of the writ petition which was filed? That is WP number, that is before 6613. Your lordships found that there is a tabulated column which is extracted, that is that two columns. That is extracted from their pleadings.
Yes.
This is their pleadings.
Yes.
ಅದು 20 ಗುಂಟೆ ಅಂತ modify
Copy ಇದ್ರೆ ದಯವಿಟ್ಟು ತೋರಿಸಿ.
copy ಇಲ್ಲ.
Where is that? Where is the application filed by Srimati Girija seeking modification?
That we have produced. That is at annexure D.
ಇಲ್ಲ.
At annexure E at page 35.
35.
Since why it has ಕಡಿಮೆ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಒಂದ್ ನಿಮಿಷ
ಅವ್ರಿಗೆ
ಇರಿ.
ಕೊಟ್ಟಿರೋದೇ 165 ಅಂತ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Yes, yes.
ಈಗ ಪ್ರಿವಿಲೇಜ್ ಲಿಟಿಗೇಷನ್ಸ್ 20 ವರ್ಷ ಮಾಡಿದಾಗ ಎಷ್ಟು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅಷ್ಟೇನೆ.
ಈಗ please come to page number 36.
36.
ಆಯ್ತಾ? ನೀವು you have given a clear description.
2 acres 60 cents.
ಮಧ್ಯದ ಕಾಲಮ್ ಅಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಅಂತೆ ಅಪೇಕ್ಷಿಸಿದ ಕ್ಷೇತ್ರ ಅಂದ್ರೆ ವಾಟ್ ಯು ಸಾಟ್ ಫಾರ್. ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 36 2A ಬರೀ ಒಂದೇ ಒಂದ್ಸರಿ ತೋರಿಸಿದ್ದಾರೆ 2 acres 60 cents. ಹೌದಾ?
ನೆಕ್ಸ್ಟ್
ದೆನ್ ಲಾಸ್ಟ್ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಮಂಜೂರಾತಿ ನೀಡಿದ ಕ್ಷೇತ್ರ ಎಷ್ಟು ತೋರಿಸಿದೀರಾ?
1 acre 60.
1 acre
65.
ಹಾ. 145 plus 20 165.
Next page 37 again.
ಅದ ಯಾಕೆ ಅಂದ್ರೆ ಫಾರಂ 10 was issued on.
Now you please don't try to explain.
ಅಲ್ಲ ಫಾರಂ 10 ನಲ್ಲಿ 20 cents ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೋಸ್ಕರ that has been paid. For a moment I request my lords to kindly take annexure D page 24. Forum 10 has issued in respect of 36 2AP 145, 36 2AP 20 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
You knew very well that it was corrected and it was shown as 20 cents.
ಅಲ್ಲ ಎಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡಿದ 1980
ಅದಕ್ಕೇನೆ ನಿಮ್ಮ ಮಾಡಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೆ ತೋರಿಸ್ತಾ ಇರೋದು.
ಅಲ್ಲ 1981 ಆರ್ಡರ್ ಅಲ್ಲಿ ಕರೆಕ್ಷನ್
ಅವರು 90 ತೋರಿಸಿದ್ರೆ ನೀವಿಲ್ಲಿ 36 2A ಕೇಳ್ತಾನೆ ಇರ್ಲಿಲ್ಲ.
That is modification. For a moment, kindly appreciate. Modification application has been filed by mother of this respondent after issuance of forum number 10. For a moment, forum number 10 may be seen at annexure D page 24. Forum 10 ಕೊಡುವಾಗ 36 2AP 1 acre 45 ಗುಂಟಾಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೊಂದು 36 2AP 20 ಅಂತ ಮಾಡಿದ್ದಾರೆ, ನಾಟ್ 90 ಅಂತ ಕೊಟ್ಟಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಿಫಿಕೇಶನ್ ಅಪ್ಲಿಕೇಶನ್ has been filed in with regard to that extent is concerned. ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ಟರ್ ಇಶ್ಯೂಯನ್ಸ್ ಆಫ್ ಫಾರಂ ನಂಬರ್ 10 ದಿಸ್ annexure E has been filed.
ಹಂಗಿದ್ದಿದ್ರೆ you would not have sought for clarification here. You would have simply said, although the tribunal granted 90 cents, while issuing form number 10 they have shown it as 20 cents anta. So you would have sought for a clarification. You would not have sought for a modification of the order.
Remaining extent ಎಲ್ಲ ಕೊಟ್ಟಿರಲಿಲ್ಲ. Kindly appreciate my lord. 1981 order has been confirmed by this honorable court. Now ಅವರು ಈಗ ಅದನ್ನ 90 cents ಅಲ್ಲ 20 cents ಅಂತ now they are coming after confirming, and
that is why the learned senior counsel is pointing out from your own application.
Let's kindly have a look at page 20 of the writ petition also.
ನಿಮ್ಮ application ಅಲ್ಲಿ, if you are so clear that the tribunal has already granted 90 cents, 145 plus 90,
ಅಲ್ಲ ಅದರಲ್ಲಿ ಬೇರೆದು ನೋಡ್ಬೋದು ಸ್ವಾಮಿ, ಮಿಸ್ಟೇಕ್ ಮಾಡಿದೆ.
they are not concerned with others.
ಅಲ್ಲ
They
ಎಕ್ಸ್ಟೆಂಡ್
are now concerned only with this survey number. ಅಷ್ಟೇ. Because only in that respect you filed another writ petition, not making them parties.
ಇಲ್ಲ ಇಲ್ಲ.
In all fairness, you should have made them parties.
No, my lord.
And you should have told the court, look here, there was a
Earlier,
mistaken notion,
my
and
name-
therefore we have impeded them also. If they accept, you proceed to pass this order or let it remain like that.
ಅಲ್ಲ my lord, we kindly see page 20 annexure K, my lord. The extent it was standing in my name as on 2020, 1 acre 45 guntas, and ಇದ್ರದ್ದು ಬಂದಿರಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ to insert my name in the revenue entries by virtue of the order passed by my lords, we made an application. Our party ಮಾಡೋ necessary ಇಲ್ಲ. We made our application before the Tahsildar to effect ಖಾತಾ. Tahsildar said ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಖಾತಾ ಮಾಡಬಹುದು, ಆದ್ರೆ ಎಸಿಗೆ ಅಪೀಲ್ ಹೋಗಿ ಅಂತ. Hence I am forced to file this writ petition before this honorable court.
When there is a difference in the extent of land, in all fairness, you should have impeded them as parties. Without impeding them, you have filed the writ petition, which clearly shows you had other intentions.
ಅಲ್ಲ ತಮ್ಮ ಆರ್ಡರ್ ಅನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ಕೋಸ್ಕರ ನಾವು ಕೇಳಿದಷ್ಟೇ, ಅದು ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ. The endorsement may be kindly see. The endorsement annexure R9 ಸ್ವಾಮಿ. Endorsement clearly states that ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಂತೆ ಮಂಜೂರಾದ ಜಮೀನಿಗೆ ಪಹಣಿ ದಾಖಲಾತಿ ಕೋರಿ ನೀವು ಅರ್ಜಿ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತೀರಿ. ಉಲ್ಲೇಖರಂತೆ ಉಪ ತಹಸೀಲ್ದಾರ್ ಗುರುಪುರ ನಾಡ ಕಚೇರಿ ಇವರ ತನಿಖಾ ವರದಿ ಪಡೆಯಲಾಗಿದೆ. ಮಂಗಳೂರು ತಾಲೂಕು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ ಸಂಖ್ಯೆ so and so 23/7/1981 ರಂತೆ ಶ್ರೀಮತಿ ಗಿರಿಜಾ ಹೆಸರಲ್ಲಿ ತಿರುವೈಲ್ ಗ್ರಾಮದ 36 2P ರಲ್ಲಿ 0.90 ಎಕರೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ಕೂಡ ಅವರಿಗೆ ಹಕ್ಕು ಲಭ್ಯವಾಗಿದ್ದು annexure R9 page 8.
How you are seeking to say it was 90 cents?
By virtue of order.
But your own application says, no, what was granted was only 20 cents. So please correct it.
ಅಲ್ಲ 23/7/1981 order has not been disturbed by this honorable court at any point of time at all. Now they are
That is in respect of 20 cents.
Yes. 1981 order annexure
That is by your own showing, sir.
ಅಲ್ಲ ಆರ್ಡರ್ 90 cents ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಅದು
ಅದನ್ನೇ you want to take advantage of that now.
ಅಲ್ಲ it has not been challenged by them at any
There
point.
was no need for challenging. The land tribunal has corrected it and it has said it is only 20 cents. That is why you filed an application seeking modification.
Land tribunal ಅಲ್ಲ ಸ್ವಾಮಿ, land tribunal 90 cents ಅಂತಾನೆ. ತಹಸೀಲ್ದಾರ್ at the time of issuing form number 10, he has issued form 10 for 20 cents. For that purpose, modification application has been filed as land tribunal.
Podi, please read your application. Please read the application.
Page E, my lord. ವಾಸ್ತವಾಂಶಗಳು ಅರ್ಜಿದಾರರು ತಾನು ಗೇಣಿ ನೆಲೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಪಡೆದ ಜಮೀನಿನ ಬಾಬ್ತು ಅಧಿಭೋಗದ ಹಕ್ಕು ಅಪೇಕ್ಷಿಸಿ ನಮೂನೆ 7ರಲ್ಲಿ ಬರೆದುಕೊಂಡ ಅರ್ಜಿಗಳು ಸ್ಥಳ ತನಿಖೆಯಿಂದ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಉಲ್ಲೇಖಿತ UTR ದಿನಾಂಕ 23/7/88 ರಂದು ಮಂಜೂರಾಗಿದೆ. ವಿವರ ಈ ಕೆಳಗಿನಂತಿದೆ. ಅರ್ಜಿಯನ್ನು ಅಡಕ 1 ಎಂದು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶವನ್ನು ಅಡಕ 2 ಎಂದು ನಮೂದಿಸಿ ಲಗತ್ತಿಸಲಿದೆ. ಡಿಕ್ಲರೇಷನ್ ಅಪೇಕ್ಷಿಸಿದ ಕ್ಷೇತ್ರ 36 2AP 2 acre 60.
ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಮಂಜೂರು ನೀಡಿದ ಕ್ಷೇತ್ರ 1 acre 65.
ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಕಾಲಮ್ 2 ಬನ್ನಿ ಸ್ವಾಮಿ. ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ಆದ ಕಡಿತದ ವಿವರ ಈ ಕೆಳಗಿನಂತಿದೆ. 36 2A
ಕಡಿತದ ಕರೆಕ್ಟ್ ವಿವರ.
ವ್ಯತ್ಯಾಸ 95.
ಕರೆಕ್ಟ್.
ವ್ಯತ್ಯಾಸ 95.
ಕರೆಕ್ಟ್.
ಅಲ್ಲ ನಾನು 2 acre 60 ಗುಂಟ
ಹೌದ್ರಿ, ಕರೆಕ್ಟ್. See, it is too much.
Absolutely frivolous, my lords.
ನಾವು ಇದನ್ನ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ನಮಗೆ ಬೇರೆ ಕೆಲಸ ಇಲ್ವಾ?
For a moment, kindly appreciate, my lord. 1981 order has not.
Tell us how much cost should be imposed. The maximum will be imposed.
I was just reading this. One judgment of the court cannot say this.
I'll have to say something about the advocates also, because you have been appearing continuously.
ನಾವು 1981 ಆರ್ಡರ್ ನಾವು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ. ಅದು ಬಿಟ್ಟು ನಾವು ಇದೇನು
Petitions are drafted by you. It is filed
My lord, we are not suppressing any facts. We are asking before this honorable court categorically to confirm occupancy rights of order dated 23/7/1981. There is no suppression of facts at any point of time. 1981 order has not been cancelled or set aside at any point of time. Now, after lapse of the 30 to 40 years, now they are coming before this honorable court stating that they are not earlier occasions. This was not the contentions of the petitioners at all before this honorable court. Now they are coming with this contentions before this honorable court.
At least you should have implicated them as respondents.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅದಕ್ಕೆ ನಾನು ನೀವು ಫರ್ದರ್ ಓದಕ್ ಹೋಗಿದ್ದು ನಿಮ್ಮ ಹೆಸರಿಗೆ ಎಲ್ಲ ಇದೆ ನೀವು AC ಮುಂದೆ ಅಪೀಲ್ ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ಕೆ ನಾವು ಅದನ್ನ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಬೈ ವರ್ಚು ಆಫ್ page R985 may be kind for a moment, my lords may kindly see R9 page 85. ನಾವೇನ್ ಮೋಸ ಮಾಡಿ ಲಾಯರ್ ನಮ್ಗೇನ್ ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಗೆ ಮೋಸ ಮಾಡಿ ಯಾರಿಗೂ ಕೊಡಿಸ್ಬೇಕನ್ನೋ ಇಂಟೆನ್ಷನ್ ನಮ್ಗೆ ಇಲ್ಲೇ ಇಲ್ಲ. ಐ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ರೀಡ್ ಮೈ ಲಾರ್ಡ್. ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಂತೆ ಮಂಜೂರಾದ ಜಮೀನಿಗೆ ಪಹಣಿ ದಾಖಲಾತಿ ಕೋರಿ ಉಲ್ಲೇಖ 1ರಂತೆ ನೀವು ಅರ್ಜಿ ಬರೆದುಕೊಂಡಿರುತ್ತೀರಿ. ಉಲ್ಲೇಖ 2ರಂತೆ ಉಪ ತಹಸೀಲ್ದಾರ್ ಗುರುಪುರ ನಾಡ ಕಚೇರಿ ಇವರ ತನಿಖಾ ವರದಿ ಪಡೆಯಲಾಗಿದೆ. ಮಂಗಳೂರು ತಾಲೂಕು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ ಸಂಖ್ಯೆ LRTR 1064/78/79 ದಿನಾಂಕ 23/7/1981 ರಂತೆ ಗಿರಿಜಾ ಹೆಸರಲ್ಲಿ ತಿರುವೇಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 36 2P ರಲ್ಲಿ 0.90 ಎಕರೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೂಡ ಅವರಿಗೆ ಹಕ್ಕು ಲಭ್ಯವಾಗಿದ್ದು ಗಿರಿಜಾರವರು ಮೃತಪಟ್ಟ ಕಾರಣ ವಾರಸುದಾರರ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲಿಸಬಹುದಾಗಿ ಉಪ ತಹಸೀಲ್ದಾರರು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ತಿರುವೇಲಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 36 2P ರಲ್ಲಿ 0.90 ಎಕರೆ ಜಮೀನಿನ ಪಹಣಿಯನ್ನು ಗಿರಿಜಾರವರು ಮೃತಪಟ್ಟ ಕಾರಣ ವಾರಸುದಾರರಾದ ಸದಾನಂದ್ ಸೋ ಅಂಡ್ ಸೋ ರವರ ಹೆಸರಿನಲ್ಲಿ ಪಹಣಿ ದಾಖಲಿಸುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ನಲ್ಲಿ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಬಹುದಾಗಿ ನಿಮಗೆ ತಿಳಿಸಿದೆ. ದಿಸ್ ಈಸ್ ದಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್. ನೀವು ಅಪೀಲ್ ಹಾಕಿ AC ಮುಂದೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ನಿಮ್ಗೆ 20 cents ಅಂತ ಇದೆ, 90 cents ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. 90 cents ನಿಮ್ದಲ್ಲ. ದಟ್ ವಾಸ್ ನಾಟ್, ದೇ ಆಲ್ಸೋ ಕನ್ಫರ್ಮ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಪಾಸ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ 90 cents ನಿಮ್ ಗ್ರಾಂಟ್ ಆಗಿರೋದಂತ. But he has told to prefer appeal before the assistant commissioner, though categorically this honorable court has passed 3 orders and it has been confirmed by the division bench.
ಅವರ ಹೆಸರು ಖಾತೆ ಆಗಿದೆ ತಾನೆ?
ಆಗಿರ್ಲಿಲ್ಲ, ಅವಾಗ ಆಗಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದೆ page 57
ಮುಂಚೆ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇತ್ತು, ಅವ್ರ ಹೆಸರಲ್ಲಿ ನಮ್ಮ ಹೆಸರಲ್ಲಿ. That extent is large, my lord, my lords may kindly see. ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ ನಾವು.
page 57 my lord.
page 18 annexure K3 ನನ್ನ R3 ಅವ್ರ ಎಕರೆಯಲ್ಲಿ ವಸಂತಿ ಬಿನ್ ಸೀನಾ ಪೂಜಾರಿ 23, ವಸಂತಿ ಬಿನ್ ಸೀನಾ ಪೂಜಾರಿ ದಟ್ ಈಸ್ 3 acres 21 ಗುಂಟಾಸ್ 2016-17 ಅಲ್ಲಿ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇತ್ತು. page 19 3 acres 21 ಗುಂಟಾಸ್ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇತ್ತು. 2021 ದೇ ಆರ್ ಕ್ಯಾಟಗರಿಕಲಿ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೋದು, ಖಾತೆ ಚೇಂಜ್ ಮಾಡಿಸೋದು, ಅವ್ರ ಹೆಸರಿಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೋದು, ಖಾತೆ ಚೇಂಜ್ ಮಾಡಿಸ್ಕೊಳೋದು.
Page 57.
Page 57 my lords of the writ petition papers. Lords, this is as on the date my lords when the earlier writ petition was filed, that is WP 6613 of 24.
Yes, you can see MR number T7 2016-17.
Yes,
As far back as 2016-17 mutation entry has been made.
Lords, these entries is what is sought to be meddled with by making an application to the Tehsildar, which clearly shows that
ಎಷ್ಟು ತೋರಿಸಿದ್ದಾರೆ ನಿಮಗೆ?
Lords, first entry is 1 acre 96 cents, first one. Marian Peris but ಆಮೇಲೆ ಸದಾನಂದು ಬಿನ್ ಸೀನಾ ಪೂಜಾರಿ 9 cents.
9 cents.
Out of 20, that is actually 9 cents is only shown. Then next ಇವ್ರು ಮಿಕ್ಕಿದವರೆಲ್ಲ ಮೇಲಿನಂತೆ ಜಂಟಿ ಅಂತ ಇದೆ.
14 cents ಅವರ ಹೆಸರಿಗೆ ಇದೆ. ಮತ್ತೆ
ಮರಿಯನ್ ಜೋಸೆಫ್ ಭಟ್ 14 cents. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ 145 cents ಸದಾನಂದ್ page 16 ಅಲ್ಲಿ. Then again at page 62 remaining extent is again in the name of Marian Joseph Peris.
14 cents.
14 cents ಸದಾನಂದ್ ಹೆಸರಲ್ಲಿ. ಸದಾನಂದ ಬಿನ್ ಸೀನಾ ಪೂಜಾರಿ.
Sanat Marian Joseph Perez.
Sorry, that 14 cents.
14 cents.
Yes, in the name of Marian Joseph Peris Bhatt.
That is your claims.
That is, yes.
ಅಲ್ಲ
Then next page, page number 60.
ಅದನ್ನ ಅವ್ರ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡು
ಇಲ್ಲಿ page number 60.
ಹಾ
ಮತ್ತೆ ಸದಾನಂದ ಅವ್ರದ್ದು 145 cents.
1
acre 45 cents.
ಸದಾನಂದ
ಅವರು. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 60 ಇದೆ ಅಲ್ವಾ? That's all. Page 62 is for the next year. Correct? ಇಲ್ಲ, page 62 is a continuation. I'm sorry.
ಅಲ್ಲಿ ಮತ್ತೆ 1 acre 76 guntras in name of
Other than the extent which is granted to them, everything else is our property. Lords, now this is one paragraph, Lords, which I wanted to read because I was just reading this judgment. How to prevent this kind of frivolous litigation?
All these revenue entries are being made during the pendency of writ petition and writ appeal. ಇಲ್ಲಿ ಇದ್ದಾಗ ಅದನ್ನ ತೋರಿಸ್ಬಿಟ್ಟು ಮಾಡಿಸ್ಕೊಂಡಿರೋ.
That is what.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇತ್ತು.
See, how could the authorities make such an entry without there being a clarity? If it was so clear that 90 cents, 1 acre 45 cents and 90 cents were given to you, how could the authorities make this entry?
ಮಚ್ ಪ್ರಯರ್ ಟು ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇತ್ತು, ಆಮೇಲೆ ಅವ್ರ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು. ಮಚ್ ಪ್ರಯರ್
ಹೆಂಗ್ ಮಾಡ್ಕೊಂತಾರೆ?
ಅಲ್ಲ, ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂಡ್ ರಿಟ್ ಅಪೀಲ್ ಕೇಸ್ ಇದೆ, ನಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿ ಅಂತ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಆಗಿರೋದು. ಇಲ್ಲಿ ನಮ್ಮ ಹೆಸರಲ್ಲಿ 1 acre 45 guntras ಬಿಟ್ರೆ ಇನ್ ಯಾವ್ದೋ ಎಕ್ಸ್ಟೆಂಡ್ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ, ಅವ್ರ ಹೆಸರಲ್ಲೇ ಇರೋದೆಲ್ಲ. ನಾಟ್ 20 cents ಕೂಡ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ.
9 cents plus 14 cents.
ಅದ್ ನಮ್ದಲ್ಲ, 14 cents ಅವ್ರ ಹೆಸರಲ್ಲಿ.
9 cents ಸದಾನಂದ.
14 cents ಮರಿಯೋ ಜೋಸೆಫ್ ಪೀರಿಸ್, ಬಟ್ ದಟ್ ಇಸ್ ಪೆಟಿಷನರಿ.
9 cents ಸದಾನಂದ.
ಹೌದು, ನಮ್ಮ ಹೆಸರಲ್ಲಿ.
Well, 145 ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ.
145, that is not disputed. MR 2018-19 ಒಟ್ಟುಗೂಡಿಸು ಅದೆಲ್ಲ ಆದೇಶ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ದಾಖಲೆ ಸಂಖ್ಯೆ, ಇದರ ಆದೇಶ CCR. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅವ್ರಿಗೆ ಖಾತೆ ಮಾಡಿ ಅಂತಾನೆ ಹೇಳಿರ್ಲಿಲ್ಲ.
Alright. Yes. But just one paragraph, Lords. I just leave the judgment also. This is what it reads. Before parting with this case, this is a judgment of the Delhi High Court. I consider it necessary to pen down one of the reasons for overflowing of the court dockets. Idala. It's not the judgment. Of the court dockets is the frivolous litigation in which the courts are engaged by the litigants and which is dragged as long as possible. Even if these litigants ultimately lose the lists, they become the real victors and have the last laugh. This class of people who perpetuate illegal acts by obtaining injunctions or other proceedings from the courts must be made to pay the sufferer not only the entire illegal gains paid by them as costs to the persons deprived of the rights, also must be burdened with exemplary costs. Faith of people in judiciary can only be sustained if the people on the right side of law do not feel that even if they keep fighting for justice in the court and ultimately win, they would turn out to be fools, since winning a case after 20-30 years of litigation would make the wrongdoer a real gainer who has reaped the benefits. Thus, it becomes the duty of the courts to see that such wrongdoers are discouraged at every step, and even if they succeed in a prolonging litigation due to their powers, ultimately they must suffer the costs of all these years of litigation. Despite settled legal positions, the obvious wrongdoers use one or the other tier of judicial review mechanism as a gamble, knowing fully well that the dice is always loaded in their favor, since even if they lose, the time gained is the real gain. But they were fully aware that it is only 20 cents. They made an application. What needs to be pointed out is it is with a verification. Annexure D, there is a bottom, it's a verification column is there. I so and so D hereby solemnly affirm what is said in para 1, 2, 3, 4, 5 is true and correct to the best of my knowledge, information and belief. If this is the solemn statement made before an authority, Lords, which is entitled to record evidence, they cannot resile from the same. Having made that statement, having made the same statement before this honorable court, Lords, I have passed on the pleadings made in WP number 6613. They have very specifically stated that 2 columns, which is extracted, Lords, in the writ petition. One column they say what is granted. The other column, what they are asking is the enhanced portions, which they wanted to seek by means of that order. Now, in that writ petition also having disclosed it, now they have the audacity to come to the court and say that whatever we might have said in the earlier rounds of litigation, whatever it may be, there is something which I can pull out of this, notwithstanding all these proceedings and the statements which I have made on oath before all concerned courts, but still I want to gain benefit out of it and keep the litigation pending for all these years. This is a very unscrupulous way, Lords, of handling the litigations. They are fully aware. Lords, I can understand if there is some bona fide mistake, some villager is there, he will not understand. These possibilities are there in this country. Those are the people who have to be granted with an exemption, but not the people of the kind. So your lordships may have to, my lords, consider imposing exemplary costs in this matter.
Perfect.
Can I seek your lordship exchange? Judgment on court. Lords, another 2 minutes, I'll send the judgment, Delhi High Court.
What happened pursuant to that orders passed in the other writ petition? Giving a direction to the Tahsildar?
We made an application to carry out, to affect my name in the revenue records. In respect of 36 2AP, this endorsement has been given. In respect of other, their revenue entries has been reflected in my other properties.
Milords.
Except 36 2AP 90 cents, all
That
other.
is the annexure A that has been challenged, Milords. As soon as I got the knowledge that such and such proceedings has been done, I made a representation to the.
What proceedings?
This order had been passed. I made a representation to the.
Order was passed by the High Court.
High Court. Thereafter I got the knowledge. At annexure
Even before they made the entry, you got the knowledge.
Yes. I made a representation at annexure K 66. When it was in process, Milords, I got the knowledge, and that I have stated in the writ petition itself, Milords. At annexure K, page number 66, I made a representation.
66.
Please. For this representation, Milords, annexure A, this endorsement was given, Milords.
Please read this. It's only
Visha Pani Dakalu.
1 page. Read it.
ಆಕ್ಷೇಪಣೆ ಮಂಗಳೂರು ತಾಲೂಕು ತಿರುವೈಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋರಲ್ಲಿ 9 ಸೆನ್ಸ್ ವಿಸ್ತೀರ್ಣದ ಬಗ್ಗೆ ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ಸೋಯನ್ಸೋರಂತೆ ಪಹಣಿ ದಾಖಲು ಮಾಡಲು ಸದಾನಂದ ಮತ್ತು ಇತರರು ಅಪೀಲು ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಅಪೀಲಿನಲ್ಲಿ ಅರ್ಜಿದಾರ ನಾನು ಹಾಗೂ ನನ್ನ ಸಹೋದರ ಆ ಪ್ರಕರಣದಲ್ಲಿ ಪಕ್ಷಕಾರರಾಗಿ ಭಾಗವಹಿಸಲು ಅರ್ಜಿಯನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಸಹಾಯಕ ಆಯುಕ್ತ ಪ್ರಕರಣ ನಡೆಸುತ್ತಿರುವ ಸಂದರ್ಭದಲ್ಲಿ ಸದಾನಂದ ಮತ್ತು ಇತರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP 6613/24 ರಂತೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ತಾವುಗಳು ನೇರವಾಗಿ 2 ತಿಂಗಳಿನ ಒಳಗೆ ಪಹಣಿ ದಾಖಲಿಸುವಂತೆ ಆದೇಶವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ ಸದಾನಂದ ಮತ್ತು ಇತರರು ಸದ್ರಿ ಪ್ರಕರಣದಲ್ಲಿ ನಮ್ಮನ್ನು ಪ್ರತಿವಾದಿಗಳನ್ನಾಗಿ ಕಾಣಿಸದೆ ಆದೇಶವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಸದಾನಂದ ಮತ್ತು ಇತರರು ಪಹಣಿ ಹೆಸರು ದಾಖಲು ಮಾಡಲು ಕೇಳುವ ಜಮೀನಿನ ಪಹಣಿಯು ನಮ್ಮ ಹೆಸರಿನಲ್ಲಿರುತ್ತದೆ. ಸದ್ರಿ ಸದಾನಂದ ಮತ್ತು ಇತರರಿಗೆ, ಅಂದರೆ ಗಿರಿಜಾ ಅವರ ವಾರಿಸುದಾರರು ಇವರಿಗೆ ದಿನಾಂಕ 23/7/81 ರಲ್ಲಾದ ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಂತೆ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸರಲ್ಲಿ 9 ವಿಸ್ತೀರ್ಣ ಮಾತ್ರ ಮಂಜೂರು ಆಗಿರುತ್ತದೆ. ಸದ್ರಿ ಆದೇಶದ ನಕಲು ಅದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಅಷ್ಟೇ ಅಲ್ಲದೆ ಸದಾನಂದ ಮತ್ತು ಇತರರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ 0.90 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಎಂಬುದಾಗಿ ದುರುದ್ದೇಶ ಪೂರ್ವಕ ಸುಳ್ಳು ಹಾಗೂ ಮೋಸದಿಂದ ಕಾಣಿಸಿರುತ್ತಾರೆ. ಹಾಗಾಗಿ ಸದಾನಂದ ಮತ್ತು ಇತರರ ಹೆಸರಿನಲ್ಲಿ ಪಹಣಿ ದಾಖಲು ಮಾಡುವ ಬಗೆಗಿನ ತನಿಖೆಯಲ್ಲಿ ಹಿತಾಸಕ್ತರಾದ ನಮಗೆ ನೋಟಿಸು ನೀಡಬೇಕಾಗಿರುತ್ತದೆ. ಹಾಗಾಗಿ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋರಲ್ಲಿ ಯಾವುದೇ ಆದೇಶ ಮಾಡುವ ಪೂರ್ವದಲ್ಲಿ ನಮ್ಮನ್ನು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು ಸಮಯಾವಕಾಶ ಕೊಡಬೇಕಾಗಿ ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥನೆ. ಸದ್ರಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿನಲ್ಲಿ ನಮ್ಮ ಸ್ವಾಧೀನ ಇಲ್ಲವ ಜಮೀನು ಕೂಡ ಇರುತ್ತದೆ ಮತ್ತು ಸದ್ರಿ ಸದಾನಂದ ಮತ್ತಿತರ ಹೆಸರಿನಲ್ಲಿ ಹೊಸದಾಗಿ ಪಹಣಿ ದಾಖಲು ಮಾಡುವವರೇ ನಮ್ಮ ಆಕ್ಷೇಪಣೆ ಇರುತ್ತದೆ. This was the representation made, Milords. At annexure A, page number 17. Yes. This is the endorsement given. ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶದಂತೆ ಮಂಜೂರಾದ ಜಮೀನಿಗೆ ಪಹಣಿ ದಾಖಲಿಸುವ ಆಕ್ಷೇಪಣೆ ಬಗ್ಗೆ ಉಲ್ಲೇಖಿತ ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ತಿರುವೈಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋರಲ್ಲಿ 90 ಎಕರೆ ಮಂಗಳೂರು ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ ನಂಬರ್ ಸೋಯನ್ಸೋ ದಿನಾಂಕ 23/7 ರಂತೆ ಶ್ರೀಮತಿ ಗಿರಿಜಾ ಪೋಮ್ ಶ್ರೀನಾ ಪೂಜಾರಿ ಅವರಿಗೆ ಅಧಿಭೋಗದ ಹಕ್ಕು ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಮಂಗಳೂರು ತಾಲೂಕು ತಿರುವೈಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋ ಪಹಣಿ ದಾಖಲು ಮಾಡುವ ಬಗ್ಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 6613/24 ದಿನಾಂಕ 3/6/24 ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ 2 ತಿಂಗಳ ಒಳಗೆ ಹದ್ದುಬಸ್ತು ಮಾಡಿ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಆದೇಶವಾಗಿರುತ್ತದೆ. ಈ ಆದೇಶದ ವಿರುದ್ಧ ನೀವು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅಪೀಲು ನಂಬರ್ 991/22. This was the earlier writ, Milords. Yes, mentioned here was the earlier writ appeal.
Yes, yes.
ರಂತೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು ದಿನಾಂಕ 31/7/23ರಂತೆ ನಿಮ್ಮ ಅರ್ಜಿ ತಿರಸ್ಕೃತಗೊಂಡಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಸದ್ರಿಯವರ ಹೆಸರಿನಲ್ಲಿ ಪಹಣಿ ದಾಖಲು ಮಾಡುವುದಾಗಿದೆ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ವಿಲ ಇಡಲಾಗಿದೆ.
So
This was issued to me on 24/1/25, my lords. Soon after I filed this
they have
repeat.
proceeded to
There was an interim order, my lords. This,
stay.
please, my lords.
So they have not proceeded.
No, 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 there was a stay.
Workers. The petitioner is aggrieved of the impugned endorsement at Annexure A dated 24/1/2025 issued by the third respondent, Tahsildar, Mangalore Taluk. Full stop. Next para. The matter brought before this court has a checkered history. Earlier too, this court had an occasion to deal with the matters between the parties, rival parties herein, in WP number 14613 of 2022. Stop. But before venturing into the said dispute and decision rendered by this court, a few facts have to be narrated. Full stop. The land tribunal, Mangalore Taluk, considered an application filed by Srimati Girija wife of Sheena Pujari, who had sought for occupancy rights in respect of various survey numbers, including 36/2A. Full stop. In form number 7, Srimati Girija had sought for occupancy rights to an extent of 2 acres 60 cents in respect of survey number 36/2A. Full stop. Order was passed by the Land Tribunal on 23/7/1981. Conferring occupancy rights in favor of Srimati Girija, including survey number 36/2A. Full stop. However, Srimati Girija once again moved the Land Tribunal by filing an application dated 11/10/1996 invoking the proviso to subsection 6 of section 48(A) of the Karnataka Land Reforms Act, 1961. Stating that 4 more pieces of land in respect of which the original application and form number 7 was filed was not considered and the same is required to be considered and orders to be passed while granting occupancy rights in respect of those lands also. Full stop. At this juncture, it would be relevant to notice the content of the application filed by Srimati Girija. It can be seen from Annexure E, the application filed by Srimati Girija on 11/10/1996 that Srimati Girija not only sought for
may make some submission, one submission. ಏನಾಗಿದೆ ಅನಕ್ಷರ ಬಿ ನಲ್ಲಿ 90 ಅಂತ ಇತ್ತು, ಇದೇನಾಯ್ತು ಫಾರ ನಂಬರ್ 10 ನಲ್ಲಿ 20 ಅಂತ ಆಯ್ತು. ನಾವು ಅಲ್ಲ ವಿ ಥಾಟ್ ದಟ್ 90 ಕೊಟ್ಟಿದ್ದಾರೆ, 20 ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ, ಅದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ವಿ ಥಾಟ್. ಈ ಅನಕ್ಷರ ಸಿ ನ ನಾವು ನೋಟಿಸ್ ನಾಟ್ ನೋಟಿಸ್. ಅನಕ್ಷರ ಸಿ ಏನಿದೆ we did not notice.
Annexure
See, that is the statement of the tenant, my lords. Annexure C, statement given before.
ಈ annexure C ನಾವು ನೋಟಿಸ್ ಮಾಡಿರಲಿಲ್ಲ.
She categorically states.
Therefore, my lord, we are under the impression that 90 guntas. ಅಂದ್ರೆ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಗಳು ಕೂಡ ಅವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕಾಗಲ್ಲ ಇರ್ಲಿಲ್ವಾ? It was not.
You tell us what to do.
Hello,
otherwise I'll proceed.
Hello, 20 ಗುಂಟೆ ನಾವು ಉಳಿಸ್ಕೊತೀವಿ ಅವ್ರಿಗೆ.
Not only that, that order will definitely be passed. The question is regarding imposing of costs.
We did not know.
All right, we'll consider.
Bona fide ಮೇಲೆ
all right. ಏನು ಹೇಳಿದೆ?
ನಾವು ನಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೂ ಕೂಡ ಅದನ್ನೇ ಹೇಳಿರೋದು. ಫಾರ ನಂಬರ್ 10 ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ.
ನಾಟ್ ಓನ್ಲಿ ಅಲ್ಲ ಅಂತ ತೆಗೆದಾಕಿ. ಶ್ರೀಮತಿ ಗಿರಿಜಾ clearly stated by giving tabular columns as to what was the declaration sought by Srimati Girija in respect of each survey number and the extent, and what was granted by the land tribunal was shown in the last column. Full stop. On a close reading of the application, it is clear that Srimati Girija sought to contend that she had sought for declaration and grant of occupancy rights in respect of 2 acres 60 cents in survey number 36/2A. However, the land tribunal conferred occupancy rights only in respect of 1 acre 65 cents. Full stop. This would clearly show that the correction made by the land tribunal in its order dated 23/7/1981, striking out 90 cents and showing 20 cents were the true facts as accepted by Srimati Girija herself. Full stop. Therefore, in the application, Srimati Girija
For a moment.
contended that she was entitled for conferment of occupancy rights in respect of another 95 cents other than 1 acre 65 cents which were already granted by the land tribunal. Full stop. Next para. Learned Senior Counsel Shri D.R. Ravishankar, appearing for the petitioner, submits that when these were the true facts, and it is clear that that Srimati Girija had accepted the fact that the land tribunal had passed an order in the year 1981 conferring occupancy rights insofar as survey number 36/2A is concerned in two pieces, that is 1 acre 45 cents and 20 cents. Full stop. This court in WP number 14613 of 2022 was concerned with the validity of the application itself and not precisely in respect of survey number 36/2A. Full stop. Learned Senior Counsel pointed out to a statement recorded by this court in paragraph number 6 of the order dated 12th of August 2022 in WP number 14613 of 2022, that learned counsel for the petitioners therein and the contesting respondents herein submitted on instructions that the petitioners give up their claim in respect of the application made at the hands of Srimati Girija on 11/10/1996. Full stop. In other words, comma, it was recorded that the petitioners wish to confine their claims in terms of the original order dated 23/7/1981. Full stop. It is submitted that pursuant to this court allowed the writ petition in part restoring the original order dated 23/7/1981 while setting aside the subsequent order passed by the land tribunal on 6/7/2022. Full stop. It is noticeable that by order dated 6/7/2022, the tribunal had withdrawn the grant made in respect of 4 pieces of land. ಇದು
ಎರಡೂ ವಿಡ್ರಾ ಮಾಡಿದ್ರು.
ಕೊಂಡಂತಿಲ್ಲ.
ಕೊಂಡಂತಿಲ್ಲ ವಿಲೇಜ್ and Interim.
1, 2, 3, 4, 5.
Tribunal
Where is that
had
order?
altered the 81 order, my lords.
Where
It
is
had
that order?
altered the, that is annexure R,
Page 60 annexure R
statement of objection.
6 maybe. Relevant portion is at page 60. Withdrawn the order of dated 23/7/1981.
What the tribunal had done there was, my lords, Punja lands were also granted, that it had withdrawn back. However, this court,
ಬೊಂಡಂತಿಲ್ಲ ವಿಲೇಜ್.
ಅಲ್ಲ, same village allu,
ಎರಡು
the dry lands which was granted, the tribunal had withdrawn.
ಏನು ಹೇಳಿಲ್ವಲ್ರಿ? They have not said anything.
ಅಲ್ಲ, ಕೃಷಿಗೆ ಯೋಗ್ಯ ಇಲ್ಲ ಅಂತ withdraw ಮಾಡಿ.
ಕೃಷಿಗೆ ಯೋಗ್ಯ ಇಲ್ಲ ಅಂತ, along with these orders also.
ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಅರ್ಜಿದಾರರು ಭೂ ಮತ್ತು ಭೂಮಾಲೀಕರ ಹೇಳಿಕೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Page 60 my lord. In my statement of objections.
16.
60.
60. ಹಾ
15.
ಸೆಕೆಂಡ್, ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಅರ್ಜಿದಾರರು ಮತ್ತು ಭೂಮಾಲೀಕರ ಹೇಳಿಕೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಭೂಮಾಲೀಕರು ನೀಡಿದ ಪುರಾವೆ ಮತ್ತು ಸಾಕ್ಷ್ಯಾಧಾರಗಳಂತೆ ದಾಖಲಾತಿ ಮೊದಲು ನೋಡಲಾಗಿ ಬೋಂಡಂತಿಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9/2, 10/3, 53/2, 55/1 ಮತ್ತು 6/1 ಜಮೀನು ಕೃಷಿ ಯೋಗ್ಯ ಅಲ್ಲದೆ ಇರುವುದರಿಂದ ಕೃಷಿಯೇತರ ಜಮೀನುಗಳು ಎಂದು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ದಿನಾಂಕ 25/10/21 ನಡೆಸಿದ ಸ್ಥಳ ತನಿಖೆ ಸಮಯದಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆಯಲ್ಲಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಕೃಷಿಯೇತರ ಜಮೀನು ಬಾಬತು ತನಿಖೆ ನಡೆಸಿ ಅವುಗಳ ಮೇಲೆ ಅರ್ಜಿದಾರರಿಗೆ ಅಧಿಭೋಗ ಹಕ್ಕು ನೀಡಲು ಬರುವುದಿಲ್ಲ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿದೆ.
ಏನ್ ಹೇಳಿದೆ? In respect of lands which according to the tribunal were non-agricultural in nature. Full stop. However, insofar as survey number 36/2A is concerned, the original extent of land which was granted in favor of Srimati Girija, namely 1.45 acres and 0.20 acres were maintained as it was in the original order. Full stop. Learned Senior Counsel submits that what is now sought to be contended on behalf of the contesting respondents herein is that at Annexure A, the original order passed by Annexure B, the original order dated 23/7/1981, the extent of land shown in survey number 36/2A is 1-45 and 00.90, which clearly is contrary to the admitted facts. Full stop. The correction carried out in Annexure B order, striking out 00.90 and showing 00.20 along with signature, is sought to be overlooked by the contesting respondents.
Penal correction ಆಗಿದೆ. Correction ಅದು ಹಾಗೆ ಇಲ್ಲ ಸ್ವಾಮಿ, correction ಆಗಿದೆ.
All right.
Annexure ಇದ್ರಲ್ಲಿ ಆಗಿರೋದು, ಇದು ಫಾರಂ ನಂಬರ್ 10 ಆಗಿದೆ, ಬಿ ಎಲ್ ಆಗಿದೆ.
ಆಯ್ತು ಬಿಡ್ರಿ, ಹೆಸರು ಹೇಳ್ತಿರ್ರಿ.
ನಲ್ಲಿ
I understood. What you are trying to show is this only. Annexure B, isn't it? Correct. Learned Senior Counsel submits that despite all these admissions at the hands of the contesting respondents, they have approached the Tahsildar seeking mutation and entry of their names to an extent of 1.45 acres and 00.90 acres, contrary to the admitted position that the same was corrected as 00.20 acres. Full stop. Where is that endorsement that was given to
R9 page 85.
85.
Statement.
However, the Tahsildar issued an endorsement dated 2/3/2023 to the private respondents herein, directing them to approach the Assistant Commissioner if such a correction and entry is required to be made, showing 0.90 acres in survey number 36/2A in favor of the private respondents herein. Full stop. Being aggrieved of such an endorsement issued by the Tahsildar, the private respondents herein filed writ petition number 6613 of 2024 to quash the endorsement dated 2/3/2023 and further to direct the Tahsildar to effect khata in the name of the private respondents herein to an extent of 0.90 acres in survey number 36/2A. Full stop. Learned Senior Counsel points out to the order dated 3rd of June 2024 at Annexure H in WP number 6613 of 2024 and submits that the petitioners herein were not made party respondents in those proceedings. Full stop. Learned Senior Counsel submits that the private respondents herein have misused the process of this court, concealed the true facts and sought a direction at the hands of this court behind the back of the petitioners herein, and this court issued such directions to the Tahsildar to enter the name of the legal representatives of deceased Girija in the revenue records within an outer limit of 2 months from the date of receipt of a certified copy of the order. Full stop. Next para. No sooner the petitioners came to know of such an order passed at the hands of this court, the petitioners raised an objection with the Tahsildar. Illide adu?
Annexure K, my lords. Page 66.
On 13/9/2024 at Annexure K, seeking an opportunity of hearing before considering the representation given by the private respondents here. Full stop. However, the Tahsildar issued the impugned endorsement at Annexure A dated 24/1/2025, declining to afford an opportunity of hearing to the petitioners, on the ground that directions have been issued to the Tahsildar in WP number 6613 of 2024 to carry out the mutation entry in the revenue records, while also carrying out the hadbast within a period of 2 months from the date of receipt of a copy of the order. Full stop. Next para. Learned Senior Counsel submits that it was never the case of the private respondents before this court either in WP number 35794-35795 of 2013 and in WP number 14613 of 2022 that the land tribunal had granted occupancy rights in favor of Srimati Girija to an extent of 0.90 acres. Full stop. This position is also clear from the application filed by Srimati Girija on 11/10/1996, wherein Srimati Girija clearly stated that the land tribunal had conferred occupancy rights only to an extent of 1.65 acres. Bracket ಅಲ್ಲಿ 1.45 plus 0.20. Full stop. If it was otherwise, comma, there was no need for Srimati Girija to seek modification of the order passed by the land tribunal. Full stop. Learned Senior Counsel would therefore submit that this court should take note of the conduct of the private respondents herein in trying to hoodwink this court to pass an order directing the Tahsildar to make entry in the revenue records as if the land tribunal had granted rights in respect of 0.90 acres. Full stop. Learned Senior Counsel would further submit that the writ petition is required to be allowed while imposing exemplary costs on the private respondents herein. Full stop. Yada judgment adu?
ಒಂದು ಸೆಟ್ ಇದೆ ಸ್ವಾಮಿ, ಕಾಪಿ
ಕೊಡಿ ಕೊಡಿ. Learned Senior Counsel would place reliance on a decision of the Delhi High Court in the case of Srimati Padmavati and others versus Harijan Sevak Sangh, 2008, SEC Online, Delhi 1202, where it was held as follows anbuto paragraph number 9 extract ಮಾಡ್ತೀನಿ. Next para. Per contra, learned counsels for the private respondents would submit that this court, while disposing of writ petition number 14613 of 2022, dated 12th of August 2022, had clearly set aside the order dated 6/7/2022 passed by the land tribunal. While restoring the original order dated 23/7/1981. Full stop. Learned counsels would submit that the understanding of the private respondents is that the tribunal had conferred occupancy rights in respect of 1.45 acres and 0.90 acres, having regard to the plain reading of Annexure B, order dated 23/7/1981 passed by the land tribunal. Full stop. The private respondents therefore approached the Tahsildar seeking such an entry in terms of the order passed by the land tribunal. Full stop. It is submitted that since the private respondents were seeking the revenue entries in terms of the orders passed by the land tribunal, comma, they did not feel any need to implead the petitioners herein. And there was no intention to mislead the authorities or this court. Full stop. ಅಷ್ಟೇನಾ? Next para. Heard the learned senior counsel, Shri D.R. Ravishankar, for the petitioners. Learned counsel, Shri B. Rupesh, for respondents number 4 to 10, comma, learned HCGP, and perused the petition papers. Full stop. What is interesting is the statement given by Srimati Girija at Annexure C, which was taken note of by the land tribunal while passing the order dated 23/7/1981. Full stop. The statement at Annexure C given by Srimati Girija clearly shows that she contended that she was in occupation of 1.45 acres and 0.20 acres in survey number 36/2A. Full stop. This is the reason why the land tribunal passed such an order confining grant of occupancy rights in favor of Srimati Girija to an extent of 1.45 acres plus 0.20 acres in survey number 36/2A. Full stop. The correction made in the order passed by the land tribunal striking out 0.90 and showing 0.20 with a signature is clearly visible even in terms of Annexure B. Full stop. This fact is substantiated by the subsequent application filed by Srimati Girija
Page 35.
on 11/10/1996. Full stop. Srimati Girija clearly stated that what she sought in form number 7 in respect of survey number 36/2A is 2.60 acres, and what was granted by the tribunal was 1.65 acres, bracket alli 1.45 plus 0.20. Full stop. It was never the case of Srimati Girija that the tribunal had already granted 1.45 plus 0.90. Full stop. This correction that is carried out in the order of the tribunal, which is not very clearly visible in the photocopies, is sought to be taken advantage of by the private respondents here. Full stop. In that view of the matter, comma, this court accepts the submission made by the learned senior counsel appearing for the petitioners. Full stop. Next para, coming to the conduct of the private respondents herein. Comma, this court is of the considered opinion that even if benefit of doubt is sought to be given to the private respondents herein, comma, that could be given if they had impleaded the petitioners herein as party respondents in the writ petition in WP number
6613 of 24.
6613 of 2024. Full stop. This act on the part of the private respondents herein, not impleading the petitioners herein in a writ petition filed before this court and seeking directions to the Tahsildar to mutate the names of the parties in respect of 0.90 acres in survey number so and so is a clear act of misleading this court and the authorities, revenue authorities. Full stop. It is noticeable that the Delhi High Court has made such observations as noticed herein above. Witnessing such incidents and petitions coming up before this court, where frivolous litigations are filed, engaging the litigants and dragging on the other side as long as possible, only to frustrate the parties at the cost of public time. Full stop. Wrongdoers will have to be dealt with firm and iron hands. Full stop. In that view of the matter, this court is of the considered opinion that the writ petition has to be allowed while imposing exemplary costs on respondents number 4 to 10. Full stop. Next para. Accordingly, the writ petition is allowed. Full stop. The impugned endorsement at annexure A issued by the Tahsildar, third respondent Tahsildar Mangur Taluk, is hereby quashed and set aside. Full stop. Liberty is, however, reserved to the Tahsildar to consider the claim of the private respondents herein only to an extent of 0.20 acres as granted by the land tribunal in its order dated so and so. Full stop.
Milord, out of that, already 9 cents stands in his name, Milord. Out of 20 cents, cents stands in his name. That is-
Sadananda.
Please, my lord.
Sadananda.
Sir, only 11 cents has to be added.
If 9 cents are already standing in the name of Shri Sadananda, comma, respond number 4 herein, comma, the private respondents number 4 to 10 are entitled to have their names entered to an extent of another
11 cents.
0.11 cents. 0.11 acres. And not more than that. Full stop. Private respondents number 4 to 10 shall pay costs of rupees 1 lakh full stop. Out of the said 1 lakh, rupees 50,000 shall be paid to the petitioner, and the remaining 50,000 will be paid to yadridu Karnataka Advocates Welfare Fund within a period of 4 weeks.
Make a submission, my lord.
From today. Full stop. Acknowledgement for payment shall be filed in the office as directed herein above.
I make a submission, my lord. There is no intention of question of cheating, my lord. When this honorable court passing the order on earlier occasion, ಅಲ್ಲಿ 90 cents ಅಂತಾನೆ ಮಾಡಿರೋದು, 20 cents ಅಂತ ಕರೆಕ್ಷನ್ ಎಲ್ಲೂ ತೋರಿಸಿಲ್ಲ ಸ್ವಾಮಿ.
ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ಮೇಲೆ ಮತ್ತೆ
By oversight we confirm. I request, my lord, there also agriculture.
ಅದಕ್ಕೆ in the beginning itself I asked you what do you want. At that point of time you would have said, all right, please allow the writ petition, direct them to register only so much. I would have passed it. You have wasted so much time of the court also.
There are also agriculture police, my lord. There is no intention to.
Yes.
My lord, in respect of cost, my lord. Humble submission. Alla, ಇಲ್ಲಿ ನಾವೇನ್ more.
I'll only have to increase more.
Humble
submission. Go on making submissions
police,
again.
my lord.
Yes.
Number 89, Vijoy MT.
Please, my lords, for the third respondent.
Lord. May I make one submission, my lord. When I to university ಅವರು they have sent the statement of objections, even I have served a copy to them. ಅದಾದ್ಮೇಲೆ ಇನ್ನು 3 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. My lords could have it any day, my lord. Next week ಅಲ್ಲಿ.
Kindly be 12th or after that, my lord, because some person and
After sending the statement of objections, my lord, they have sent 3 more documents.
I have received the statement of objection from respondent.
Only announcement of marks alva.
Yes, that's all.
Actually, there is respect. Okay. 3 days, my lord.
At the request of learned counsel for the respondent KSLU. Release this matter on 12th of August.
14th, my lord, if possible.
Please,
14th of August.
Yes, ma'am.
At 2:30 p.m.
Yes, much about. Yes.
Allow them according to the petition in the connected matter.
Beda 2:30 beda. Regular.
Please.
Yes.
Allow them according to the petition in the connected matter to become instructions.
Which one? 89.1.
24680.
24680.
Please file a memo. Please file a memo. Learned counsel for the petitioner.
May I make one submission? 24680 IFA for university. I have to file my objections. It cannot become.
My lords, it is not infructuous, my lords, unless your lordships hear that matter. My lords, the second matter may not be taken up.
Yes,
I am appearing for the institution, my lords.
All right. We will see this.
Please, ma'am.
Grateful.
Much about.
Huh? Huh.
34.
ಏನಾಯ್ತಪ್ಪ ಅದು? 74.
Serial number 74.
ಎಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್?
ಅಭಿನವ್ ರಾಮಾನಂದಿ. ವೆಂಕಟಮ್ಮ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ.
ಎಲ್ಲೋ
ಮಾರ್ಕ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿ ಎಲ್ಲೋ ಬ್ಲಾಕ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಅವರು ಮುನಿಗ ಅವರು. ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಮುನಿಗ ಅಂತ ಹೆಸರಿದೆ. 2 acres.
ಕೊಡಿದ್ದು ಇನ್ನೊಂದು ಕೊಡ್ರಿ. ಇದ್ರಲ್ಲಿ ಏನು ಗೊತ್ತಾಗಲ್ಲಪ್ಪ. ಏನವ್ರ ಹೆಸರು? ಮುನಿರಾಜು. ಮುನಿಗ. ಚಿಕ್ಕ ಮುನಿಗ ಬೇರೆ. ಚಿಕ್ಕ ಮುನಿಗ ಬೇರೆ. ಎಲ್ಲಿದೆಯಪ್ಪ? ಅಲ್ಲಪ್ಪ, ಇದ್ರಲ್ಲಿ ಇದು ತೋರ್ಸಪ್ಪ. ಚಿಕ್ಕ ಮುನಿಗ ಅಂತ ಒಂದು ಕಾಣ್ತದೆ, ಅದೇ ಚಿಕ್ಕ ಮುನಿಗ. ಮುನಿಗ ಬಿನ್ ಓಬಾ. ಮತ್ತೆ ಅದು ಚಿಕ್ಕ ಮುನಿಗ ಅಲ್ಲ ಹಂಗಂದ್ರೆ. ಸೊ ಚಿಕ್ಕ ಮುನಿಗ ಅಲ್ಲ. ಚಿಕ್ಕ ಮುನಿಗ ಒಂದು ಎಂಟ್ರಿ ಇದೆ 2 ಎಕರೆಗೆ. ಯಾವ ಊರ್ದದು? ದೊಡ್ಡ ಸಣ್ಣೆ. ಅದನ್ನು ಅಷ್ಟೇ ದೊಡ್ಡ ಸಣ್ಣನೆ. ಚಿಕ್ಕ ಮುನಿಗ 2 ಎಕರೆ ಒಂದಿದೆ. ಈ ಕಡೆ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಮುನಿಗ ಬಿನ್ ಓಬಾ 2 ಎಕರೆ ಒಂದಿದೆ. ಈ ಚಿಕ್ಕ ಮುನಿಗ ಇದೆಯಲ್ಲ, ಇದ್ರದ್ದು ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಬೇರೆ ಇದೆಯಾ ನೋಡ್ರಿ ಇಲ್ಲಿ. ಪ್ಲೀಸ್ ಕಮ್ ಹಿಯರ್. ನೀವು ಬನ್ರಿ ಇಲ್ಲಿ. ಇಲ್ಲಿ ನೋಡ್ರಿ, ಇದು ಚಿಕ್ಕ ಮುನಿಗ, ಇದು 2 ಎಕರೆ. ಮುನಿಗ ಬಿನ್ ಓಬಾ 2 ಎಕರೆ. ಹಂಗಾರೆ ಚಿಕ್ಕ ಮುನಿಗ ಅವರಲ್ಲ, ಬೇರೆಯವರು. ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು, ಇದ್ರದ್ದು ಬೇರೆ ರೆವಿನ್ಯೂ ಎಂಟ್ರಿಗಳು ಇದಾವ ಸಪ್ರೇಟ್ ಆಗಿ ತೋರಿಸಿರೋದು, ಅದನ್ನು ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ತಗೊಂಬನ್ನಿ. ಬಟ್ ಗೊತ್ತಾಯ್ತು, ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ, ಚಿಕ್ಕ ಮುನಿಗ ಇವರಲ್ಲ, ಅವ್ರು ಬೇರೆ, ಅವ್ರದ್ದು ಬೇರೆ ಲ್ಯಾಂಡ್ಸ್ ಇದೆ, ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಿರೋದು ಲ್ಯಾಂಡ್ ಬೇರೆ, ಅದ್ರದ್ದು ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಬೇರೆ ಆಗಿದೆ, ಅವ್ರ ಮಕ್ಕಳು ವಾರಸ್ದಾರರು ಹಿಂಗಿದ್ದಾರೆ, ಅವ್ರ ಹೆಸರು ಇದೆ ಅದನ್ನು ತೋರಿಸೋದಕ್ಕೆ ಏನಾದ್ರು ಇದ್ರೆ ದಾಖಲೆ ಅದನ್ನು ತಗೊಂಬನ್ನಿ. ಅದು ಇನ್ನೊಂದೇನು, RTC ಕೊಡಿ ಇಲ್ಲಿ. ಅಷ್ಟೇನಾ? KN ರಂಗಸ್ವಾಮಿ ಯಾರು? ಅಲ್ಲಲ್ಲ, ಇಲ್ಲೂ ಈ ಪ್ರೀವಿಯಸ್ ಪೇಜ್ ಅಲ್ಲಿ ಮುನಿಗಾ ಬಿನ್ ಬಾಬಾ ಅದರಲ್ಲಿ KN ರಂಗಸ್ವಾಮಿ ಅಂತ ಒಂದು ಹೆಸರು ಕಾಣ್ತದೆ. ಅದ್ಯಾರಿದು ನೋಡ್ರಿ, ಇದು ಪರ್ಚೇಸರ ಪರ್ಚೇಸ್ ಮಾಡಿದಾರ ಇವ್ರು. ಈ ಮುನಿಗಾ ಬಿನ್ ಬಾಬಾ ಪರ್ಚೇಸ್ ಮಾಡಿದಾರ. ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ, ಹಂಗಾರೆ 2+2. ನೋಡ್ರಿ, ಚೆಕ್ ಮಾಡಿ ಬರ್ಕೊಳ್ಳಿ.
My lord, I am appearing for petitioner, my lord. My lord, we will also come and inspect the records, my lord. My lords may have this matter on Monday, my lord. By then, my lord, we will be able to assist the honorable court.
I had asked both the parties to be present before the court.
Please, my lord, my senior is on his legs, my lord.
ಅವರು ಬಂದಿಲ್ಲ, ನೀವು ಇಲ್ಲ.
Monday,
in terms of the directions issued by this court, the learned AGA has kept the original grant register and the ledger of record of rights. ಏನ್ ಹೇಳಿದೆ? has made so and so available before this court. Full stop. On perusal of the original grant register, comma, this court finds that in survey number 28 of Dodda Sanne village, grants have been made in favor of totally ಎಷ್ಟು ನಂಬರ್ ಇದೆ ನೋಡ್ರಿ ಅದು ಆ ಹೆಸರುಗಳು ಲಾಸ್ಟ್ ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿದೆ ನೋಡಿ ಅಲ್ಲಿ ಆ ಬುಕ್ ಅಲ್ಲಿ ನೀನು ಅವಾಗ ತೋರಿಸಿದ್ರಲ್ಲ ಇದಲ್ಲ ಅದು ಇನ್ನೊಂದು ಮುಂಚೆ ತೋರಿಸಿದ್ರಲ್ಲ ಅದು ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಲಾಸ್ಟ್ ಒನ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು ದೊಡ್ಡ ಸಣ್ಣೆ and other villages ಕೊಡ್ರಿ ಇಲ್ಲಿ in favor of about 67 persons. Full stop. At serial number 62 is the name of Muniga bin Oba, extent 2 acres in Dodda Sanne village, and at serial number 4, serial number 4 is the name of Chikka. Allah, sorry. Serial number 10 is the name of Chikka Muniga, extent 2 acres, Dodda Sanne village. Learned AGA submits on instructions that Muniga bin Oba is the original grantee insofar as the present case is concerned, and not Chikka Muniga. Full stop. The RTC records would also show the entry of the name of Muniga bin Oba in survey number 28. Iden block ಏನು ಕೊಟ್ಟಿಲ್ವೇನ್ರಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. Full stop. However, it is also seen that the name of Sri Muniga bin Waba also finds reference in another RTC to similar extent of 2 acres in survey number 28 of Dodda Sanne village. However, in column number 10, it is shown as inverted commas Kraya, and Darkast made in favor of Sri K.N. Rangaswamy. Full stop. Next para. The respondent Tahsildar is directed to furnish information in respect of Sri K.N. Rangaswamy, land granted in favor of Sri K.N. Rangaswamy and whether Sri Muniga bin Baba purchased the said lands from Sri Rangaswamy, and revenue entries have been carried out accordingly. Full stop. Similarly, the Tahsildar is also required to file an affidavit insofar as Chikka Muniga is concerned, stating that the said Chikka Muniga is not the same as Muniga bin Baba, and the land granted in his favor is different, and the legal representatives of the said person are different, and the revenue entries are accordingly maintained. Full stop. Release this matter. Go on.
After 2 weeks.
20th of August. Yes.
Published.
Serial wise ಕರೀತೀರಾ ಕೊಡಕ್ ಸರ್? Serial wise ಕರೀತೀರಾ? ಸರ್ ಇದಿದೆ. 86.
Preliminary ಎಲ್ಲ ಬರಕ್ ಹೇಳುತ್ತೆ. Next week ಅಲ್ಲಿ ಬರುತ್ತೆ. All preliminary next week.
Sir, 25. Sir, serial number 25, sir.
Serial number 30.
Second sir. Sir, up to serial number 37 next week ಬರುತ್ತೆ ಎಲ್ಲ.
Sir, entry ಮಾಡ್ರು.
ಮೇಡಮ್
ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗತ್ತಲ್ಲ?
ಯಾವ್ದು ಮೇಡಮ್? ಅದೆಲ್ಲ 60 ಎಲ್ಲ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಡ್ಜರ್ನ್ ಮೇಡಮ್. ಓನ್ಲಿ ಪ್ರಿಲಿಮಿನರಿ ಅಪ್ ಟು 37 ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸರ್
ಸರ್ ಅಡ್ಜರ್ನ್
86
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಲ್ಲ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಹೇಳಿದ್ರಲ್ಲ ಸರ್ ಮತ್ತೆ ಸರ್ ಹೇಳಿದ್ರಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ
ಸರ್
serial number 35.
ಸರ್ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಹೌದು ಸರ್ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ಅಪ್ ಟು serial number 37 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಸರ್. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ಅಡ್ಜರ್ನ್ಡ್. ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ ಸರ್, ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಅಡ್ಜರ್ನ್ ಆಗಿರುತ್ತೆ ಆಫ್ಟರ್ serial number 37.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಗೆ ಫುಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸರ್ ಕೋರ್ಟ್. ಇನ್ನೂ ಜಾಸ್ತಿ ಬರುತ್ತೆ. ಇವತ್ತೇನ್ ಲಿಸ್ಟ್ ಇದೆ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಬರ್ತಾ ಇದೆ ನಾಳೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಸರ್ ಸುಮ್ಮನೆ ಹಾಕ್ಸ್ಕೊಂಡು
25 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್. ಸರ್ 25 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇದೆ ಸರ್.
Sir, this court is not giving date, sir. Automatically it will be coming.
ಸರ್ ಅಲ್ಲಿ 55 ಅಲ್ಲಿ 55